ವೇಟ್ ಮಾಡಿ ನೋಡೋಣ ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರೆ. ಹೌದು ಸರ್, ಹೌದು, ನಮ್ಗೆ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ವೇಟ್ ಮಾಡಿ. ಗೊತ್ತಿಲ್ಲ ಸಾಹೇಬ್ರು, ನೀವು ಹೇಳಿ, ನನಗೆ ಸಾಹೇಬ್ರು ಹೇಳ್ಬೇಕು. ಓಕೆ, ಅದೆಲ್ಲ ಅವರೇ ಬರ್ಬೇಕು ಸರ್. ನಮ್ಗೆ ಇವಾಗ ಬಂದ್ರೆ ಏನ್ ಯಾವ್ದಾಗ್ತದೆ ಯಾವ್ದು ಏನು ಎಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಮ್ದೇ ರೀಚ್ ಆಗಲ್ಲ, ನಮ್ದೇ ಮುಗಿಯಲ್ಲ. ಯಾವ್ದು 3 ಲಿಸ್ಟ್ ಇದೆಯಂತೆ ಇದಪ್ಪ. ಡೇಟ್ ಕೊಡೋದು ಬ್ಯಾಟ್ರಿ ಕೊಡಮ್. ನೋ ಅರ್ಜೆನ್ಸಿ ಆಫ್ಟರ್ 2 ವೀಕ್ಸ್ ಅಂದ್ರೆ ಕೊಡ್ಬೋದು. ತಿರ್ಗಾ ಕೊಟ್ಟು RF ಸದ್ಯ ಬರೋದು ಫ್ರೈಡೆ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬ್ಲಾಕ್ ಆಗಿದೆ. ನೋಡೋಣ ಯಾವತ್ತು ಬರುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವ್ರ 3 ಲಿಸ್ಟ್ ಅರುಣ್ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದೀನಿ. ಅವ್ರದೇನ್ ಬಂದ್ ಅವರೇ ಮಾಡ್ಕೋಬೇಕು, ನಮ್ದೇ ಮಾಡಕ್ ಆಯ್ತಲ್ಲ. ನಾನು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಇಟ್ಬಿಡು, ನಾನು ಅವ್ನಿಗೆ ಹೇಳ್ತೀನಿ. DR ನಮ್ದೇ ನಮ್ಗೆ ಮಾಡಕ್ ಆಗಲ್ಲ. ಬರ್ಬೇಕಾ ಬರಿಬೇಕಾ ಅಂತ ಏನೇನೋ ಕೇಳದ್ನಂತೆ, ನಾನು ಇರ್ಲಿಲ್ಲ. ಇಬ್ರು ಇರ್ತಾರೆ, ಒಬ್ರು ಬಂದ್ ಬರೀಲಿ, ಒಬ್ರು ಏನಾದ್ರು ಮಾಡ್ತಾರೆ. ಬೇರೆಯವರೆಲ್ಲ ಹಾಗೆ ಮಾಡ್ತಾರೆ. ಸರಿ, FR ನಂಬರ್ ಅಂತ ಹೇಳಿದ್ರೆ ಕೊಟ್ಬಿಟ್ರೆ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತೀನಿ. ನಂಬರ್ ಅಂತ ಫಾಲೋ ಅಪ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. 6:30 ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಎಷ್ಟು ನಂಬರ್ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ನಂಬರ್ ಬೇರೆ ಇಲ್ಲ. ನಾನು ವಿಜಯಣ್ಣ ಅವ್ರು ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಬೇಕು ಅನ್ನೋ ಪರಿಸ್ಥಿತಿ ಹೋಗೋದು ಇಲ್ಲ. ಅದೇ ನಾ ಏನು ಎತ್ತ ಅಂತ. ಸರಿ ಮೇಡಮ್, ಯಾರು ಫೋನ್ ಮಾಡಿ ಯಾರು ಬಂದಿಲ್ಲ. ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದಂತೆ ನಾನು ಪೇಪರ್ ಅವ್ರಿಬ್ರು ಬರ್ಬೇಕು. ಮೇಡಮ್ ಫೋನ್ ಮಾಡಿದ್ರು ಇಲ್ಲೇ ಇರ್ಬೇಕಂತಪ್ಪ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ. ನೀವಿಬ್ರು ಇಲ್ಲೇ ಇರ್ಬೇಕು. ನಿಮ್ ಚೇಂಬರ್ಗೂ ಹೇಳಿದಾರೆ. 22 ಅವ್ರ ಕಡೆ 22 ಅವ್ರ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಕೊಡಿ. ಅವರು ಡೈರೆಕ್ಷನ್ ಆಗಿದ್ವಿ ಅಪ್ಪ ನಮ್ದೇನೆ. BMC 2 ವೀಕ್ಸ್ ಇದು 2 ವೀಕ್ಸ್ ಇವ್ರೆ ಸರ್. ಹೌದಾದ್ರು ನಮ್ ಕಡೆ ಕೊಟ್ರೆ 2 ವೀಕ್ಸ್. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಸಾಹೇಬ್ ಎಷ್ಟು ಲಿಸ್ಟ್ ಅಪ್ಪ ಒಟ್ಟು ಎಲ್ಲ ಒಂದಕ್ಕೆ ಇದಾವ? ಒಂದಕ್ಕೆ ಇದಾವ? ನಮ್ಮ ಸಾಹೇಬ್ರೇನು ಯೂಶಲಿ ಏನು
Thank you. Lease. Yes.
Okay. Good.
Mention madam.
Date wise.
Submission.
ಹಾ ಕರ್ಸ್ ಅದನ್ನೇ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು ಅವ್ರವ್ರ ಏನೋ ಮಾತಾಡ್ಕೊಂಡವ್ರೆ ಹಾ 80 94 54 ಹಾ 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 ಒಂದು ಕನೆಕ್ಟ್ ಹಾ ಅಡ್ಮಿಷನ್ ಹಾ 140 ಹಾ 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 646 ಹಾ 146 60 ಎಂತ 60 ಹಾ ಆಯ್ತು 8 ಹಾ ಹಾ ಆಯ್ತು ನಾನು ಬಂದು ಹೇಳ್ಬಿಟ್ಟು
54 03 ಕರೆಕ್ಟ್.
ಸಿಕ್ಸ್ ಅಂತ ನೋಡು. ಇಲ್ಲ ಅಲ್ಲಿದ್ದಾವೆಲ್ಲ ಆಗೋದು. 06 ಒಂದು ಗೊತ್ತಾಗ್ತದೆ. 99 ಹಾ ಕೊಟ್ಬಿಡೋದು.
06 ಇಲ್ಲ.
06 ಬೇರೆ ಸ್ಟೇಜ್ ತಾನೆ.
ಅದು ಆರ್ಡರ್ಸ್.
ಈಗ ನಂಗೆ ಹೇಳಿದ್ದೆ ಯಾವ
ಅದೇ ಆರ್ಡರ್ಸ್.
ಲಾಸ್ಟ್
ಹಾ
ಇನ್ನೂ
ಇದಾವ. ಸರಿ
30 ಅದಾದ್ಮೇಲೆ
ಆಯ್ತು. ಅಲ್ಲಿಂದ ನೀನ್ ನೋಡ್
ಮುಗೀತಾ ಅಲ್ಲಿಗೆ.
990 ಇಂದ
06.
ಹಾ ನಮ್ದಾದ್ರೆ ಅಲ್ಲಿ ಇಟ್ಬಿಡಪ್ಪ. ನಿಮ್ದು ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಪ್ಪ? ಅಲ್ಲ ಯಾವ್ದಾದ್ರು ಅರ್ಜೆಂಟ್ ಅಂದ್ಬಿಟ್ರೆ ಏ, ಅದ್ ನೋಡು. 3 ಎಲ್ಲ ಕಂಪನಿ 3 ಲಿಸ್ಟ್ GMCPC ನಿಮಗೂ ಇದೆಯಾ? ನೀವು ನಮ್ಗೆ ಉಲ್ಟಾ ನೀವು ಸರಿ ಬಂದ ತಕ್ಷಣನೇ ನಾನು ಹೇಳ್ತೀನಿ. ಹೇಳಿದ ತಕ್ಷಣ ನೀನು ಹೇಳು ನಿಮ್ ಕೊಡೋದು ಏನೇನಿದೆ. ಅವ್ರು ಕೊಟ್ಟು 22 ಅವ್ರದ್ದು ಅವ್ರ ಕಡೆ ಕೊಡ್ಬೇಕು ನಮ್ಗೆ. ಎಮರ್ಜೆನ್ಸಿ ಮೆಮೊ ಕೊಡ್ಬೋದು. ಕೊಟ್ಟಾಕ್ಟಲ್ಲಿ 22 ಅವ್ರಿದ್ದಾರೆ ಕೊಡಿ ಅವ್ರ ಕಡೆ. ನಮ್ದಿದೆ 2 weeks. ಮೆಮೊ ಕೂತ್ಕೊಳ್ಳಪ್ಪ ಕೂತ್ಕೋ ಬರ್ಲಿ ಅವ್ರು ನಮ್ ಕೋರ್ಟ್ ಬಂದವರು ಅವರು ಇಲ್ಲ ನಮ್ ಸದ್ಯ ಬರಲ್ಲ ನೋಡೋಣ ಹೇಳ್ಬಿಟ್ಟು. ಅಲ್ಲಪ್ಪ ನಮ್ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಅವರ ಹೆಂಗೆ ಅವರು ಅವ್ರ ಕೋರ್ಟ್ ಕೂತ್ಕೊಳ್ಳಿ ನಮ್ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಅವರ ಯಾರು ಅವ್ರ ರಜಾ ಅಂತೆ ನಮ್ ಚೇಂಬರ್. ಅದಕ್ಕೆ ಕೇಳಿದೆ. ಒಂದ್ ನಿಮಿಷ ಎಲ್ಲ ನಮ್ ಕೊಡ್ತೇನಾ? ಆಯ್ತು 2 weeks. ಸರ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಮೂವ್ ಮಾಡೋದು. ಇಲ್ದೆ ಹೋದ್ರೆ ನನ್ ಕಡೆ ಕೊಟ್ರೆ 2 weeks. ಆಯ್ತು ಮೂವ್. RFP ಸದ್ಯ ಬರಲ್ಲ. ಯಾರು RFP ಕೊಟ್ಟು ಸದ್ಯ ಇಲ್ಲ ಸರ್. ವಾರಕ್ಕೆ 1 ದಿವಸ ಅದನ್ನು CPCನೇ ಆಗ್ಬಿಟ್ಟು. ಮೆಮೊ ಇಸ್ಕೋತೇವಣ್ಣ. Follow. Week ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. 2 weeks, 2 weeks.
ಹಲೋ ಸರ್, ವಿಡಿಯೋ ಆಡಿಯೋ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಬಿಸಿಯಲ್ಲಿ ಇರೋರ್ಗೊಬ್ರು ಕೇಳ್ಬೋದು ಅಮ್ಮ ಅವ್ರಿಗೆ ಕೇಳು.
ಶ್ರೀ ಸರ್.
ಅವ್ರ ಹೆಸರು ಹೇಳ್ಬಿಟ್ಟು ಕೇಳ್ಬೋದು.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ.
Your Lordship, the court mic is muted, Your Lordship.
For stay of proceedings.
What is that urgency, madam?
We had filed commercial appeal, my lords. My lords had permitted us to withdraw the commercial appeal and file fresh suit for WP within 20 days, which lapses on 31st of March, madam. There's continuing of stay in lower court, my lords.
No, what is that you are challenging here?
They're challenging the order on IA number 347 rule 10 for return of plaint to file before the competent court having jurisdiction, my lord. So there was stay continuing, my lords. So the last date of hearing, my lords had permitted to withdraw the commercial appeal and file fresh suit for the WPB have filed fresh suit, my lord.
Who has said that you have to withdraw commercial appeal?
The last
This
date of
court.
hearing, yes,
How can be? It is not before me. Commercial appeal will not come before me. Yes. Second.
My lords, this matter was listed, my lords, this matter was previously listed on 12/3, my lords, and it was adjourned at the instance of the KVATA, my lords. There's an interim order operating against me in the trial court, my lords. It's listed tomorrow, my lords, the trial court matter. Hence, it may kindly be taken up tomorrow, my lords.
No, last occasion it was urgent to when?
My lords, no date was given, my lords.
Why? Yes, third.
One covered by decision villa. Question proof villa. Under stamp act, after marking of the documents, it cannot be
Yes,
imported.
second. Yes, fourth, you will have it on third, yes. We'll have it on second, yes.
My lord, plaintiff.
ಆಯ್ತು, ಇಂಜಂಕ್ಷನ್ ಹಾಕಿದ್ರಲ್ಲ ಏನಾಯ್ತು? ಯಾವತ್ತು? Yes, yes,
My lord,
we'll have it on first, yes.
my lord, plaintiff sued for.
What is that urgency,
Court commissioner application and one more application, it's pending for 3 years.
Hmm.
And date by date, every agreement has been given there. And no action will be taken by the.
You are seeking for direction to dispose of. Yes, tomorrow.
Minutes.
No, execution. What is that order passed by that executing court? Objection taken as nil. What is the next date, Mister? Fourth, yes. Hmm. The next date? Yes, Monday,
Lord.
Monday, yes.
So defendant filed an application for temporary injunction.
Hmm.
So the trial court granted, appeal filed, my lord, appeal dismissed. As against it, my lord, writ petition.
Hmm.
There is,
What is that order?
my lord, 39-1 and 2. Defendant filed the application in the plaintiff suit. The same is not maintainable, my lord.
Yes. Second, yes,
Please.
I had filed an application for vacating interim order, but earlier it was listed, but it didn't reach and
yes, fourth,
Please.
yes.
Order 39-1.
Execution petition. What is the next date? Second week of April. Then what is that urgency? Yes, seventh, yes.
My lord,
Lordship, the impugned auction order is scheduled tomorrow. The matter was supposed to be listed today. So your lordship may kindly have. it
For
to-
challenging.
Your lordship, section 3 of Partition Act application was dismissed.
Tomorrow is that action.
Please.
Tomorrow, yes.
Your lordship, today at 2:30.
Tomorrow, yes.
Lord,
Lordship,
order-
today is the auction order. I mean, tomorrow is the auction order.
We'll see it. Yes, when that order has been passed, Mister.
Your lordship, 22nd of March, and I moved a memo yesterday also.
Yes. Yesterday, what has happened? Memo.
It was supposed to be listed today.
Yesterday, date has been given today.
Please.
Check, right? Date ಕೊಟ್ಟಿದ್ದು. Tomorrow, yes. You see that tomorrow.
my lord, I have challenged the order on.
Every date ಕೊಟ್ಟಿರೋದು.
Your lordship,
The order.
tomorrow is the
Yes,
auction.
there is an office objection when court has given a direct and Mister. It has to
I've
be
challenged the order.
verifying that office, any office objection is there.
I have challenged the
Please.
order passed on order 8/1, my lord.
Hmm.
The case is posted for evidence on the 1/4 and already 3 dates have been elapsed. So kindly have it on Monday, my lord, tomorrow.
Not Monday, Mister. Third, yes.
Order 39 rule on dismissed, MA also dismissed.
Hmm.
They have filed, they have started the current connection in this place.
Yes, second, yes.
Your lordship, I have filed.
ಅದೆಲ್ಲ ಯಾಕೆ ಬೇಕ್ರಿ ಮೆಮೋ ಜೊತೆಗೆ? You are giving in a memo or
Photos.
application?
Photos.
Photos ಎಲ್ಲ ಬೇಡ ಇಲ್ಲಿ application memo ಮಾಡಿ.
Yes.
Yes, you give
Your
that
lordship,
memo.
I have filed suit for declaration and injunction. Court commissioner has been appointed and he filed the report.
Hmm.
But trial court rejected my objections, whatever I had filed objection.
Hmm.
So only I am seeking direction to the trial court, take my objections and record your
No,
lordship.
if it is rejected, you have to challenge. How can I direct it, Mister?
Your lordship, I have filed writ petition, your lordship.
Fourth, yes.
My lord, arrest, your lordship, Monday, your lordship.
Fourth. Hmm.
The trial court has, without considering the IFR, not to alienate or create charge over this property, my lord, issued emergent notice.
Hmm.
There is a cut off disposition, my lord, tomorrow, my lord.
Yes, tomorrow, yes.
2000 partition suit, my lordship, in this case. Plaintiff is the petitioner here. Recording evidence completely concluded 2 years back in the 2022 itself.
Hmm.
During the course of cross-examination of the DW1 by the plaintiff, some of the omissions and admissions are there.
Hmm.
In the background of the DW1, file an application to cross-examine DW2 again, which is not permissible. That civil court is allowed the application, therefore we filing an application, the interim order is passed by this honorable court, that is stayed, my lord.
Hmm.
Matter is so urgent, citizenship, 86 years old, my lordship, plaintiff.
Yes, we'll have it on second, yes.
My lord, arrest warrant is being issued against the petitioner, my lord, in the execution.
Please.
proceedings.
When it is issued?
First week of April, ma'am.
First week of?
April.
No, when the order has been passed, Mister?
Last year, my lord,
Last year. Till you have not yet arrested.
Mhm.
Then you were safe, yes. Fourth, yes. Yes, all the
My lord,
other court matters.
my lord, one request, my lord.
We take a date.
Portal number 22, my lord. There are two lists, my
Memo. My lord, police protection has been ordered, my lord. We are actually in possession and we stand.
Wait, somebody is mentioning, Mister. Yes.
My lord, there are two lists, my lord. Second list may be posted for third, my lord, because every Thursday is only being posted. my lord.
Third. What
First
about
list will be 10th, my lord.
First
there are
is tenth.
My lord, and first
There are two lists, my lord.
Hmm.
First, second list, third, first list, 10th, my lord.
There is no urgency, no. There is no urgency. Let it come on 10th.
Yes.
My lord, first list, item 51.
Wait, wait. First,
Secondly, some urgency is there. It may be, take it up on third one.
third, yes.
First list were requested, for the 15th, my lord.
All list, entire list.
10th is holiday.
10th holiday.
15th or 16th?
15th, 16th.
16th,
15th,
16th.
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 Huh? Guruvara, 17th.
Please.
17th. Second list, 3, 4. Yes, all that matter, yes.
My lord,
That is 19, next week, yes. Yes.
19.
my lord, memo,
Yes.
59.
my lord, the,
Today's list.
In which matter, in which, our list?
Please, my lord.
We will call, wait, yes.
my lord, they've ordered police protection, my lord. We are for the defendants and we are in possession, my lord. We stand at the risk of dispossession. So it may be heard, my lord.
No, what is that order you are challenging?
Police order, granting police protection to the plaintiffs, my lord.
No, you have any injunction order in your favor?
No, my lord.
Second.
We are claiming that we are in possession, my lord, so it may be taken up.
No,
this
that,
action.
is there any injunction order against you?
No, my lord.
Then why police protection, mister?
The plaintiffs have gotten the order.
Yes, next week, 3rd, yes.
Total number 12 matters for adjournment, list number 1, page number 1, serial number 1 to 8. Page number 2, serial number 9 to 16. Page number 3, serial number 17 to 26. Page number 4, serial number 27 to 30. Page number 5.
30.
Serial number
30.
20,
30.
30. Yes, you are appearing for?
I'm appearing for this one.
I'm for the petitioner in this matter, my lord.
No, 20, nobody is there for respondent, 30.
30, my lord. I'm appearing for the petitioner.
What do you want?
Short adjournment may be granted.
Tell the respondent.
My lord, I'm
Gupta.
yes, I'm appearing for Karan Gupta. My lord, I
Where is
don't
that
have.
respondent, mister?
We'll undertake to file the.
You want to file? No, what is that?
We'll undertake to file the wakalat.
Yes.
My lord, I'm not objecting to the adjournment. My only request is before the trial court, we may jointly undertake that the trial court may keep the matter pending, because my concern is that the trial court is going to dispose of the execution petition on the next date, on 3rd April. If my learned friend will consent, we will make a joint submission before the trial court and a date may be fixed, Your Honor.
Yes. When do you want?
Any date.
2 weeks.
A
Yes. at
date
the
may be
request
fixed,
of
my lord.
So and so learned counsel undertake to file wakalat for respondent. At his request, leaves this matter after 2 weeks.
My lord, may I request a date may be fixed?
Yes. 17th.
Obliged.
Yes.
Page number 5, serial number 31 to 34.
Serial number 33, Your Lordship. I may
Yes.
be permitted to convert a writ petition into MFA.
Into MFA.
Yes, Your Lordship.
Yes. Learned counsel for the petitioner filed in a memo. Seeking permission to convert this writ petition in miscellaneous first appeal. Memo is taken on record. Petitioner is permitted to convert this writ petition into MF.
2 weeks time.
Yes. For such purpose, writ petition is disposed of.
Page number 6, serial number 36 to 35 to 37.
My lord, for serial number 37, my lord, I pray a short adjournment be granted. I am for the petitioner, my lord.
Yes, at the request of counsel for the petitioner, leaves this matter 2 weeks.
Page number 7, serial number 38 to 40. Page number 8, serial number 41 to 43. Page number 9, serial number 44 to 46.
My lord, we already filed a withdrawal memo. Kindly permit us to withdraw this.
Which one?
46.
Want to withdraw? Yes.
Yes.
Dismissed as withdraw. Yes.
Page number 10, serial number 47 to 50. Page number 11, serial number 51 to 56.
You are appearing for? You have informed? Yes. At the request of counsel for the respondent, leaves this matter after 2 weeks. Interim order granted earlier is extended till next date of hearing.
Page number 12, serial number 57 to 59.
My lord, 59, my lord.
Hmm.
I appear on behalf of the petitioner in WP 411 of 2024, my lord. I seek for 2 weeks accommodation, my lord.
Yes.
In this 59 and 59.1, now I hold NOC wakalat for the respondent in 59
and petitioner in 59.1.
Hmm.
In 59.1, there is some urgency is there because interim order which I got it in the trial court was vacated by the appellate court. Hence, I have filed it and there is no interim order as such. 59.1 is concerned, it may be called next week. The other one may go after 2 weeks also. I have no
He is
objection.
asking in 59 only.
Both, my lord, both.
No, but he has an
I'm a
objection.
petitioner in 59, my lord,
But there is-
respondent in 59.1.
It's the application for vacating interim order.
In 59. Please, my lords, it may be taken up at least next week, my lord. In fact, we had informed the opposite side counsel. We were unaware of the fact that there is a NOC wakalat.
Yes.
Date may be fixed.
Yes,
or-
sir. The request of counsel for the petitioner, leave this matter on 8th
My lord, interim order may kindly be extended, my lord.
till next date of hearing.
Grateful, my lord.
Page number 13, cell number 60 and 61. Page number 14, cell number 62 to 65. Page number 15, cell number 66 to 71. Page number 16, cell number 72 to 77. Page number 17, cell number 78 to 83. Page number 18, cell number 84 to 93.
Your lordship, serial number 89, your lordship.
Hmm.
A short accommodation of 2 weeks may be given. Senior is not keeping well.
You are appearing for?
Respondent, your lordship.
Yes.
Objecting in lordship, will hear the matter.
You have an objection. Yes, madam, what to do?
Senior is not keeping well.
Not well.
Sometime may be granted.
Wait,
your
wait,
lordship.
wait.
Trial court is actually in the matter, my lordship, so we would like to hear it today.
Your lordship, they have not been appearing in the trial court from many dates, your lordship.
Kindly pass it over, my lordship, senior will.
Yes, you inform the senior and mention, madam.
We
No,
have-
you just ask your senior that other side requesting the time on the ground that counsel is not well.
I had called up, my lordship.
We have informed
I
them.
was given instructions to object.
No, that even that after that also you are, yes, let us see, madam. Yes,
Great.
let us.
CL number 88, lordship.
Hmm.
Inconvenience to the senior today.
80,
88,
88, you are appearing for?
petitioner, lordship.
Yes, at the request of counsel for the petition. Have you informed other side?
Please, lordship.
The request of counsel for the petitioner leaves this matter next week.
Please.
Page number 19, cell number 94 to 100. Page number 20, serial number 101 to 107. Page number 21, serial number 108 to 110.
109, lordship.
Hmm.
Same, lordship.
Yes. You are
And for
appearing
the
for?
petitioner, lordship.
At the request of counsel for the petitioner leaves this matter next week.
Please, lordship.
List number 1 for preliminary hearing, serial number 1, Balraj AC for petitioner.
Kindly pass over, my lord.
Yes, pass over.
Serial number 2, Santosh BM.
Suit for partition, my lord. Was filed in the month of February 2020, my lord.
Hmm.
While instituting the suit, my lord, the petitioner's property was not inserted in the suit schedule. During the pendency of the suit, I purchased the property.
Hmm.
In the year 2023, my lord, by way of an amendment, my lord, they have sought for impleadment of the property and, inclusion of the property and an application for impleadment, my lord, impleading me, my lord.
Hmm.
My lord, your lordship may kindly take the IA, my lord, filed by,
No, impleading is allowed.
please, my impleading and amendment both are allowed.
Yes, where is that order?
Order, my lord, is that annexure A, my lord, page number 36.
No, this is amendment. Where is that IA for?
IA, my lord, 62, my lord.
No, both order you are challenging.
Both are right. My lord, 62, my lord, is the IA. Annexure D is the IA.
Annexure?
D is the IA. At the time of filing the suit, this property was not included. My lord, after 2 years, my lord, it has been, after 3 years, my lord, it has been inserted.
No, you are the
My
defendant.
lord, some basic pleadings, my lord, in the IA, as a prudent person, my lord, some basic, this was the date I got the knowledge. This, if not in the affidavit, my lord, at least in the amendment which they have sought.
No,
At,
Mr.
I may permitted to read this.
No, see, you are the defendant.
No, please, I am the defendant,
Hmm.
proposed defendant.
No, you are the
Proposed defendant number 9.
The application has been filed to implead you as a.
Please, please.
On what ground they are asked to implead you?
My lord, I am the purchaser of the property during the pendency of the suit. They say that this is a joint family property. This was not a joint family property. It was independently purchased by defendant number 4, my lord. My lord, some basic pleadings should be there in the IA. My lord, your lordship may kindly take annexed D, my lord. Affidavit.
Now, where is the order passed by the trial court?
Trial court, my lord, is at page 36.
No, this is an order on IN order 6/17.
Please.
No, you are challenging that impleading. You have been impleaded as a party.
Both are in the same order.
ಎಲ್ಲಿದೆ ಅಲ್ಲಿ?
Other continuation is ಅಲ್ಲೇ ಇದೆ. 39 page number
yes.
39 is the other order.
Yes, yes, now that what
They
is
were
the-
supposed to pass two independent.
Yes, yes, now that order has been passed. Now, what is the reason given by that? You read that page 40.
They say that evidence is not yet started.
Page 40.
So far as amendment is concerned, my lord, page 37 is the reasoning.
No, now first your grievance is that impleading.
Both impleading and amendment.
First implead you answer.
Impleading.
Come to page 40.
Page 40, my lord.
Hmm.
The question as to whether the property sold was absolute property of the fourth defendant for him to have executed a sale deed is one that would have to be answered at and after trial. The sale deed dated so and so is admittedly a pendant late sale, and under such circumstances and having regard to the judgment in ILR so and just so, in order to see that the proposed defendants are subject to the process of the court and there are no further alienations, the application is required to be allowed. Accordingly, I pause the following.
What is that 2016 ILR Karnataka?
Lord,
Have that judgment.
no, I have not.
Then you are arguing on that.
My lord, some basic pleading should be there in the right. One ನಿಮಿಷ sir. Hello.
No, Supreme Court said purchaser is a necessary party. Purchaser, in all cases, purchaser himself has to be come forward to implead as a person in that partition suit on the ground that he can claim his equity.
No, this was never a joint family property. If at all it was a joint family property, they would have inserted this during the institution of the suit itself.
Mr. Counsel,
Please.
then you should be thankful to them. They have been impleaded you and you have to go and say that this is not a joint family property. If you are not there, they will collide and pass given a consent degree.
No, I have also challenged it. The insertion of my property, they have sought for amendment to insert my property, my lord. My lord, even that I have challenged.
No, then you are impleading, then you can challenge that. You are challenging that you are impleading also. How can you challenge if your impleading application is dismissed, Mr.?
No, both I have challenged in this writ petition, my lord. Impleading and amendment.
No, by impleading, you get a chance to object it, is it not?
I've sought for setting aside the amendment itself, my lord. The order of amendment to insert my property in the suit schedule.
Then you should be in a party. Should you not be in a party to object in that writ, in that suit?
No, my lord, I have sought even for setting aside that order also, my lord, in this writ petition. Both orders I have challenged. Both orders I have challenged in this writ petition.
That is true, Mr. Now you are in that party in the suit. There you can file an application saying that this, or you can file an objection saying that this is not in a joint family. Suppose if you are not made as a party there, how can you contest that?
No, the question of me contesting doesn't arise, my lord, because this is not a joint family property. It was independently purchased by the defendant number 3, my lord.
That has to be decided by the trial court, not me, Mr.
My lord,
Yes, ILR.
my lord, your lordship may kindly take annexed D for a moment, please.
Yes.
Para number 9A. It is submitted that after the plaintiff filed the above suit against the defendants, they knowing well about the pendency of the suit with malified intent to defeat the rights of the plaintiff or the property bearing survey number so and so village, which is purchased by the defendant number 4 from 1 Bommaya, so and so white registered sale deed dated 2014, registered in the office of the sub-registrar so and so, the said property as purchased out of the joint family funds, which is joint family property, and defendant number 4 without consent of the plaintiff and family members has sold the said property in favor of Mr. Dattatreya Rao, white sale deed dated so and so, registered in the office of so and so. My lord, when they came to some basic pleading should be there. When they came to know.
That is their suit for partition, they can include that any properties of the
No,
joint family
they
at any
they
time.
say that this is joint family property. They deliberately don't insert this property. No, at the institution of the suit, this was not inserted, my lord.
No, they can insert at any time, Mr. If it is a.
No,
joint family.
at least there should be some basic pleadings, my lord.
Yes, notice.
My lord, sought for, at least this, my,
No, I am hearing that purchaser has filing an application to implead me, but you are saying that I have to be deleted.
no,
Yes. Notice.
even this amendment doesn't survive.
Yes, notice.
Serial number 3.
My lord, at least stay of the impugned order, my lord.
Pass an order on merit itself. Which is that
My
judgment?
notice,
Yes, we'll pass an order. Yes,
notice, my lord.
yes. Notice.
Serial number 3, Shanta Kumar
Here
KC.
for the petitioner counsel,
Yes.
defendant writ petition. Suit was specific for an agreement dated 2011-2014,
Yes,
executed by me in favor of the plaintiff.
yes.
Sale consideration was agreed at 17,25,000.
Hmm.
On the very same day,
Hmm.
another agreement was executed by the plaintiff in my favor.
Hmm.
Sale consideration was shown as 1,20 lakhs.
Hmm.
This advance amount has to be adjusted toward that amount, this one so on. Then portion of the property has been notified for Bangalore-Mysore highway. That is why neither of the parties does not want to press the agreement of sale between the parties. In spite of it, suit came to be filed before the trial court.
Hmm.
Your last may kindly take the written statement filed by me, page 17.
No, that suit is filed by whom?
Suit is filed by the plaintiff
No, seeking?
for enforcement of the agreement of sale dated 2011-2014 executed by me in his favor.
Yes.
And another agreement of sale executed by him in my favor, very same day.
No, first agreement you have executed.
ಒಂದೇ ಡೇಟ್ ಇದೆ ಎರಡುವೆ.
You have executed, say, for what? Want to
Sale. 2011-2014 is the agreement of sale executed by me.
2011,
2014.
20,
Selling this survey number 178/1,
178/1, yes.
21 guntas.
Hmm.
Sale consideration was fixed at 1,20 lakhs.
1,20 lakhs, yes.
Then another agreement of sale executed by the plaintiff in my favor
Yes.
in respect of survey number 188/6.
Sutherland, it is like an exchange.
Exchange.
Yes.
ಮುಂದೆ ಏನಾಯ್ತು ಅಂದ್ರೆ portion of the property has notified by Bangalore-Mysore highway for extension of the road.
Which you have land by yours.
Nandu.
Nimdu.
He doesn't want to purchase the property.
Hmm.
Similarly, I don't want to exchange the property. The sale consideration is only an adjustment.
Yes, yes.
No cash transaction between the parties. Kindly take paragraph number 4 of my written statement. I mentioned the same in the written statement.
Page,
Page 17.
yes,
Paragraph 3, I admitted the sale agreement of sale executed by me in favor of the plaintiff.
yes.
Paragraph number 4, I said it is submitted that another agreement was executed between the plaintiff and the defendant on 2011-2014,
Hmm.
wherein the plaintiff has agreed to sell so and so.
Yes.
ಇದಾದ ನಂತರ I did not give an explanation what had happened to subsequent to that.
Hmm.
Now the plaintiff has lead evidence. I filed an application annexure C page 23.
Yes.
I wanted to incorporate what had happened subsequent to that agreement of sale.
Hmm.
Kindly take annexure C page 23.
You are filing an application for amendment.
Amendment including that neither of the parties doesn't want to enforce the agreement of sale.
Yes.
The trial court proceeded on the basis, I have not made any statement at all. Kindly take the order passed by the trial court, annexure E page 29.
Yes.
Sorry, annexure E page 30.
Yes.
Relevant portion will be at the last page, page 35.
Yes. Read.
The object of the rule to avoid the multiplicity of proceedings. Moreover, the amendment should not be allowed, where the other party cannot place the same position as if the pleading has been originally correct. The proposed amendment amount to a fundamental alteration of the pleading. The plea taken by the defendant altogether different. It is not altogether different, it is already in there.
Yes. Heard. Issue notice. Stay of further proceedings in OS number 111 of 2022, pending in the file of Principal Senior Civil Judge C.J.M. Hassan till next date of it.
Serial number 4, Laksha Kalappa petitioner.
For
Yes.
this petitioner, my lord.
Yes.
My lord, this stems from a commercial suit, my lord. Suit is filed for by the landlord against the tenant for recovery of arrears, my lord.
Yes,
Lease deed is executed in 2013.
yes,
Defendant numbers 1 and 2, that's the petitioners, are running a lounge and bar in the premises.
yes,
In 2018, what happens? They decide to induct and let go of the management. They hand over the management entirely to defendant number 3, who's the respondent number 2 here.
Yes.
Respondent number 2 starts paying the rents. There's onset of COVID, as a result of which they are unable to pay rents.
yes.
Then we are evicted from the premises. Notice is issued, PIM proceedings are initiated, then suit is filed, my lord.
Yes.
During the process of the suit, all of the movables that were in this bar and lounge continue to be in the premises. In 2023,
Yes.
the respondent number 1, the plaintiff, files an application to injunct the defendants from selling any of the movables and to attach defendant number 2's personal property. The trial court vide order at Annexure F, page 70, my lord, rejects this injunction application and attachment applications under Order 38 and 39. Thereafter, in the same year, the trial court passes the order in February 23. In November 23, they sell all of the movables. They do not inform me at all. In 2024, after the plaintiff concludes evidence, I file an application to appoint court commissioner to see what and all remains in that property, because I have to lead evidence basis on that. To my application, they file objection saying no property is there. It has all been sold entirely, and the same is admitted by the witness in cross-examination. I file an application, the IA numbers 18 and 19, before the trial court, seeking to deposit that 9 lakhs which they have recovered by selling my goods as scrap before the trial court, and for a list of whatever they have sold. Trial court rejects my applications by saying that it's unreasonable, and because I have no counterclaim, my application is not maintainable. My submission before the trial court was also that I did not have a cause of action for a counterclaim, because I believed that those things still existed there. And my cause of action arose when they filed objections to my application to appointment of court commissioner. The trial court has refused to take my
Where is your
submissions.
application?
The impugned order is at page number 26, my lord.
Where is your application, madam?
My lord, my application is at page number 103, Annexure K, my lord.
Yes. Deposit sum of rupees obtained from that sale of the immovable property that was in the premises, all that piece and parcel of that area so and so, built situated on the second floor of the so and so place so and so situated. How can you seek such a directions in his suit, madam?
My lord,
Which is the provision which is provided for to seek a direction to the plaintiff to deposit that?
my lord, because it's my movables, they've sold my property without
Your
my permission,
movables
and they have not informed.
have any right, you have to approach the court and get an order, not
My-
that you are seeking in his.
My lord, the reason I'm seeking the deposit is very simple. They did not tell the court, if they have misused my 9 lakh rupees, the plaint has to be amended and the amount that they're claiming has to be adjusted as against it. They didn't even inform the court. So I filed 2 applications. One for let the money be deposited in court. I don't want the money.
No, you
Or-
don't, first we have to establish what is your right, madam. You
My-
can say 100 things, I don't
My
want.
property, my lord, it's my money which they've sold without, my
No,
property that they've
your
sold without.
property, somebody is selling illegally, you have to approach the court and take an injunction. If he
Well,
has
it's
filed an.
sold. I can't, there is no injunction at all. I can file an application for Order 39 in the mandatory form for them to deposit. But when I file that
If there
mandatory,
is no injunction, if there is no.
my lord, I'm sorry, my humble submission is that an application under Order 39, 1 and 2 in the mandatory form, the position, it is, if I ask them to deposit the rent, it amounts to a 151 application itself, my lord, because
Yes.
they may raise an objection saying that Order 39, 1 and 2 in mandatory form is not maintainable and 151 hakirodu. And the court has discretionary power to deposit it. At least
No,
let the money be in court, my lord. It's my money.
No. Just because you are asking that, you can't do it, madam. You should be sure that right in the suit. You can't ask that, see, you can't file which is prohibited under Order 39, Rule 1 and 2. That is, you are invoking 151 and getting that. That cannot be, madam.
They have
151
admitted
is
in
not
their
for that to
objections saying that it's
come
my
in that
property.
backdoor entry, madam.
My lord, this is my only relief left. There's section 144 and 151 of the CPC
Yes,
under which
yes,
I have to
yes.
seek relief.
Yes.
They have in the objections, they have admitted that they're my property. They didn't tell me that they're selling it. Even if this is wrong, my lord, the conduct, they have illegally sold my property.
We are not deciding all these things, madam. It is not a public interest litigation. You stick on to this case.
My lord, this case, I have.
First, you have to establish your right.
My
then
lord,
we'll see that
the
conduct.
right is that it is my property and I have the reason I filed for I asked for two applications, my lord. One is at Annexure K and one is at Annexure M for list of mobiles which they have sold, my lord. I
Yes.
don't know what they have sold. I have produced the,
Yes, you take notice. Yes.
my lord, my lord, the trial court matter is pending on Monday. I have to lead evidence. I have filed an application for judgment of admission. I filed an application for perjury. If this money, if I do not file for counterclaim, I lose my cause of action and limitation, my lord. And the trial court, let me just read the order, says I have no cause of action for counterclaim, my lord. And such being,
That is left to you. We see.
my
court
lord,
has not
if
said-
it stayed till the next date of hearing, let a date be fixed and this writ petition be disposed of,
Yeah,
my lord.
Madam, if we have any counterclaim, then only you can file an
My
application.
lord,
That's what they said.
counterclaim- Yes, my lord, but the counterclaim is
Yes,
that
yes,
the
you
mobiles
read
have
that.
been sold.
Yes, yes, I will conclude that. You read. Yes, what is that impugned order?
At page number 30, my lord,
Yes.
the inventory has been prepared and it has been duly signed by the defendants and they have not chosen to
Now,
take.
where is the finding of the trial court?
My lord, the finding of the trial court is at page number 32, my lord.
Yes. Yes.
That
read.
on perusal of the written statement averments, the defendants have not stated anything about their counterclaim or set off as against the plaintiff. So the defendants asking for deposit of sale consideration in the court will not serve any purpose. Arguments seem to be reasonable. Moreover, the application itself, the defendants have categorically and unequivocal admitted the joint inventory has been conducted in their presence and it is a specific contention of the plaintiff that the defendants have signed the inventory. Such being the facts of the case, defendants well aware of the list of the mobiles belonging to them allegedly held in the suit schedule premises. If such would be the fact, what is the necessary to ask further list of mobiles from the plaintiff has not been explained. Since the plaintiff has filed the present suit against the defendants with specific contention that defendants are liable to certain amount
Where
in
are you
respect-
reading?
Page number 32, my lord.
You read 30,
2, my lord.
32. You read from 31. Reasons start from 31.
Yes, my lord. That on perusal of the contentions of the applicants, defendants, it reveals that they are seeking direction against the plaintiff to produce list of mobiles belonging to the defendants held in the suit schedule premises have been sold by him, also sought for direction for depositing the sale consideration amount of 9 lakhs in the court till disposal of the case. These facts have been denied by the opponent plaintiff in common objections, contended that the applications are filed in a belated stage only with the intention to protract the proceedings. The list of mobiles belonging to the defendants, which were existed in the suit schedule schedule premises, are mentioned in the inventory prepared in their presence. After preparing the inventory, the defendants did not chosen to take possession of mobiles, but handed over possession of the suit schedule premises with no alternative. The plaintiff sold them for consideration amount of 9 lakhs. The plaintiff has filed the present suit against the defendant for recovery of unpaid rent and other damages, same as subject matter of the suit yet to be adjudicated. So the application filed seeking deposit of sale consideration amount is unsustainable. Further, list of mobiles sought by the defendants under the applications are already available in the court record as Exhibit P64. Despite the same application is filed only to create hurdles in the adjudication of the case on hand, admittedly, the plaintiff's side evidence has already concluded. Defendants are required to lead evidence at this stage these applications are filed. That on perusal of the written statement averments, the defendants have not stated anything about their counterclaim or set off against the plaintiff. So, the defendants asking for deposit of sale consideration in the court will not serve any purpose. Arguments seem to be reasonable. Moreover, the application itself, the defendants have categorically in an unequivocal term admitted the joint inventory has been conducted by the plaintiff in their presence, and it is a specific contention of the plaintiff that defendants have signed the inventory, such being the facts of the case. Defendant well aware of the list of mobiles belonging to them allegedly held in the suit schedule premises. If such would be the fact, what is the necessity to ask further list of mobiles from the plaintiff has not been explained. Since the plaintiff has filed the present suit against the defendants with a specific contention that defendants are liable to pay certain amount in respect of the suit schedule premises, so now reason found to direct the plaintiff to furnish list of mobiles to be held in schedule premises, so also no necessity found for directing deposit of the sale consideration in court. As already discussed above, admittedly, there is no counterclaim or set-off made by the defendants. At this stage, without any counterclaim seeking direction for deposit of the alleged sale consideration appears to be unreasonable to accept. The applicants have miserably failed to make out grounds for considering the prayer sought in the applications. The applications are filed only to protect the proceedings.
Yes.
No reason to deny. My lord, the court has said there is no counterclaim, so I cannot give deposit nor give the list.
Yes.
Swami, scrap ಆಗಿ ಮಾರಿದ್ದಾರೆ. I am saying that it was a bar and lounge. There were music systems, there were equipments, there was all sorts of which they've sold for 9 lakh rupees as scrap. ನನಗೆ ಹೇಳಿದ್ರೆ Swami, we would have got somebody together, sold it, and I would have been able to pay back what I was owed to them. And for the court to not even say that till date, it's been 2 years since they've sold it, they have not amended the plaint, they've not even informed. If I had not filed that court commissioner IA, my lord, my 9 lakhs would have not, they would have not told the court. They would have used up my 9 lakhs in addition to principal and interest, my lord. That's the reason I'm asking for a list is because they have only given me invoices which I have produced, my lord, at page number
Yes.
125. It says ferrous waste and scrap,
Yes.
aluminium waste and scrap, electrical and electronic waste and scrap.
Yes.
My lord, some of the speakers are worth 15-20 lakhs, which was used in that bar and lounge. So if they've sold it as scrap, I want to know what has been sold. If they are able to prove their claim as against me of 68 lakh rupees,
Yes.
idan marbitte ನನ್ನ debt na clear ಮಾಡ್ಬೋದಿತ್ತು ಸ್ವಾಮಿ. ಇವಾಗ now I've lost this, I've lost my 9 lakhs,
Yes.
and I have to pay them more money. That's why I'm saying let it be deposited. And they've lied on oath. Evidence affidavitally, they've not mentioned about the sale, my lord.
Yes.
So that's the reason I'm asking for the deposit to be, and a list to be furnished as to what they have sold.
Yes. That's
My lord, if the suit is stayed till at least 3-4, my lord, the writ petition may be listed on the same date of hearing. It can be disposed of on that.
completed your argument.
Yes, my lord.
Yes. Third. This petition is filed by defendant number 1 and 2, challenging that order dated 17/2/2025, passed by 88 additional city civil and session judge, Bangalore, whereby IA number 18 and 19 filed by that petitioner is dismissed. The plaintiff has filed a suit for eviction. What is the stage in the suit?
My lord, it's posted for objections to my application for admission of judgment, admission on judgment, for objections to my perjury application, and for me to lead evidence.
You have filed a written statement.
Yes, my lord, I have filed it.
Yes.
It's produced
service of
before this
summons.
honorable court at annexure C, my lord.
Defendant has filed a written statement. Issues is not yet framed.
It's framed, my lord.
On the pleadings of the parties, the trial court has filed an issue. The matter is posted for evidence.
Yeah, and objections to IS.
Yes, at the stage, defendant has filed this application. The plaintiff has filed present suit against the defendant for recovery of the unpaid rent and the other damages. Is the subject matter of the suit has to be adjudicated by the court. The grievance of the defendant that the plaintiff has sold that articles which is inside the premises, which is belongs to the defendant for sum of rupees 9 lakhs, directed to be deposited before this court. It is not disputed by the petitioner defendant that the joint inventories has been conducted by the plaintiff in their present. The plaintiff defendant, the defendant petitioner have signed that inventories. The plaintiff, the defendant is aware of the list of the movable belongs to the alleged to be held in the suit scheduled premises. The list of inventories is also placed before the court. When the issue in respect of relief of the plaintiff regarding recovery of unpaid rents, other damages is pending before the court. When defendant has not filed any, claimed any counterclaim or set off, therefore, the trial court has rightly rejected that application. There is no error or illegality.
My lord, my cause of action didn't arise till I knew that they sold the property, my lord. The suit is going on. Sub judice,
You
they
have
sold it.
completed an argument, I have passed an order. If
My
you
lord,
have any grievance, you challenge it.
My lord, but there was
Don't
no
tell
cause
what
of action, my lord. And the Honorable Supreme Court has held that when cause of action has arisen after
Madam,
issues,
you won't challenge it, my order.
my
if
lord,
it is not.
I can challenge it, my lord, but
If after completion, if you want to interfere, it amounts to a contempt, madam. I have
my lord, but-
concluded my
lord, but
arguments.
Cause of action has not arisen. It arose only after they told me that they sold the properties, my lord. That goes against the basic principles, my lord, that there is,
Madam,
my lord, cause of action for a counterclaim only arises much like a plaint, my lord. I can file a separate suit for the 9 lakhs. That's the point of a counterclaim under order 8, my lord.
I have dictated, madam. You do.
I know,
whatever-
my lord, but there's no cause of action to confirm the order. The trial court is grave misjustice, my lord. Let at least notice be issued on this writ petition, my lord. Let them come and confirm, argue the matter, my lord.
That I said, issue a notice, you said that you want to stay, therefore.
My lord,
No,
but
madam, I have
there is, it
dictated.
was fairly, I had pushed for an interim order, my lord, because, my lord, the trial court will
completed.
proceed. I will lose my,
Next matter,
I
madam.
cannot maintain a counterclaim, my lord, such being the case, because he's already adjudicated on the issue of counterclaim, my lord,
Yes.
when I did not file such an IA, my lord. When without me filing an application for counterclaim, trial court has said I do
How
not
many
have a
years-
cause of
How
action,
many
my lord.
years you have put in that bar, madam? Once court has dictated the judgment, it's the end of that matter.
I know, my lord, but I can still
Then
try and
you are
convince this honorable
still
court, my
interfering
lord.
into that court proceedings, madam. Yes.
Serial number 5, Annaya CV.
My lord, appear for the petitioner. My lord, the petitioner is the plaintiff in a suit for partition before the trial court.
Yes.
The third defendant, after 14 years of filing the suit,
Yes.
attempts to file a written statement. At page 32,
Yes.
IA 20. That application is rejected. Defendant number 3 is not permitted to file written statement.
Yes.
Then next she files IA number 27, page 41 for transposition as plaintiff.
Yes.
That application is rejected, not challenged.
Yes.
As on date, the third defendant has no defense in the partition suit.
Yes.
ಆವಾಗ ಏನಾಗ್ತದೆ, I file an application under Order 1, Rule 10, saying that I want to make KIDB a party. Then I realize that KIDB in a partition suit is not necessary because anyhow, whoever succeeds will go to the KIDB, take the money. So I file a memo. Please come to page 54. So, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾರೆ, third defendant files objections. Ultimately, the court, please come to page 55.
Yes.
The plaintiff filed the suit against the defendants for partition and separate possession. Already the suit item so-and-so acquired by so-and-so for development. Compensation amount to be awarded for which plaintiff and defendants are entitled to their share. Considering all these facts, making propose is not necessary.
Yes.
Hence, the proposed defendant is not party to the suit. So my memo is accepted. My application is
Yes.
permitted to be done. Then what happens is the third defendant makes an application to implead the very same KIDB, which the court has said is not a necessary party.
Yes.
Please come to page number 62. ಅರ್ಜಿ ಹಾಕೊಂತಾರೆ.
Yes.
I file my objections.
Yes.
Saying that principles of res judicata applied in the different stages of the suit.
Yes.
The court itself has held that defendant number 9, the same KIDB is not a necessary party. You can't, there's no need. And I being dominus litis, I'm saying I don't want him as a party.
Yes, no doubt the court under Order 1, Rule 10(2) has the power to say, no, please make him a party, direct me.
Yes.
But to do that, the court has to come to the conclusion that the person is a necessary party. My lord, please see the order now. Without considering any objections, page number 23. Issue notice to proposed defendant. The same court has held earlier, page 23 ನಲ್ಲಿ type copy ಹಾಕಿದ್ದೀನಿ.
Yes.
Issue notice to proposed defendant. My lord, the court itself has held that 9th defendant is not a necessary party. Second time when the third defendant files, I filed objections until the court has come to the conclusion. When I filed objection being dominus litis, if you want to overrule my status and still say under Order 1 Rule 10(2) that you have to do, court has to say yes, is a necessary party. The question of issuing notice doesn't arise.
No, they may dismiss it after.
No. The question is, the point is this, my lord. This is what I'm saying, pure question of law. My lord. The court, because your lordship sees Order 1, Rule 10(2). 10(2), my lord. Order 1, Rule 10(2). Yes. My lord, please see 10(2). The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to be to the court to be just, order that the name of a party properly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined as plaintiff or defendant, whose presence before the court may be necessary, be added. My lord, what happens is, now the question is, it doesn't depend upon KIADB to say whether I want to be a party or not. It depends on the plaintiff. The plaintiff has to say, I want him as a party, because ultimately, if it is not necessary party, my suit will go. But for the honorable court to say, no, I'm not accepting your objection as dominus litis, then what happens? My lord, please see this. Two judgments of the apex court. Paragraphs 7. Para 7, my lord.
Yes.
It's on the third page. Lordship has it, no? Para 7.
Yes.
By operation of the above quoted rule, though the court may have power to strike out the name of a party improperly joined, or add a party either on application or without application, but the condition precedent is that the court must be satisfied that the presence of the party to be added would be necessary to enable the court to effectually and completely adjudicate. That is true, now what happens is now comes the issue. Please see this judgment. Please see this judgment, my lord. 22 judgment. Please come to para 10. Please note that earlier, this court, the same court, in the very same suit, has held that KIDB is not a necessary party. My lord, then please come to para 10.
Para 10.
Para 10. To the bottom of the page. Para 10.
Yes.
From what has been noticed and discussed in the preceding paragraphs, it remains hardly a matter of doubt that the doctrine of res judicata is fundamental to every well-regulated system of jurisprudence, for being founded on the consideration of public policy, that a judicial decision must be accepted as correct, and no person should be vexed twice with the same kind of litigation. The doctrine of res judicata is attracted not only in separate subsequent proceedings, but also in subsequent stages of the same proceedings. On the face of it, my lord, unless the court had said that my earlier order was wrong, KIDB is a necessary party. This very court in this very suit says, not a necessary.
Where is that earlier order?
Yes, but I'll point. See, please see page number 20. No. I'll give it to you. Page number 54. Page number 54.
Yes. Read, what is the reason?
The plaintiff filed the application, page 54, I'll read from the beginning.
Yes.
The plaintiff filed the application Order 1 Rule 10 to permit the plaintiff to implead Karnataka Industrial Areas Development Board as defendant number 9 The defendants filed their objection to IA 25. Subsequently, the plaintiff's counsel filed a memo for not pressing IA 25. The plaintiff filed the suit against the defendant for partition and separate possession. After filing of the IA 25, the plaintiff has realized that the proposed defendant is not a proper or necessary party to the suit. The suit schedule properties have been acquired by the proposed defendant nine. Further impleading of proposed defendant only complicate the issue involved in the case and further delay. Hence, he pressed allow the memo and dismiss the IA as not pressed. The defendant number 3 filed objections to the memo. Defendant number 3 objections. The plaintiff is blowing hot and cold at the same time and filing a memo whimsically whenever he desires and retract the same. The plaintiff himself has filed IA 25 containing that whereas the defendants are having legitimate share in the entire suit properties. If IA 25 is not allowed, the other sharers will be put to irreparable loss. The intention of filing this memo is to draw the entire compensation amount and deprive them. But then hurt both sides. The plaintiff filed the suit against the defendants for partition and separate possession. Already the suit item 5 to 9 so and so acquired by KIDP for development purposes. Compensation amount will be awarded for which the plaintiff and defendants are entitled to their share as per the partition suit. Considering all these facts, making defendant number 9 a party is not necessary.
Yes.
Hence, my lord, now once you hold that it is not necessary,
Yes.
the question of issue notice again for the same defendant.
Stay of
Proceedings in this, tomorrow, it's posted tomorrow for
stay of further proceedings in
OS number.
OS number 256 of 2088 pending in the file of third additional senior civil judge JMFC Polar till next date of grateful.
Till number 6, Chandranath Arigake.
Here for the petitioner.
Yes.
Plaintiff is the petitioner for declaration. Declaration that plaintiff succeeded to the plain schedule property by virtue of a will executed by her mother.
Yes.
That is the prayer. Annexure A is the plain. My lord, the defendant have filed the written statement.
Yes.
That there are other defendants also. That there are other children to the mother. They need to be impleaded. They were impleaded.
Yes.
My lord, later, the defendant number 3
Yes.
filed a written statement and also counterclaim.
Yes.
That is found at page 41. Page 41 is the
No, in the original suit to defendant number 3 is not there.
not there. Subsequently, she
Impleaded.
got impleaded. We had no objection
Yes.
on that. Now, defendant number 3 filed the written statement,
Page.
page 41.
Yes.
Annexure F. Annexure F. This is the written statement.
Yes.
She denied the execution of the will. She raised a counterclaim.
Yes.
My lord, by way of counterclaim, she sought partition, page 45. Page 40, in page 45. She sought partition of this property.
Yes.
My lord, for this, the plaintiff, that is the petitioner, filed a rejoinder. Rejoinder. And later, the petitioner filed an application for amendment. Amendment. That is found at page 53.
Yes.
Amendment that the counterclaim, in the counterclaim, the suit is valued at more than 10 lakhs. By that, the court loses the jurisdiction, counterclaim is not maintainable.
That is what that provision says.
Yes.
Counterclaim cannot be beyond the
Yes.
jurisdiction.
So an application came to be filed.
Yes.
My lord, that is by way of amendment.
Yes.
For that, objection is filed that application came to be rejected by annexure M, page 62. That it is belated. After the plaintiff's evidence, this application is filed. Therefore, it is belated. Fine. that is at page 62.
Yes.
My lord, find the last page, rejection. Paragraph 16.
Yes.
At the page 67. Merely stating page 67, my lord.
Yes.
paragraph 16,
Yes.
That whether the said amendments are necessary at this stage is to be seen. And court says no amendment shall be permitted after the commencement of the trial unless there is a due diligence. My lord, kindly see this word due diligence is insisted. My
Yes,
lord,
that is-
this application of mine came to be rejected. Defendant number 3 files an amendment application that amend my counterclaim.
Yes.
That application, my lord, finds it at page 81.
Yes.
After 3 months, his application is allowed. Court says there is a due diligence. Double standard for the very same, in the very same suit.
Yes.
My application came to be rejected for amendment,
Yes.
and his application, which came to be filed much later.
Yes.
That was on 22/10/2024.
Third issue notice. Stay of further proceedings in OS number 71 of 2015 in the file of Senior Civil Judge ACJM Karkala till next date of hearing.
Cell number 7, Acharya Guru Raja.
Petitioner.
Yes.
The petitioner is the landlord.
Hmm.
The respondent is tenant.
Yes.
The landlord filed a eviction suit against the respondent tenant.
Yes.
The trial court rightly decreed the my suit and directed to vacate the premises within the 3 months. Thereafter, the respondent not vacate the premises, I filed the execution petition.
Yes.
In execution petition, my lord, the
Where is the decree?
decree, your lordship, kindly page number 14. 14, relevant decree,
Order.
your lordship, kindly 45 is the,
Defendant hereby quit and vacate that vacant position within 3 months.
yes, 3 months. Thereafter, my lord, I filed a execution petition.
Yes.
In the execution petition, my lord, he filed a objection along with one application, order 21, rule 2029, stating that this decree is not executable because the reason the other tenant is premises, filed a one scheme suit before the principal court, therefore is not filed. My humble submission is section 92 CPC3 representative capacity. It is against only for the public rights, but the tenancy rights is only individual capacity against the private rights. This basic elementary was not considered.
No,
by the
where is
section.
that order?
Order by not kindly see annexure J, page number 113.
No reasoning.
Reason, my lord, kindly see page number 117, reason, start.
Yes.
He says admittedly, the holder has filed a SC number 1968/2016 against the judgment data for the ejectment and recovery of the arrears of the rent. After the contest of the case, so and so. Thereafter, your lordship kindly see para 7 also. It is no doubt, as could seen from the plain, order sheet OS number 3829/2020, one Kishan Law MC for others have filed a scheme suit under section 92 CPC against the decree holder, herein and other 7, including the so and so. Thereafter, your lordship, the very important reason in the page number 120. Page number 120.
Yes.
Para number 14, my lord.
Yes.
It is true that rightly contended by the decree holder, petitioner, in the statement of objection, the judgmentor is not a party in the suit in so and so. 3829 scheme suit kuda party la. However, the suit is in OS number 3829/2020. Scheme suit was filed by a person or on behalf of the tenant challenging the act done by the dependent 1 to 4, seeking the removal of the dependent 1 to 4 from the trusteeship and appointment of the suitable person as the trustee to the execute the object of the trust created at 1/8/1959.
No, how it is related to that? You are the trustee or a owner of the property?
I am the owner of the property. Earlier, your lordship kindly see the family trust sold to the me on 2005 itself. Thereafter, I find this ejectment suit, he has admitted Compromise also.
No, how that removing of the trustee under 92 petition is applicable to this case?
No way, because he also not a party. Your lordship kindly see para.
Order 21 rule 29. I think there is in that the same party and in respect of the same property.
Kindly covered by decision, this honorable court very clearly says in even section also, order also observed in judgment. Your lordship kindly see. Para 3.
Where is the provision? Extra.
Provision also there, sir. Para 3. Your lordship
Yes.
kindly para 3.
Stay of execution.
To examine the correctness of the impleading order, it is relevant to notice that scope of ambit of the order 21, rule 29, which is read as follows. Your lordship.
Yes.
Next one very important.
Yes. Heard. Issue notice. Next matter, what is that?
Same, another, kindly see the decree, the two tenants I find a common decree, my lord.
Yes. Stay of. What is that you are seeking for? Stay of.
For the page number 113, Eviction J, my lord.
Stay of order dated 31/7/2024 passed by third additional. Which court, Mr.?
You see, actually, a bit. Page number 113.
Third additional
Judge and motor accident.
and
crime tribunal,
ABCD
Bangalore.
Tribunal, Bangalore.
SCH 18, my lord.
Yes. In execution number 304 of 2023 till next date of hearing. Yes, what is that next? Same order.
Same order, but execution number 305, my lord. I do.
Execution petition number 305 of 2023. Yes.
Date, sir.
Serial number 9, MJ Alva for petitioner, N. Sridhar.
Undertake to file wakalat for respond number 4.
Yes.
Lord, your lordship may kindly direct him to serve a copy of, yeah,
Yes,
only
Mr.
petition copy ಕೊಟ್ಟಿದ್ದಾರೆ, annexures ಯಾವುದು ಕೊಡ್ಲಿಲ್ಲ.
Continue.
ಇಲ್ಲ sir, ಕೊಡ್ಲಿಲ್ಲ. Only what I have this. Out of 170 pages, I have got only. ಇಲ್ಲ, ಅವರಿಗೆ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇನಿದೆ.
ನಾನೇ ಕೊಟ್ಟದ್ದು.
But you know, I'll take my notes.
ಇಲ್ಲ, ಇಲ್ಲ.
R4.
No, there are
ಇದರಿಗೆ
4
ನಾನು
respondents.
full set ಕೊಟ್ಟಿದ್ದೀನಿ.
two respondents ಇದೀರಾ?
4 ಜನ ಇದ್ದಾರೆ.
Respondent 1, 2, 3.
1 to 3 ಗೆ ಅವ್ರು ಕೇವಿಟ್ ಹಾಕಿದ್ರು,
Data note.
ಅವರಿಗೆ ನಾನು ಕಾಪಿ ನಿನ್ನೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
ಹ್ಮ್.
ಎಸ್ಟರ್ಡೇ ಸರ್ವ್ ಕಾಪಿ ಫುಲ್ ಸೆಟ್. ಬಹುಶಃ
Now you
ಅವರಿಂದ ನಮ್ಮ
R4
ಸ್ನೇಹಿತರು
minutes.
ಕಾಪಿ ತಗೊಂಡ್ರು ಅಂತ ಕಾಣುತ್ತೆ.
ಅವ್ರಿಗೆ
R4.
It is not that I have not furnished any copy to him.
No, he has not yet entered.
I am
Notice is not
undertaking
yet added. Now you want to take notice.
notice for
You
R4.
serve a copy to him.
Please, I'll permit you to serve the copy to him.
Tuesday, your lordship.
Yes. Now you are appearing for caveator for respondent number
1, 2,
For
3.
4 ಗೆ
1 to
3.
1 to 3. You will take 4.
Yes.
Yes. Caveator undertake to appear for respondent number 1 to 3. Venkatesh undertake to appear for respondent number 4. Learned counsel for the petitioner is directed to serve one set of copies on counsel appearing for R4. Please this matter on
Tuesday, your lordship.
Tomorrow, please.
ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ, ಇವತ್ತು ಕೊಡಿ, ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
Tuesday. Why ನಾಳೆ? Monday.
It is some urgency. Monday ಆಗ್ಬೋದು.
Monday.
ಮಂಡೇ ರಜೆ ಇರ್ಬೇಕು.
Monday ಅಲ್ಲ, Tuesday. 1ನೇ ತಾರೀಕು. First.
First. Tuesday.
Very soon.
Serial number 10, Dhananjaya CP.
Yes.
Suit for partition, your lordship. Petitioner had filed this repetition agreed by the impugned order dated 28/2/2025. Plaintiffs had filed the partition suit on 2019. In 2019, defendant had filed WS. Initially had filed WS where he never says anything about the will, execution of the will.
No, suit for?
Partition.
You have filed in a partition suit.
Yes, your.
Hmm.
In 2019, it doesn't whisper anything about the execution of the will.
Hmm.
In 2021, after he again files additional return statement where he files stating that there is a will executed by late Shivanna.
who is the grandfather of the petitioners. He had executed a will in favor of the defendant. We had also filed, hence we had filed the application stating the, for the scientific examination of the thumb impression of the late Shivanna. And we had also produced the post office SS book, and which has been also marked as exhibit P3.
Yes.
And then in later stage, IA number 8 has been filed by the plaintiffs under section, under order 26 rule 10A for specific scientific examination of the thumb impression. The court below had dismissed the application, rejected the application, Your Lordship, on 28/2/2025.
Where is that application?
Page number
Where is your
29, Your Honor.
application?
Page number 29.
29. Scientific exam thumb impression of the Shivanna. No, they have produced that will.
Yes, Your Honor.
Who has filed this application?
The plaintiffs had filed this application.
Why you have to file application? They have to prove that will. See, that is a burden on them
Yes,
to
they
prove that will. Why do you want to take that handwriting experts, Mr.?
He had produced, he had examined DW2 as a witness. Who is the witness to the, this thing, will. That's why we had filed this application for say, thumb impression and the contents of the signature of the content.
You read reasoning, para 18, the page 18. ಕಂಪರೇಷನ್ ದುರ್ದೇಶದಿಂದ ಅವರು ಸಿಟಿ ಸೂಚಿಸುತ್ತಾರೆ ಅಸಲು ಎಡಗೈ ಹೆಬ್ಬೆರಳು ಗುರುತು ಇರುವ ದಾಖಲೆಗಳನ್ನು ಬಗ್ಗೆ ಅವರು No, that they have to prove that will by examining. Why do you want to see entire burden on that to person who is holding the will to show that if that person witnesses are present or that scribe is there, they have to examine. Otherwise, it is for them to prove. Why do you want to? You can deny that it is not the signature. Then that is burden on them. Why you want?
In the cross-examination also, we had denied the same thing, Your Lord.
Then is burden is there. Where is that issue? Issue is burdening on them to prove that there is a will. Issue is there.
Issue illness.
Then what is that issue framed by the trial court? Why you want that examination of handwriting experts for their will, Mister? You produce that will issue copy. You'll see that. If the burden is on them, then normally it should be on them only. Yes. But the request leaves this matter of 2 weeks.
Bill number 11, T. Sheshagiri Rao for petitioner, Poniraj Kashyap.
Yes.
Might your lord have this on Monday?
Monday.
Yes, I had requested that I will take instructions from. the-
Yes. Yes, leave this matter on Monday. Tuesday. Yes.
I am sorry, put it with you, Monday.
Yes.
Bill number 12, Vinita Thomas petitioner, party in person.
Yes.
this petition, my lords, is arising from an ejectment suit. Suit in OS 2694/2012, suit lacking maintainability and a real cause of action.
You are the
upon,
defendant. Suit for,
Ejectment,
suit for ejectment.
yes.
Yes.
Common order impugned has been passed by the learned trial court. I have annexed it at annexure N on two applications. First application is under order 11, rule 14 and 15, read with section 151 of CPC, and the other one is under order 16, rule 1 and 2, read with section 151 of CPC. For both the orders, a common order impugned, that is annexure N. My lords can come to the grounds taken by the learned trial court. My lords can come to page number 103,
No, that,
para number 11.
Application is filed under order? Order 9, which is that you are challenging? Order, which is that impugned order?
Both the applications I am challenging, in a common order impugned has been passed.
Yes.
First time going with the first application, that is under order 11, rule 14 and 15.
Yes.
Page number 103, para number 11.
103.
On going through para number 11 of the order impugned annexure N.
Yes.
On going through the provision referred above, it clearly shows that if the document sought to be produced is necessary for the adjudication of the issue, then court has to direct the party to produce the same. But in the case on hand, there is no dispute regarding the ownership of the suit premises, and there is no issues framed with regard to ownership of the premises. As ownership of the suit premises and jural relationship has been admitted by both the parties. So here 3 grounds has been taken in short by the learned trial. The first point is my admission at para number 3 of the written statement. Second point is no issues has been framed in OS 2694/2012 with regards to ownership of the property of the plaintiff. And the third point is jural relationship has been admitted by both the parties, that is the first and second defendants. My lord, here I will start from point number 3 and cover 1 and 2. Jural relationship, my lords, my admission, there is an admission made by second defendant, me, who has impleaded in the suit.
Now, where is that your application for production of additional documents?
Production of documents, that is, I have annexed it at
Yes.
annexure. G.
Annexure?
No, sorry, my lords, H, annexure H,
Page?
page number 6.
Yes.
So, here, the jural relationship, the first defendant has neither appeared nor ever filed any written statement in this particular suit. He has filed.
Who is that first defendant?
Is my husband.
Yes.
Okay, so he has filed wakalatnama through certain counsels and then vanished with a common intention to secure a judicial ruling.
Yes.
He has never appeared nor filed any written statement. There is no admission from the first defendant.
Yes.
So there is only one admission was there from me, that is second defendant at para number 3 of the written statement. So the plaintiff is relying on this admission to prove his jural relationship and also his right to sue cause of action.
Where is your written statement?
That is annexure B.
Annexure?
B. I am coming to that because it has been amended. So this particular written statement has been amended by this honorable court in WP number 6885 of 2020 by 25/8/2021. My lords can come to annexure K. Page number 72 and 73, my lords. Para number 9 and 10 read together. So this is a order passed by this honorable court with regards to the amendment.
Yes.
Because my that was a hearsay admission.
Yes.
Which has been amended. And also due to the extensive collusion existing between the plaintiff and first defendant.
Yes.
So para number 9 and 10 read together. In order to demonstrate that there is collusion between first and second respondents, petitioner adverted to a legal notice dated 12/4/2012. The said legal notice has been issued on behalf of the first respondent against petitioners as then calling upon him to deliver vacant possession. The notice is sent from the office of Shekhar and Kumar Associates Advocates. The letterhead of the law office read as follows. Shekhar and Kumar Associates, P. Prasanna Kumar and L. Chandrasekhar Advocates. Petitioner pointed out that.
What is that challenge in that writ petition, madam?
No, this writ petition is actually allowed in my favor for amending my admission. My admission has been amended, so the plaintiff cannot rely on it further.
No, see, first you have admitted that, then you have filed an amendment application.
Yes.
In that, what is your stand?
Because it is actually a collusive case and first plaintiff
No,
is
have
not
you-
the owner.
You have denied that.
Yes, I'm denying.
Where is that? Where is that second amendment which is allowed?
That is Annexure B, my amendment.
You have denied that ownership.
It is actually the first defendant who is contesting, controlling and financing the.
No, it's over, madam. Second, you came on records, then you have denied that he is not an owner. Where is that?
Yes, that is Annexure B, my lords.
Yes.
3A and 3B.
Para number?
3A and 3B.
Yes.
So, this honorable court's order, I'm
Call
just reading
absolute
out,
owner of
so
the
that there
suit
is
to
a pollution also existing.
Yes.
Petitioner pointed out that that I'm reading it from that
Out.
WP.
Issue notice.
Pointed out that one of the
Stay
associates.
of further proceedings in OS number 26942 of 2012. Pending in the file of. No, that, when that order has been passed by the trial court, madam?
This order has been passed by 8/7/2019.
Then you
So
take,
after 2022 only, the issues has been framed. After
take
amendment,
notice, yes.
additional issues has been framed in the suit.
Yes, you take notice. Yes, issue notice.
My lords, kindly stay the further.
No, 2019 order, madam. Yes.
My lords, there is I will just, because it is a collusive case, it is a first defendant who is contesting, controlling and financing the.
No,
entire
your
suit.
application has been dismissed in the year 2019.
Yes, my lords.
And now you are coming before the court. You take
Because
notice.
I
Yes.
will not be able to question it before the 2022, because my lords can come to the annexure.
When did you come on record?
No, I'll just,
No,
one point.
You have filed an application for additional documents after you have been impleaded, is it not?
Yes, they have, the learned trial court has.
Yes, you
passed
take notice,
additional
madam. Yes, you take notice.
Issues number
Number 13.
6 and 7.
Yes, you take notice, yes.
My lords,
But
kindly give a.
No, stay, madam. It is already 5 years back order, yes.
But issues has been framed in 2022, my.
No, you have come to the court after 5 years. I can't entertain, madam. Yes.
My lords, kindly one small point.
Yes.
Additional issue number 7. It is questioning the plaintiffs whether the plaintiff proves that he is the owner of the scheduled property and entitled for the relief of eviction of defendant number 2 from the suit premises. I am staying in the shared household. So that my husband, in standing in the shoe of the plaintiff, he is evicting. So eviction is being used as a tool to defeat the purpose of DVR.
No,
my
we are
lords.
not on that. We have concern with that order which you have challenged. It has been passed in the year 2019.
Yes, it is passed in the year
Yes,
2019.
yes, you
But
take
in the
notice.
year 2019, I'm not, because additional issues has not been framed. The additional issues has been framed in the year 2022, my lord.
Yes. No,
So that
see,
is why I'm happy.
your case is that you want to produce the document to show that he is not a owner.
Yes, I will just read out one more point
Yes.
that
No, you-
plaintiff, just one small point.
When
The
that
plaintiff-
additional issue has been framed.
Additional issue is framed on 5/3/2022. After that, Order 7 Rule 11, it was Order 7 Rule 11, the learned trial court's arguments like observations, I'll read it out. Because the only document now the plaintiff is relying on is Exhibit P1. This document is not a genuine or authentic document, my lords.
No, where is that issue?
That is Annexure L, my lords, page number 81. There are two issues.
Page number?
Issue 6 and whether questioning the maintainability and
Where is
also
that?
ownership.
Where is that issue number?
Number 81.
81.
Yes, and
81.
Annexure L, page
Yes.
81, additional issue number 6.
Hmm.
Whether the defendant number 2 proves that plaintiff has filed this suit colluding with the defendant number 1 with a common intention to evict the defendant number 2 and suit is not maintainable. Here, the additional issue questioning the maintainability due to the collusion between plaintiff and owners lies with the second defendant. To prove the collusion, a summoning first defendant becomes necessary for cross-examining DW1. Here, DW1 was being not cross-examined. And additional issue number 7, whether plaintiff proves that he is the owner of the CH-12 property and entitled for the relief of eviction of defendant number 2 from the premises. So here, questioning the ownership of the property of the plaintiff because he has not proved the ownership, neither he proved the jural relationship with any genuine or authentic document. For that, my lords has to come to the next annexure M. That is the order passed in Order 7 Rule 11A of CPC. The learned trial court has stated, because this is the only document in existence which is used by the plaintiff to prove his jural relationship and the ownership of the property, because in an ejectment suit, it is a settled
Here filed by the defendant is hereby allowed in part. Yes.
Page number 88, my lords. Page number 88, para number 30. In this regard, 11 to note that exhibit P1 is a rental agreement. On the reverse of the first page.
Now, where you are reading?
P1.
Para?
Para number 13, my lord.
Yes.
Page 88.
Yes.
13. On the reverse of the first page of exhibit P1, there is a certificate by the Deputy Commissioner stamps and the district registrar which disclose that tenant Praveen Kumar B has paid the deficit stamp duty on the rental agreement. Said Praveen Kumar B happens to be the defendant number 1. Exhibit P1 implies the document provided by the plaintiff. Defendant number 1 paying the deficit duty and penalty of the plaintiff's document obviously implies the collusive nature of plaintiff and defendant number 1. Coming to para number 40.
Now,
page
what has
89.
happened that your application is allowed? What is that final order, madam?
Which final order?
Now that you are reading now, page 90.
No, partly it was allowed. That's
Partly
all.
means what?
It was a mistake of law. It was partly allowed, Order 7 Rule 11. So I'm reading out the observation, page
No,
number
partly
89.
means whether suit is dismissed or what is that?
No, it is still continuing.
Then what is that allowed means, which is the part of that order has been allowed?
Maintainability is not there against me. That is the defendant number 2. The maintainability is not prima facie. I will read out the last ending paragraph. That is page 91. In the other verse, whether certain acts of the defendant number 1 prima facie set course of action appears to be collusive and illusory. As such, suit against defendant number 2 is found not maintainable.
Yes.
So here, again, page 89, this is one of the most important.
Tenant is subject to the
paragraph. I want
TMC
to
Act,
read
the
it out.
examination of the material record, it is not a cause of action agitated by the plaintiff.
Page number 89,
Not a proper and genuine one. Yes.
para 14.
Hmm.
In this regard, the order of the Honorable High Court of Karnataka passed in Expedition number 6885 of 2020 in para number 10 has observed these facts lead to an irresistible inference that the same law firm has acted on behalf of the petitioner's husband and also against him. These observations are based on comparison of the address of the advocates representing the plaintiff hearing and the defendant number 1 in MC proceedings. Therefore, going to be noted, my lords, it is noticed that the interest of the plaintiff and defendant number 1 is not real and rival in nature. Defendant number 2 herein is impleaded during the pendency of the suit. Even defendant number 1 has not cross-examined PW1. My lords can come to the next page, page number 80, para number 60. Whereas in this proceedings, it is noticed that the obligation of the plaintiff to pay the deficit duty on the documentary evidence is paid by the defendant number 1. Thereby, point to be noted, my lords. The collusive nature between the plaintiff and defendant number 1 has eclipsed the genuineness of the rental agreement. In the other words, defendant number 1 paying the duty and penalty of the document of the plaintiff has in other way accepted the liability of providing proper residence to the defendant number 2. Because defendant number 1 has paid the deficit duty and penalty on the document of the plaintiff at that point of time, defendant number 2 as on record. So from this, it is very clear, my lords, that the plaintiff is relying only on this particular document. Which is also part of the plaintiff.
No, what is the documents you want to produce?
No, I'm relying on the document, that is, my lords can come to annexure D. That is a document filed by the plaintiff. He is relying only on this document to prove his jural relationship, at the same time to prove his cause of action. That is page number 46 and 47. My lords can see this document is a document which has been relied on with the pleadings that also
No,
constitute
your case is that this is created for only purpose of
filing the
eviction.
suit. by, that too, by the first defendant, and in my lords can see,
Yes,
page
our-
47.
Issue notice, stay of further proceedings in OS number 2694 of 2012 pending in the file of City Civil and Session Judge Nehal, Bangalore till next date of hearing.
My lords, the next date.
Next date will come after service. Yes.
Serial number 13, Prakash T. Abbar for petitioner,
Specific date.
V.N. Shankaraya.
First you take notice to the other side.
My lords, hand summons to councils because the parties are not.
You pay the process,
Huh.
notice will be sent through the court, madam. Yes.
Acha.
Serial number 13,
Yes, Mr. Prakash.
Lord, I appear for the petition. Lord, the plaintiff's writ petition, my lord.
Hmm.
The suit is for declaration of title and for injunction.
Yes.
Lord, my title is based on the two grant certificates, exhibit P1 and P2,
Suit for?
suit for declaration and permanent injunction.
Yes.
Lord, the defendant is the adjacent site holder,
Hmm.
who is lying on the, whose property is lying on the eastern side of my property.
Yes.
Lord, they're apprehending that there is an encroachment.
Hmm.
My lord, of course, the honorable trial court dismissed my suit, and in the appeal, Lord, the encroachment was noticed, and accordingly,
Hmm.
an application for appointment of the court commissioner was appointed, was filed. Lord, that was resisted by the defendant, my lord. The honorable appellate court, my lord, dismissed my application.
Hmm.
On two grounds, my lord. The one is that we have not produced the sketch,
No, it is filed before that first appellate court.
first appellate.
What has happened to the suit?
Suit, my lord, that came to be dismissed, my lord. There is a challenge, my lord, in the appeal. And in the appeal, my lord, this application came to be filed.
They have filed that application.
Pardon?
No, application is filed by whom?
Application is filed by the plaintiff, that is
Plaintiff.
myself.
Hmm?
Yes, my lord.
Yes.
That came to be rejected, my lord, on three grounds.
Hmm.
One is that we have not produced the sketch showing the location of the property.
Yes.
And the second one is that we have not described
Hmm.
that the defendant's property is abutting our property. This is incorrect, I will point out. And that we have not stated that there is an overlapping over the suit property.
Hmm.
Lord, there is no dispute with regard to the property of the plaintiff as well as the defendant. But that is not in dispute. The only thing is that his site, Lord, measures for 40.
Yes, you are appearing for whom, mister?
I am for the defendant, my lord, the respondent.
No,
My
you are
lord,
taking notice to all.
I will get instructions, my lord.
Yes, you take notice. You are now K-waiter for whom? Yes.
Yeah, David.
K-waiter is undertake to appear for respondent number 2. Issue emergent notice to 1, 3 and 4. Yes. Take notice, let us.
Pardon?
You take notice.
Lord, argument stage, my lord, there.
No, that order has been passed 1 year back, mister. Yes.
Lord,
Yes, yes, yes.
state, Lord, the only further proceedings. my
No,
lord.
no, mister. Yes.
But in the meanwhile, if it is decreed, my lord, there is.
No, you waited for 1 year. You wait for till disposal of that RE.
Serial
Yes.
number 14, Gangireddy BV for petitioner, connected matter, Rachita Nanaya M.
Yes. Yes, mister.
That this is a fiction filed by the husband against the wife. But here. the
Suit for?
Family court, my lord.
Hmm.
The husband, is a petition filed. Petition under Gordon Watts Act
Hmm.
for custody of his 3 children, minor children.
Hmm.
And respondent of her appearance.
Hmm.
Filed IA number
9 and 10.
Hmm.
So, what's that? 9 is for,
Yes.
1 minute. I number 9 and 10.
Hmm.
I number 9 and 10 for maintenance. But here, the learned judge, my lord, on 2 petitions. I
Where
have
is that
also
order?
filed- I have also put another petition
Hmm.
for conjugal rights. On both the cases, clubbed together, a common is passed on 3 IAs.
Hmm.
That is IA number 5.
Hmm.
In, that is, IA number 5.
Hmm.
In, MC number 5299 of 21.
Hmm.
And IA number, that is, in respect of WP number 16856.
No.
Question that, order.
For what purpose IS are filed? First explain me.
But the
IA number 5 is for what?
This is, first case is concerned law.
ಎಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ವಾ?
Common number.
You tell me that what is that IA number 5?
This WP number 2563.
Hmm.
2563 is concerned IA number 9 and 10.
9 and 10.
9 and 10.
Hmm.
IA number 9.
Hmm.
IA number 9 and 10 in Guardian Watts Act 5 of 22 for medical expenses and maintenance of 30 maintenance.
ಆಯ್ತು, ಎಲ್ಲಿದೆ IA ಎಲ್ಲಿದೆ ಹೇಳಿ? IA 9.
IA 9.
Please to order.
Page number 36.
The children.
Page number 36, 3 children there are.
30?
36, page number 36, my lord.
In which matter, Mr.? 20563.
20563,
Where is that first IA 9?
I9, filed by the page number 36.
Page 36, my lord. Direct the petitioner to pay a school fee of 3 children, namely Kumari Abigail studying in 5th standard, Kumari Kaira studying in 1st standard, both of them studying in Bishop Cotton Girls School, of rupees 1,60,000.
No, ಅದೇ ಮಕ್ಕಳದು education fees.
ಅದು ಕೇಳಿದೆ.
What is that in another IA?
Another IA.
Number
Not
10.
entry matter.
For maintenance. For entry maintenance.
Yes. What is wrong in that, Mister? Now you come to that order.
Yes. A common order is possible.
Where is that reasoning of the trial court?
Reason starts from.
Para
2.
Para 14.
14. The respondent in her affidavit of assets and liabilities declared that she is housewife and she has no independent income, source of income. The petition did not disclose the said fact. The petition in this affidavit of assets and liabilities, at column number J, referred to the income of respondents as 4,25,730. It is I stated claiming that it is the information revealed by the respondent in her IT returns from the assessment year 2022-23. She herself filed a returns, my lord, that returns papers in the trial court. So our income rupees 4,25,000.
Read. Yes.
Amen. Then, but the petitioner failed to produce the said IT returns. The respondent in her affidavit of assets and liabilities, call number F, declared that she is not income tax assessee. Absolutely, there is nothing on record to hold that the respondent is having independent source of income for maintenance of herself and the 3 children. Though the petitioner claims that respondent is leading adulterous life, it is a point to be considered by adjudicating the main matter. Since it is application filed by section 36 of Divorce Act, the point for consideration is whether respondent is entitled for the relief sought for in the application or not. The fact that the respondent is housewife and all the 3 children are under the care and custody of the respondent is not in dispute. Under such circumstances, it is the bounden duty of the petitioner to maintain his wife and children. MC number 680 of 253 and 5 of 22 are other 2 cases pending between the parties. Further, this is the petition filed by the petitioner of section 32 of Divorce Act, read with section 22 of Social Marriage Act for restitution of conjugal rights. The petition continued that he is pursuing his higher education at present. He is depending upon parents for his needs. He has no independent source of income and thereby express his inability to maintain his wife and children. The petition being the father of the three children, bound to meet their expenses towards the maintenance, education, medical, and others. He is also bound to maintain his wife and children, providing them with their basic needs, and they entitled to lead their life in par with this standard of living. Though the respondent tried that petition is having a handsome earning, she failed to disclose the same in her affidavit.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? Now everything is admitted. Now that what is that directions which has been directed? Petitioner hereby directed to
Lordship may
8,000 each per month for a
67.
maintenance of wife.
ಇದು
3 children become.
ಡಬಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ಗೆಲ್ಲ. IA number 5 filed the respondent in MC number so and so, that is restitution case ಅಲ್ಲಿ. And IA number 10 filed under section Garden Watts Act so and so. ಇದ್ರ ಮೇಲೆ petitioner is hereby directed to pay rupees 8,000 each per month for the maintenance of his wife and 3 children, which becomes 32,000 per month from the date of IA number 5 filed in MC number 5299/21 till the disposal of the respective cases. ಅದು ಒಂದಾಯ್ತು. ಆಮೇಲೆ the petitioner is in addition to that, my lord, the petitioner is required to meet the entire educational, medical and other expenses of all the 3 children apart from paying maintenance. So I have to pay the educational expenses, medical expenses, everything, in addition to the 32,000 rupees.
No, 25,000 for the education. You can't deny because they have produced the documents for education and all. Now, only thing is that 8,000 for wife, whether that 8,000 each for the 3 children, you have to be considered.
ಆಮೇಲೆ ಅದು ಹೇಳ್ತೀನಿ. Then petition is required to pay rupees 25,000 rupees each towards one-time litigation expenses in MC number 5299 and Garden Works number 5 of 22. Each case I required to pay for 25,000 rupees as a litigation one-time expenses. ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ then IA number 9 in Garden Works case number 5 of 22 is allowed. The petition is directed to make payment towards education expenses of the 2 children, and which the respondent has already incurred from the academic year 22 till the disposal of the both petitions in MC number so and so.
Now, Mr. Counsel, you have to pay that education expenses.
But education expenses are right to the state, my lord. He is now paying education expenses. Every fee he is paying from right beginning. He is paying. Every year he is paying nearly 1.5 lakh. Now 2 lakhs he is paying. Education, the whole the school fees, everything he is paying from his pocket.
Now, you go and pay that whatever there in that school education.
At present, he has not paid.
Paying.
When the court ordered, directed him, he paid for 1 year, 2023 and 2022-23. And after that, he has not paid you. We requested many times before the trial court. He has not paid. The 3 children, and the second, the only has paid 2 daughters, education expense. Third child, he has not paid.
No, that payment of education expenses is concerned, you have to pay. Now, litigation expenses is concerned, we will see. Now that
both the
25,000
that we'll see.
for each case.
We'll see when the matter is finally heard. Now that direction to pay that 32,000 per month, what is that petitioner is doing?
But he was a pastor at the time of marriage.
He was
Pastor.
Church
In the
pastor.
church in the Vellore. Now he is in Bangalore. But he has no work
no,
now.
according to that, your income tax returns.
No. One thing, one submission, this is a very important. She herself filed the income tax returns papers in the ಯಾವ case in the 2 cases. Her income is ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Documents are also I produced.
ಯಾರ್ದು?
ಅವರದ್ದು lady, wife ಕೊಟ್ಟಿದ್ದಾರೆ. Your lordship may kindly see.
She is an housewife, that's it, they said.
She said housewife. Your lordship may kindly see her own
Statement.
statement annexure G4. Annexure at page 40, my lord. At page 40. 4,25,730. Next page. For the year 21-22, 4,30,770. Right, next, my lord. 2021.
ಎಲ್ಲಿದೆ ಅದು? That is not forthcoming in this order, Mr. Yes, Mr. She is an income tax.
No, at present,
That's the wrong income, the alleged judge has not considered this aspect of the matter while passing the order.
No, that you pay monthly maintenance.
At present, she has no income here. At the time of filing of application, she has no income. Before that, there was a giant account that some amount, she, for the payment of school fee, to purchase the groceries, she has sold her car. There was a car with her, so she has sold that car. That some income, 1,60,000 has come to her account. So immediately she has purchased the grass for rupees
Out of
60,000.
32. Now you pay that 20,000. And regarding that all education fee for academic year, for litigation purpose is concerned, we'll see.
Even at presently, even due is there. Now their 3 children have completed this academic year. There is a due.
What is the due?
Due is for the academic year 24-25 euro.
No, academic year, there is a direction I am not going to stay.
Yes.
That will be there.
Whatever
I
that.
will say only in respect of that litigation expenses that we'll see.
Yes.
Then I will modify it at present till the disposal. Instead of 32, let him pay 8,000 to that wife. Then another 12,000. ಅಂತ ಅಂದ್ರೆ 3 ಜನ.
3 ಜನ children.
4,000 each for 12,000, 20,000 at present. Then we'll hear that matter.
Yes.
Yes.
He's unemployed. As on today, he's unemployed. He's borrowing money from his father. His
No.
father was a retired teacher.
No, nothing forthcoming in this judgment saying that you are unemployed. You are saying that,
But I have paid, I stated my.
no, there is a finding that you are paying an income tax.
No, I am not paying income tax.
Now, who's that?
This is the income tax returns filed by the other side, not by us.
Asset liability refer to that income tax respondent
Oh, that's
payment
right.
to be so on. So what is that you have filed an affidavit for asset and liability?
None, ಏನಿಲ್ಲ ಅಂತ ಹೇಳಿ 5,000 rupees income ಅಂತ ಹೇಳಿ.
You are not getting any this thing.
No.
What is that material to show that he has an income, Mr.?
No, this is the he's saying that he doesn't have any income here. But
then-
there are 3 children. Then and also
That maintenance has to be paid to the status of that
yes.
parties. On that income, it is that if you prove that he has sufficient income, then maintenance will be more. If that income is not there, how can you see that? Whatever that maintenance he can be given according to his income only. You can't compare that income of that each person's same. Now that unless if he shows that
He's having a
20,000 plus, even if you take that monthly 20,000 he has to pay and his expenses for 10,000, he should have earning 30,000 per month. What is that to show that he has earning 30,000?
he is having earnings.
ಏನಿದೆ ಕೊಡಿ, that is what that you have to show, whether he is working, he has any documents, he has produced nothing, but you have produced that income tax return.
That before 2021, 20 and 21, that is income, that amount that she has sold the car, so that income has come, and there is a giant account with the mother, that income shows. But she is personally, she is not having a.
Now you forget about that her. Now what is that income he is having? What is that material to show
That
that he is?
he is saying that he doesn't have any income.
But you have to show that if he is don't have that.
There is a bounded duty of the father to take care of the children. And
ಎಲ್ಲರೂ ಅವ್ರವ್ರ ಕೆಪಾಸಿಟಿಗೆ ಅವ್ರವ್ರ ಮಕ್ಕಳನ್ನ ನೋಡ್ಕೊಳ್ಬೇಕು. You can't compare everyone to see that. ಅವ್ರ ಇನ್ಕಮಿಗೆ ಅವ್ರ ಮಕ್ಕಳನ್ನ ಮಕ್ಕಳು ನೋಡ್ಕೊಳ್ಬೇಕು. It is his duty. ಹೌದು, ಅವ್ರ ಇನ್ಕಮಿಗೆ ಎಷ್ಟಿದೆ ಅಷ್ಟು ಆ ಮಟ್ಟದಲ್ಲಿ ಮಕ್ಕಳು ನೋಡ್ಕೋಬೇಕು. Is it not?
till dispute arises, he has admitted to the Bishop Cotton School 2 children, and he had paid school fee till that time. When they are started to live separate.
That income, Mr., when you are paying all this in last academic year and all. Now you are saying that I'm,
Unemployed.
Huh?
Unemployed. My father is a retired teacher. He is helping me for my maintenance and maintenance of.
You
the
are not
children.
working anywhere.
At present, I am just finished the higher education, Your Lordship.
What is your age, mister?
Your Lordship, I was a pastor in the church. I was doing job. Of the dispute, when the dispute started, before that I left my job and.
Now you pay that the 20,000 plus
Your Lordship.
education. Other we will see that.
Compliant. 20,000 is exorbitant.
No, I thought that he is
My lord,
40 years.
Last occasion also the court considered is the income and law. 12,000 rupees increment they are ordered with this.
Where is that?
Earlier occasion, there is an order. My lord.
Where is
An
that?
order.
Where is that earlier occasion?
Interim order.
Interim order.
Interim order ಆಗಿದೆಯಾ ಇದ್ರಲ್ಲಿ?
ಆಗಿದೆ.
ಮತ್ತೆ ಏನಕ್ಕೆ ಇವತ್ತು ಬಂದಿರೋದು?
26 ಅಲ್ಲಿ.
ಏನಕ್ಕೆ ಬಂದಿದ್ದಾರೆ?
ಒಂದರಲ್ಲಾಗಿದೆ.
Preliminary hearing ಒಂದಿರಿಗೆ ಬರುತ್ತೆ. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಎಲ್ಲರಿಗೂ? ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ? ಈ ಗ್ರೂಪಿಗೆ ಬರ್ಬೇಕಾಗತ್ತೆ. No, there is already an order. Matter has to be heard finally. Why it is posted today? It has to be posted in, I thought that first time.
At least let him pay all the children's school fee or whatever the dues are there.
No,
Can
that-
directly pay
no,
to the.
This court
We have paid the school fee.
granted an interim order in respect of the school fee. What is
It's kept silent, it's kept silent about that school fee.
And he has income of 4,000 per month where the petitioner is not earning. Facts and so on. So continue to pay 12,000 per month for a fifth of every succeeding month. The petitioner paid 12,000 for so on. So Learned Counsel purpose have to take out that notice for every month interim granted by this court vacate, stay stands vacated without that interference. Court to pay all these three children with the maintenance amount of 32,000 per month. No, this only maintenance.
Yes, school fee regarding school fee.
He's paying. He's paying for next academic year, may also he is going to pay the school fee.
Yes.
Necessary order is required, Your Honor. For that.
No, according to you, has he paid?
No, Adi, 2 years before he has paid, after that he has not paid.
Now, when is that he has to be paid, mister? As that academic year started?
2024-25 is also due. And next academic year also has to be paid.
Academic year will start from that March, June. Now
May,
it's going to end.
May, June. Yes, Your Honor.
Now that May.
He is yet to pay and previous year also due is there.
Previous year he has not
He has
paid.
not paid. He has not paid. Then there is no, he has not paid you.
You get that endorsement from the school that he has not paid.
Yeah,
He's asking
I
for
have
the
filed application before the trial courts, he can direction to pay. He has not paid you.
serial number history.
Yes, 23-24 he has paid.
According to my client's instruction, he has paid. The last year.
Show me that document to show that he has paid. Then actually being written for the middle. First, ಯಾವ್ದು ಅದ್ಯಾವ್ದು ಇದ ಅದ್ರಲ್ಲಿ ಏನಿದೆ? No, what is this for? This is for GMFC battery. GMEL. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ ರೀ. ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ? GMFC ಬೇಡ, GM ಕೊಡಿ ನನಗೆ. CPC 2065. ಇದರಲ್ಲಿ ಏನು ಚಲೋ ಮಾಡ್ತಾರೆ?
Right, yes.
No, that
Last year he had not paid, that he will pay, and also he will pay the
subsequent year.
next academic year.
Academic year. No, that the writ petition is in that WP 20563. What is that application? Which is that application under 20563?
Only for either.
That is education.
Study of the children.
20?
That is 20563, IA number 10 euro.
IA number 10.
IA number 9 and 10. IA number 9 for payment of school fee. Payment of school fee. That time it was arrears was there.
10?
IA number 10. 10 for entry maintenance.
Entry maintenance.
9 and 10 for, I number 9 for.
That's, you will take notice in this, this also you have taken notice.
Yes, I have appeared, I have filed wakalat also.
Yes. Akilva. Yes. Yes, you pay that last year and this year.
Yes, yes, definitely we will.
Last year means 23, 24.
Yes.
24 and 25, 26.
It has to become
Yes,
26,
Yet to
24,
become.
25 has to become.
Yes,
yes.
Yes.
That is the school. fees,
and
sir.
maintenance.
Adu kudi idರಲ್ಲಿ James.
Right, apart from the paying.
Burnett Council appearing for the petitioner submitted that idu WP 16826 of 2024. ಎರಡನೇ matter. Submitted that. Petitioner will
One
pay.
submission, one submission. Now, we required to pay 20,000, 2,20,000 rupees per month, per year, school fee. So, my lord, it's 2,20,000 rupees per year. In addition to that, my lord, he required to pay another 20,000 rupees as a maintenance.
No, maintenance, there is already an order.
Yes.
We are not concerned this.
Your
That is, FC matter has been tagged with this. Here, in this case, only in respect of the academic
Yes,
fees of the student.
that I will pay.
That interim order granted earlier will be extended. Subject to that, we have to pay that examination fee. Then that 12,000 has to be paid regularly.
Here, my one submission. He was a pastor of the church. He's have some deduction from the school fee, or not there, entirely is not going to
No,
pay.
not past-
Some
not-
deduction will be there in you. That is Bishop Cotton School. So he was the pastor. So he is having some
ಆಯ್ತು ಬಿಡಿ ಒಳ್ಳೇದಾಯ್ತಲ್ಲ ನಿಮಗೇನ
but maintenance to pay every 12,000 is not sufficient for 3 children to maintain.
Mister, this has been passed an order long back. If you want, you file an application for vacating. Today it is posted that other matter which has posted today, not for that. Yes. Submitted that. Where is that order here? As per that impugn order dated 20th April 2024. The petitioner has to pay educational expenses of 2 children.
3 children. 2 daughters and 1 son.
Yes, education expenses of the 3 children for the academic year 23-24.
24 and 25.
Right? 23-24. That he will pay. And he is also undertake that.
23, 20.
That education expenses of the 3 children for the year academic year 24-25 also.
This one.
The submission of the learned counsel for the petitioner is taken on record. The petitioner is directed to pay that educational expenses of the 3 children.
2 children.
As per the directions of this court for the academic year 23, 24 and 25-25.
23-24 up to only 2 children, not 3. From 23-24 in the, 23-24 in the, from 23-24, he required to pay school fee for 3 children.
That's what that I am telling, only 23-24.
For the
24, 25 still has to come.
He is a minor. He said to join in the school.
No, I already joined. He 24.
Mister, you said 23-24.
Yeah, you
He has to pay 23-24. That's what that I said. 23.
not for 3 children, you are only for 2 children.
No, now that he is become
Now that he is admitting one more child, 24-25 that I have to pay.
24 and 25.
25.
Yes, I has agreed to pay medical, the education expenses of the 2 children for the academic year 23-24.
For 2 children,
And 23-25, 24-25, you will pay education expenses of 3 children. Undertaking is submission of that learned counsel for the petitioner is taken on record. The petitioner is directed to pay the education expenses of the two children for the academic year 23-24, and he is also directed to pay education expenses of the three children for the academic year 24-25.
And 25-26 next, 24, yes. One more thing, Your
You
20,
want that this has to be pending even for
no, no,
24,
one
25.
submission,
First
24,
let them
24,
condition, the interim order granted by this court in earlier is extended.
24, 25, she has already paid for this son. He has not paid 94,000. That amount he has to, he can repay to her, Your. We can direct him to whatever the, she reimburse that amount.
If that,
She has paid, Your.
if that education expenses, education fee,
Of
if
son.
it is already paid by that respondent wife, the petitioner is directed to reimburse the same to that respondent. Yes.
Admission matter, serial number 15, Anuparna Bordolai for petitioner.
Yes.
For petitioner. Well, it's here, there is an order
Your,
which was passed by.
previous order, one submission, Your. We can timely, direct him to pay within some time, Your. Time limitation.
No, academic year, when that is necessary, he has to pay, Mr. If it is not paid, you can move that court, yes. You have to intimate what is the date which has to be paid in the school, then you will has to pay that.
Time is already over previous year, Your Honor.
That's
Adu
what-
pay money immediately has to pay. Otherwise, they will not give admission to the for coming academic year.
For academic 23-24 is directed to pay forthwith. Yes.
ಈಗ 25 next academic year 25-26 start ಆಗುತ್ತೆ ಇವರು. ಅದು
Start
coming.
ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ ಅದು. First ಎಲ್ಲಿ admission ಆದ್ಮೇಲೆ then you have to pass on to them, then you will pay that. Yes.
ಅದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್
Yes. Yes. What is it?
Lords, there is an order which was passed on 10th March 2025, my lords. Thereby, the notice was dispensed because to the defendants on the ground that it was only for expeditious hearing of IA under guideline 1 and 2, my lords. What was not disclosed that there is a batch of matters, connected matters. The list is here, my lords, and those matters.
Yeah, filed by the petitioner under order 39 pending in the file of so and so. Respondent suit injunction along with that plaint so and so, injunction so and so. Hence, the learned counsel praised the early disposal. In view of the above, trial court is directed to dispose of IA before the end of April 2025. Yes.
Lords, what was not disclosed that there is a batch of matters. Along with this, there are 8 other matters which were divided into went to two different courts. Initially, interim order was granted by the allotted court as well as in charge court. Thereafter, the matter got divided. The 4 matters got to one court and 3 matters went to another court. Thereafter, we have filed a civil miscellaneous before the court, and the civil miscellaneous is pending on December 30th. We have filed a civil miscellaneous to club all the 8 matters. The notice was served to them. They are appearing before that court, and on last hearing in this very same matter, they have appeared in their presence, arguments were heard, and the court have passed an order prior to this order saying that civil miscellaneous is pending. Please bring all the matters together and in order to avoid divergent finding, and we'll adjourn the matter. The civil miscellaneous was filed in December. Notice was issued to them.
No, is it that all matters arising out of that same?
See, my lord, between the same parties, same.
No.
Wait. No,
That is the reason we have filed.
no, first, see, all suits has been filed by for what?
My lord, what has happened? It is a lease. Lease was granted. We are query lease owner. They are the owners of the property. There was a rental agreement entered into between the parties. This is adjacent to each other. What had happened after receiving the first year rent, they started interfering with the possession of the property. And based on this lease agreement, we have entered into various query leases and things like that, my lords. Now they started interfering with the possession. We went to the civil court and we got an expedited injunction order. And thereafter, my lords, the matter has been heard by the same one court, in charge court, and the same court. Thereafter, because the new court came in and the matters got divided. Therefore, December 2024, we filed a civil miscellaneous to bring all the matters to.
No, see, which are the suits filed by you?
Please, my lord, the list I have given. OS number. My lord, list I just handed over.
Where is that?
Here, here.
Yes.
My lord, the first three matters
Hmm.
before principal civil judge,
Hmm.
JMFC, OS 721 of 2023, 723 of 2023,
Hmm.
725 of 2023.
Filed by?
Filed by Vinay Kumar, BC versus BC Ramay.
No, that is your client.
My client.
Yes, you have filed in a suit for what?
Suit for injunction. Permanent injunction, restraining them from interfering with peaceful possession.
Yes.
On the
What?
same, and then another set of matters, which is OS 720 of 2023, 722 of 2023, 724 and 726.
Hmm.
The ex parte interim order was granted on the same day on all these four matters with all the 7 matters because it was coming before the same court. And the cause of action arose also on the same day. Therefore, all the matters were filed on the same day. Orders were also passed on the same
No,
day.
all these cases is filed by whom?
All these 5 cases were filed by 2 individuals, my lord. One is Vinay Kumar, one is N. Krishna. The respondents are nothing but the family members interstate.
No, this is
There is a
7.
separate lease deed that is a rental agreement that got executed, my lord.
No, this 724.
Please, my lord.
724 is filed by that owner.
No, petition.
My lord,
Good.
filed by
The lessee.
lessee.
My lord, my lord, all these suits are filed by lessee.
Hmm.
My lord, there is an unregistered lease deed. The lease has expired.
Yes.
My lord, these Vinay Kumar, watch me kindly see in the list 721.
Yes.
Vinay Kumar.
Hmm.
He is the leasehold person. Watch me kindly see the defendants, Ramay and others.
Hmm.
Then another suit, Vinay Kumar versus Lakshmi kindly see the defendants,
Hmm.
Ningama and others. Next suit, Vinay Kumar versus
Owner has not filed any case.
owner has not filed.
All that.
And when it is a suit for injunction, the nature of alleged interference is something different. And therefore, it is not a suit for declaration. It is not suit for a partition, for clubbing.
I'm just asking that. No,
The tenants has filed this suit,
724 suit is filed by you.
not by me, by
The
the
tenant has filed.
review petitioners.
No,
The
that.
tenants have filed
Hmm.
against the landowner. All the tenants.
Yes.
ಅಲ್ಲ ಓನರ್ ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿಲ್ಲ ಓನರ್ ಯಾವ್ದು ಮಾಡಿಲ್ಲ
No, 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 I'm asking that. 724 is filed by you. Yes. You are the tenant. You have filed a suit for injunction. Hmm.
Ex parte interim order was granted.
Hmm.
Thereafter, my lord, all these 3 matters, all these 7 matters were filed together.
Hmm.
And on the same day, ex parte interim
Oh,
order.
you are the defendant.
Yes, ma'am.
For application for vacating is not considered.
Not considered. Objection to IA number 1.
Not decided. Now, my lords, all these matters initially was before one court. We were arguing before one court. Thereafter, what happened? The in charge court got accommodated and all the matters came before the 2 different courts. So what we did is we filed with the consent
No,
of the other
madam.
side.
See, you have taken an injunction against to him in this one case. This is between you and him. Supreme Court said within 30 days, ex
Yes.
parte order has to be
39.
decided. Otherwise, the court become.
Just I will pass in the
Yes.
judgment of the
You can't do
apex
it, madam.
court.
You, just because you are pending in that other case, you can't say that this, no, that I will vacate that injunction order. You club it and do it.
Yes, madam.
I thought that, see, you have obtained that injunction order against that party. When he has filed before the court, filed an objection, it is the duty of the court to decide within 30 days. That's what Supreme Court said.
Let it April only, my
No,
lord.
no, we are not concerned with that. This application is filed, court has to decide within 30 days. I said direction to madam has to consider in accordance.
With kind permission, Lord. Lordship may kindly.
Which law says that
I know that.
injunction has to be granted? There are so many other connected matters, therefore it cannot be decided. No, let him pass any order on application saying that I can't vacate that injunction order because other case is there. When they are appeared, they have filed an objection, he has to pass a speaking order that why I want to continue that order. He cannot go on extending. Madam, ex parte is without the hearing other side. When they are appeared, let him pass any order. It is not that it is, he can pass an order saying that because of this reason, I want to continue that, but he can't pending.
That was not brought. before.
ಒಂದು ವರ್ಷಗಳ ನಂತರ ಟ್ರಾನ್ಸ್ಫರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು.
Where is that order on your order 39 rule 1 and 2?
Not passed.
Kindly see, this is passed on 10th March.
Yes.
They appeared before the court and they argued. And
If it is order is passed, then it become.
ಅಲ್ಲಲ್ಲ, only expired temporary injunction was granted. Expired temporary injunction.
the court at page 19. Page 19, this is the order. 24th of February 2025. This order is challenge my lords. In the presence, this order is.
Page number?
Number 19, my lords. Memo file CI extended to the deputy for 20 furnished CIS copies of OS number 751 and 12 further also furnished CIS number civil miscellaneous number which is pending before honorable principal district and session.
Petition.
Above civil miscellaneous for clubbing of 20 to avoid diversion findings and order the court and furnish the above said documents construct competent involved for pending of civil miscellaneous petition and to avoid.
No,
diversion.
madam,
How
it is clubbing for passing in a final degree.
Yes.
That
Not for
doesn't
it.
mean to say that ex parte injunction order can be continued.
Not to hear interlocutory applications.
In April, I have no difficulty. What I'm saying is, my lord, let it be heard by one court instead of.
No, that is for the court. No, injunction is against that individual.
Yes.
Whether he is interfering, if you make out in a case, so and so in your suit is interfering, what will grant?
The nature of interference is something
The
different.
Interference of this A, he is similar to that in other suit is B, Mr.
Family members, my condition.
Maybe
It's
no,
not,
no, no.
I thought that
It is not so.
partition suits,
No, no.
if
Yes.
all are having interest.
If that is the case, we conclude, my lords. Our only difficulty was that the diversion finding will come.
No, how can
Let it
injunction
come.
order, that cannot be.
We will
different
face it
part.
if the divergent opinions come. Appeal is one can file an appeal if there is divergent opinion is
Yes.
there. Well, with kind permission, Lord may kindly allow the review petition and pass the same order. Otherwise, tomorrow they may not take
I
up.
will dismiss this review petition. It cannot be, yes.
Or my.
There is only a direction has been given that. Yes, review petition is filed.
My lord, instead of dismissing, I may be permitted to withdraw before that.
Yes. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this review petition. Memo is taken on record. The review petition is dismissed as withdrawn. Yes.
My lord, all contentions left open. my lord.
All the contentions of the parties are left off. It is always there, madam.
Please.
Yes. Okay.
My lord, similar order for all the other connected.
Yes, all matters has been same order.
Please.
We file a memo, we'll, yes,
Pending application.
all pending applications are disposed of.
Office objection, first time matter, serial number 20, Pawan Shamye.
Serial number 20 minutes.
Yes.
There was some urgency minutes. We moved the matter.
That office objection. Advocate welfare stamp, annexure details, nature of the petition. You comply office objection, you
Lords,
pass it out.
it was filed in the morning. Yesterday, it was filed in the morning, my lords, and moved. So therefore, because of the memo was there, they did not give us a,
Yes, you comply it, I will pass it over.
please,
Yes.
great.
If it is complied, I will take after pass over.
Serial
Yes.
number 21, Kumara KG.
Petitioner, my lords. Lords, office objection is, my lords, the petitioner is in custody, my lords. We have filed on, my lords, memo of appearance. That is the office objection.
Verification affidavit, IA detail.
Memo of fact shall hakidivi. That is the, my lord, office objections.
Part is to be specified with respect to that subsequent order. Verifying affidavit and the wakalat of the petitioner to be filed.
He's in
What is that verifying and wakalat?
My
What
lords,
is the
he's-
procedure, mister?
He's
You
in
have to take,
He's in custody, my lords. We have
then
filed.
you
on-
have to take a permission from the this thing. That
this
criminal case you permitted, not that civil, mister.
Lords, because in civil imprisonment, my lords. He's
No,
in civil.
therefore, you have to go there from jail superintendent, the permission has to be taken. That may be the procedure. I don't know that.
ಅಲ್ಲಿ affidavit ಹಾಕಕ್ಕಾಗಲ್ಲ.
Civil, I don't think civil court you can appear without that wakalat, mister. Criminal you can that.
But my lords, in the, we are challenging the order of my lords civil imprisonment because in custody, my lords.
No,
And that's
therefore
where-
I am asking that what is the law? You are the council, you are there to assist, mister.
My lords, I am submitting, my lords. I can file memo of appearance based on my lords memo of
In the
fact.
civil, in the civil matter, you can file it, show me that which is that law, then I will permit you. Just can't
RS.
Throw that arguments, Mr. You are a counsel when you are assisting.
Usually,
You
my
should
lords,
be an
what,
author.
my lords, usually what we'll do, my lords, in the parole matters and all, my lords, same thing we'll do. But my lords, in the GMCPC, my lords,
The civil petition, you just find out. Show me that authority it can be, I will entertain. Otherwise, what is that options available for you? You have to do it. Civil petition, you find out that what is the procedure.
please, please.
Yes. Where do you want?
Second, my lords.
Second, yes.
Till number 22, cashier for petitioner.
Yes.
My
Yes,
lords,
madam.
2 days time may be given,
Yes.
we'll comply.
At the
My
request.
lords, the date may be fixed. There's an urgency in this matter.
Yes, 2 days time is granted to comply office objection. Leave this matter on third.
Obliged.
Till number 23, Suryansh Naidu A.
My lordship, there's very small office objections, my lord. If my lord may permit to hear this matter.
And age proof of the petitioner copy to be stitched. IA to be paginated properly. Yes, why IA has not paginated
My lord,
properly?
yesterday only we could actually
Yes, what
got
is
the
this? Yes.
corrections done. If my lord may have the matters heard, my lord, this is an important matter. We'll do, my lord, in the course of the day.
Yes.
Yes, ma'am. My lord, in this matter, this is a matter between the nephew and the uncle, my lord. Nephew is residing in Germany, having renounced the world, my lord.
Now suit for?
Suit for declarations for cancellation of the gift deed and release deed, my lord.
Yes.
My lord, the trial court, having not appreciated both the applications, we went to the first appellate court, my lord. In the first appellate court, one of our IA, which was allowed, my lord, appreciating the entire facts and circumstances, the third party interest creations was prohibited, my lord, now. But the enjoyment of the suit properties, which admittedly, both the parties admit that 29th of April 2016, my lord,
Yes.
this gift deed, which is in challenge, has been passed. If my lord would see the reasons given by this order, which we have in challenge, my lord, kindly see, my lord, I'll read out the relevant para, my lord, 173 page, if my lord would see. This petitioner is the plaintiff, my lord.
173.
My lord,
Yes.
my lord, para 20. If my lord would see, since because there is cloud on the
Now,
title.
what is
the
that application you have filed, Mr.?
Complications, my lord, this plaintiff has issued.
You have filed in 39, 1 and 2.
Yes, my lord, for peaceful enjoyment of the property, my lord.
Now, what has happened before that trial court?
My lord, trial court straight away rejected, my lord.
Then you, in the
Then
first
we-
appellate court is also
we-
confirmed.
No, my lord. We filed 2 applications because there was in the trial court also it was both the applications. It was a common order. In the appellate court, my lord, one of our applications was granted whereby the third party interest was not to be created. It was a directions to the respondent, my lord. My lord, during this period, my lord, this particular petitioner was enjoying the fruits of the coconut tree, my lord. The sugarcane was also being produced. It was a huge land, my lord. He had an intentions to create an ashram in this property, my lord. That entire fact has been admitted. What is the contentions, my lord? The defendant says that it was a consent, that he consented to this transfer. My lord, there are emails which clearly says, inter se emails, which says that he has given it for the purpose of selling it out for establishing an ashram. That is there, my lord. That is an admitted fact. My lord, the position is that in the gift deed itself, it says that on this very day, I am transferring my possession and peaceful enjoyment to the defendant. Now, my lord, the lower appellate court, what, my lord?
Who has gifted that property?
There's this petitioner, my lord.
You have gifted that property.
Yes, my lord. But under a fraud, my lord, what happens?
You are disputing that gifting.
Yes, my lord, because it is already there. He is under the fiduciary capacity, my lord. He is the uncle. The defendant is the uncle. Now that transfer of the property by way of gift is admitted to the extent that it was for the purpose of selling those properties, which was because it was on the basis of a family settlement. This petitioner got these properties, my lord. Both in B and C scheduled properties was jointly owned. A scheduled property was completely owned by the petitioner.
C is your self-acquired property.
B and C is the joint owned property, my lord. A is not self-acquired, but in the family partition, it is on the defendant's admitted position that it is in his name, the petitioner's name. So, yes, my lord, plaintiff's name, my lord.
Yeah.
The issue is on the A scheduled property, the gift deed has been made. On B and C scheduled property, release deed has been made, my lord. Now, considering these questions, my lord, The trial court has already issued notice,
He's,
my lord.
he is your brother.
No, my lord, uncle.
Your
My lord,
uncle.
his father has been died by Veerappan, my lord, while he was posted as a police officer, my lord.
Who's,
The petitioners, the plaintiff's father. My lord.
yes.
My lord, now the reasoning given why we have challenged, my lord, if you are not see,
No, you are seeking declaration for both gift deed as well as.
both, my lord,
Yes.
both. Now, having appreciated in one of our applications that yes, this is a tribal issue, immediately there are email exchange where it is admitted by the defendant that he was to sell this property for establishing an ashram, but for running by this plaintiff, my lord. That is admitted position in the emails. Now, subsequent to that, even at the stage of appellate forum, my lord, court admits that there is a tribal issues and third party interest has been restricted, my lord. Now, while giving reasons in our these applications, if my lord would see only two paras, my lord. It says since because there is a cloud on the
Which paragraph?
my lord, para 2173.
Yes.
Since there is a cloud.
Para?
21. 20, my lord. Para 20.
20, yes.
173.
Yes.
Since because there is a cloud on the title of the plaintiff over the suit schedule property and genuineness or otherwise of the gift deed and release date dated so and so is disputed. At this stage, the plaintiff is not entitled for the relief temporary injunction. My lord, this is wrong, my lord. On the facts of it, it is wrong because there is no cloud on the title of the plaintiff's property. Because both of them admits that because the title was with the plaintiff, it has been given to the defendant by way of
If they are
the.
given a gift, you will lose the title, mister.
My lord, that has been in challenge.
No, that is what has to be decided now.
That's right, my lord. For that, the notice has been issued. Now, my lord, kindly see the second, which is again, my lord, wrong. That is para 22,
Yes.
page 174.
Yes.
However, from the materials on record, one thing is clear that the plaintiff has not produced prima facie material to show that he is in possession of the property on the date of the suit. My lord, to this, my lord, kindly see the gift deed, my lord. That is, my lord. That is page 45, my lord. Annexure B. The possession has been admitted by both the parties, my lord, if you honor would see page 49.
Yes.
Page 49, my lord, it says that, and whereas, my lord, may I read? Subsequent to the aforesaid partition,
No,
donor,
page
who is the
49.
plaintiff? My lord, it's 49.
49 from where you are reading?
Yeah, at the very
46.
first para, my lord, whereas.
Whereas, yes.
Yes, my lord. Subsequent to the aforesaid partition, partition has been admitted by the defendant, my lord. The donor has been in absolute possession and in enjoyment of the suit scheduled property as its absolute owner, and revenue records in respect of the scheduled property stands transferred in the name of the donor. Donor is the present plaintiff, my lord. And the donor has been paying taxes and all. My lord, kindly see the next. Now this deed gives witnesses. Just on the 5 lines down, my lord.
Yes.
The donor has this day delivered vacant possession of the same unto and in favor of the donee to have and to hold. My lord, it is the donors and donees both case that on 29th of April 2016 only it has gone to the defendant's hands, my lord. Now the trial court, my lord, the appellate court to hold that he hasn't been able to make out any case that he was having a possessions. Well, that is questionable.
No. See, court has to decide the day you have filed in a suit.
Yes, ma'am.
Admittedly, you are not in the position. Therefore, injunction cannot be granted. That is what they can't go beyond that. Only for injunction, when you have filed in a suit, you are not in the position because you are yourself has gifted that property by a gift deed.
Yes, ma'am.
There is a clause saying that donor has delivered that vacant position to the donor.
Yes, my lord.
It is presumption that you are not in the position.
My lord, see the entire emails, my lord. That's the last I would like, my lord, to see 35, my lord.
No, all that will not taken over, Mr. When there is a registered this thing.
No, my lord, this has been appreciated while granting me an injunction in respect to creating third party rights, my lord.
No. Therefore, position is with the respondent. Respondent has been restrained to not to create third party interest. That is correct.
Yes, ma'am.
To restrain them, how can it be? When you have seek that he is in the possession, he cannot be alienated. How can you say that he can be restrained from?
No, my lord, it is not in I'm sorry, my lord. It is not in respect to those properties, which is he is in possession. In these properties, where in constructive possessions, my lord, why? First, the A scheduled property has never been in the possession of the defendants. The B and C scheduled property were joint properties, my lord. In that properties, he has.
For seeking that injunction
In
in
respect
respect of A scheduled property.
No, my lord. Also, B and C scheduled properties where the petitioner, this petitioners has those coconut trees and also, my lord, the.
See, through this gift, which is the property which has been donated.
That is, my lord, A scheduled properties.
Scheduled
Yes.
property. What
That,
about,
that status quo has been given in the other applications, my lord.
what about B and C?
B and C, my lord, that is a joint owned property.
No,
Some part he is
no,
in
they are
possession.
claiming on the basis of what defendants? Is there any another gifted?
No, my lord, there's no. My lord, position is A scheduled property is clear. So that is why the gift deed is there. The B and C scheduled properties, that in some of the lands, he has his house, the defendant. And the other areas where he had his own cultivated land and the other areas where this petitioner has the rights, my lord, there another person on the basis of an GPA, my lord, was carrying out the cultivations. Mr.
Now you are seeking only in respect of the A scheduled property.
No, my lord. A scheduled property has been, the stay has been, status quo has been given, my lord. My lord, by way of the other application which has been granted. My lord, kindly see page 152. It starts with 152.
152.
Yes, my lord. On the operative part, I would read, my lord. See, my lord, page 160. Para 15 onwards, my lord.
Yes.
My lord. Now it might clear that A scheduled property was given. Perhaps my lord would have this through this A and B clarity, my lord.
Yes.
A scheduled property given to the share of the plaintiff.
18.
Yes, no, my lord, 15. It starts with 15.
Yes.
My lord, now it might clear that plaintiff A scheduled property was given to the share of the plaintiff and B and C scheduled properties were allotted to share of Puttagowda who was died intestate. That is the father of the petitioner as well as the defendant, my lord.
Yes.
That's the grandfather of the petitioner. It is very appropriate to note that the plaintiff had already lodged complaint against the defendant to the police by sale or otherwise to anybody till disposal of the suit on merits.
Where is that status quo? Status quo, you said that there is a status quo in respect of possession where only restrain it not to alienate, that's all.
Yes, my lord. I was just reading out that, my lord, as
That
far
is
as.
your contention.
Yes, my lord. Since the
See,
25th
trial court has rejected
Yes, my lord.
that IA is set aside,
Yes, my lord.
IA is allowed, injunction has been granted not to alienate
Alienate,
that
my lord.
property.
My lord.
Next,
My lord, my submission.
39 rule 1 on to another application,
Yes, my lord.
not to interfere, that has been rejected.
Yes, my lord. This interferences is only in respect to the enjoyment of the property. Why, my lord? This property produces an yearly revenue of almost 25 lakhs, my lord, through sugar cane. It's
Yes.
such a huge properties. And there are also
Now
coconut
you
trees.
maintain status quo, let us. Yes.
Yes, my lord.
Or issue notice. Parties are directed to maintain status quo in respect of petition scheduled property till next date of it. Yes, submission is accepted. Office of, you pagination, you correct it. Yes.
Yes, my
In the
lord.
meantime, directed to comply office.
Cell number 24.
My lord, may I
Remitted
just-
Maheshaya
My lord, may I have the order?
Yes. Yes.
for petitioner, Sri Harsha.
Appearing for petitioner, my lord. Lord, office subjection, my lord.
Hmm.
Copy of the memorandum of appeal in MEI 2/24 to be filed. File ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ ಅದು. Kindly see the.
Having served a copy, ಕೇವೇಟರಿ copy.
ಮಾಡಿದೆ, ಅದನ್ನು ಮಾಡಿದೆ ಸ್ವಾಮಿ.
Who is ಕೇವೇಟರ್?
My lord, party in person. Who is respondent number 2, my lord.
Yes.
But in this case, my lord,
Hmm.
suit for partition, my lord.
Hmm.
Present petitioners are defendant number 1, 2, 3, my lord. Lord,
Yes.
my lord, the respondent herein, my lord, filed suit for partition against the present petitioner and other 9 persons, my lord. The partition between the parties has been taken place 50 years before, my lord. Now they have filed a suit for partition. I am not going on merits of the suit, my lord.
Yes.
My lord, during the pendency of the suit, my lord, the trial court granted interim order, my lord, in favor of the present respondent and order 39 rule 1 and 2, my lord.
Hmm.
Thereafter, my lord, for the some business transaction between the present petitioner with some other persons, my lord, during the COVID period, my lord, for the purpose of surety, my lord, they have executed one deed in favor of the some other person, my lord.
Hmm.
Thereafter, present respondent, my lord, initiated proceedings under order 39 rule 2A, my lord.
Yes.
For the disobedience of the court order, my lord. That proceedings came to be rejected by the trial court, my lord. Thereafter, the present respondent filed appeal, my lord, in MEA 2/24, my lord.
Hmm.
In that proceedings, my lord, MEA came to be allowed, my lord, and directed the trial court to take action against the present petitioners, my lord. My lord, kindly come to the page number 84, annexure H, my lord. This is actual cause, my lord. The trial court considered all the facts, my lord.
Hmm. Where is
Detail,
that
my lord.
order?
Kindly come to the page number 79, para number 12, my lord.
79.
Yes, my lord. Para 12, my lord. As discussed, supra, the petitioners are not only have to prove the alienation, but also prove the aspect that the alienation
What is
was.
that application he has filed?
My lord, order 39, rule 2A, my lord. Which is,
Violation of this order.
yes, my lord.
Hmm.
My lord, this is page number, my lord, 65, annexure E, my lord.
Hmm.
Based on that application, my lord, the trial court registered CMS proceedings, my lord, and passed an order, my lord, by dismissing the application of the.
39 rule 1 and 2 hereby rejected. Yes.
Yes, my lord. Thereafter filed MEA, my lord. In MEA, my lord, the petitioners could not appear before the MEA court, my lord. In expert order passed by the MEA court, my lord, direct the trial court to take action against the present petitioner, my lord.
Where is that order, MA court?
My lord, MEA court is annexure E, my lord.
Page?
My lord, page number, my lord, 9, my lord.
Yes, what is that?
Operative portion 17, my lord.
Hospital is allowed, the trial court is directed to take necessary action. Yes, where is that party is not there? Yes. Or issue notice. Stay of
MEA portion.
dated 25/6/2024, passed by second additional district and session judge in MEA number 2 of 2024 till next date of it.
Much.
Yes. Office of the-
Lord, I have complained, my lord.
Yes, submission is accepted of submission. Yes.
Please, much.
Office objection, second time matter, serial number 25, Bhargav G.
Your lordship's suit for recovery of possession.
Yes.
This is the defendant's petition, your lordship.
Yes.
Your lordships, at the time of chief evidence of the plaintiff, exhibit P1 to P37 were marked. Suit for recovery of possession.
You are the plaintiff.
I'm the defendant, your lordships.
Yes. Yes.
Exhibit P1 to P37 were marked. And the plaintiff herein also filed two other documents which are sale deeds of the year 1918, 1918, and 1949. Two sale deeds were produced before the court. Since those documents were unregistered and unstamped, court marked those documents under O series as O1 and O2. And after that, we preferred a writ petition, your lordships.
Yes.
Against that order, we preferred a writ petition 62962 of 2016. In that, this honorable court directed the trial court to decide the issue pertaining to admissibility of the document, pass a suitable order.
Yes.
And the learned trial court judge passed an order wherein he held that the such documents could not be marked for the reason that both are unstamped and unregistered. Against that order, the plaintiff herein again filed a writ petition before this honorable court. And this honorable court held that since the plaintiff is a Maharaja, there's no need for him to register or pay stamp duty with respect to the documents. And
Where is that order you are challenging?
I'm not challenging that order also, your lordship. That order, if I may bring your lordship's attention to page number 79. Page number 79 of the petition.
Yes.
The relevant, your lordships, relevant page is at 90.
Yes.
In the outer limit of, in the above circumstances, this writ petition is favored. The impugned order is set at naught. The trial court shall admit the subject documents in evidence. Since suit is of the year 2002, the court below shall try and dispose of the same within a outer limit of 1 year and report compliance to the Registrar General of this court. It is needless to mention that now that the subject documents have been held admissible in evidence, it is open to the respondent to lead further evidence either by further examining or further cross-examining any witnesses or by producing any document as may be required for the due adjudication of the list.
Yes.
After this order, your lordships, the trial court passed the matter, listed the matter for chief examination of the PW1.
Yes.
I have, may submit the order sheet, the entire order. May I bring your lordship's attention to page 227, ink page number 227.
Yes.
227, Adesha. On 15/10/2019, Adesha, ಮಧ್ಯಂತರ ಅರ್ಜಿ ಸಂಖ್ಯೆ 58 ಮತ್ತು 59 ಪುರಸ್ಕರಿಸಲಾಗಿದೆ.
What is that Madhyantara Arji?
With respect to evidence, your lordship, chief examination of defendant. ಅದಾದ ನಂತರ ಮೂಲಕರ್ತ ಮೂಲವಾದಿಯನ್ನು ಸಾಕ್ಷಿ ಪಟ್ಟಿಗೆ ಪ್ರವೇಶಿಸುವಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ. This is with respect to plaintiff.
Yes.
And at 226, your lordships, 14/10/2019, 226, same page. In the High Court of, page number 226, in the High Court of Karnataka.
Order admale, they have been permitted to.
We've been permitted.
reopen the-
But even to this day, we have not cross-examined your lordships.
Who?
We haven't cross-examined PW1. PW1 and court directed that the O series document has to be marked as exhibit P38 and P39. While marking the documents also, witness did not enter the witness box. He did not enter the box and the documents were marked in his absence. And after that, the court ought to have given us an opportunity to cross-examine the witness, but no opportunity was given. And your lordships, we have challenged that in the impugned order, which is at Annexure A. Annexure A, page number 25 of the petition, your lordship. Ink page 25.
Yes.
Memo with affidavit filed by the learned counsel for the defendant is hereby allowed. The order dated 13/8/2021 passed on IA number 68 is hereby reviewed. Page number 25, your lordships, of the petition.
Order portion.
Order portion. Memo with affidavit filed by the learned counsel for the defendant is hereby allowed. The order dated 13/8/2021 passed on IA number 68 is hereby reviewed in view of the order of the Honorable High Court of Karnataka dated so-and-so passed in WP number so-and-so as follows. IA number 68 filed by the plaintiff under section 151 of the Code of Civil Procedure is hereby allowed. Exhibit O1 and Exhibit O2 are marked as Exhibit P38 and P39 respectively. While passing this order, your lordship, we were not given an opportunity to cross-examine the plaintiff hearing. Instead, the matter was directly posted for the straightaway posted for arguments, final arguments.
Yes.
My only grievance is that I should be given an opportunity to cross-examine him. And your lordships, I have seriously disputed the existence of those unregistered and unstamped sale deeds. I've even challenged the probative value of those documents. To elicit the truth of the about the documents, I have to cross-examine him, your lordships.
Yes. Where is that rejection?
This is the rejection.
No, that he has been permitted, that's all.
He has been permitted, and after that, a document has been straight away marked as P38 and P39. I have not been given an opportunity, your lordship.
You have not filed any application.
They filed the application, they withdraw.
One moment, I'll complete, your lordships. I had filed I had filed an application to cross-examine PW2, but later I realized that without marking the documents in accordance with law, without entering the witness box, documents could not be marked. Now that the documents have been marked, I cannot cross-examine him. I went to the root of the case, your lordship. For those reasons, I withdrew the application for cross-examining. Besides that, the court cannot circumvent the entire procedure. Once the documents have been marked, I should be given opportunity.
When you have filed an application for cross-examination?
Blood application was filed, memo was filed on 14/3/2025, withdrawing the application, seeking permission to cross-examine.
Where is that order?
That we are producing the order. This is a matter, my lord, where 5 lakh cost was imposed on the last occasion for abusing the process. Application 21 years, my lord, that dragged the proceedings. My lord, kindly see the applications at page number 56 and 63. These documents are marked, they were cross-examined.
What is that suit for?
Eviction? Suit is filed for eviction. Now he claims to be a tenant. He's a rank trespasser because his father was a GPA holder. He died and he continued to be in possession of that Maharaja's family, and that he claims to be a tenant. 23 years he dragged the proceedings. The latest application is 90 and 91. What has happened is, I'll simplify. These two documents we produced for before the court for marking. The trial court marked is at subject objection O1 and
court
O2.
has clarified that it need not be registered and all.
Yes. Now O1 and O2 it was marked. Then they filed an application. You give a ruling whether they can be admissible in evidence or not. The trial court said it cannot be admissible in evidence. Then we came before this honorable court. This honorable court said they have to be marked. They went to Supreme Court. Supreme Court dismissed the petition. Therefore, all that the civil judge and these in the meanwhile on O1 and O2, which was exhibit P30, elaborately was cross-examined. PW1 and P2 was elaborately cross-examined on these two documents when he was alive. Now, all that the trial court has done is converting O1 and O2 as P38 and P39. That's all because the Alva High Court said it cast mark. They wanted to cross-examine on this aspect. They filed the application at page number 56 and 63 to cross-examine the witness. Kindly submit the prayer 61, 58, I'm sorry, 58.
I have it.
58. This was filed in March 2000, before filing of the writ petition. For his reasons stated in the accompanying bit, the counsel for the defendant most humbly prays that this honorable pleased to recall the plaintiff and permit the cross-examination of PW2, and the same may be allowed in the interest of justice and equity. The next IA may kindly be seen, that is at page number 61.
Yes.
For the reasons stated in the accompanying affidavit, the counsel for the defendant most so-and-so, please to recall the order dated 16/1/2017 and reopen the stage for cross-examination of the PW2, and the same may be allowed in the interest of justice and equity. Then they filed a memo at page number 64, withdrawing both applications. Now, suppressing this fact, they filed the writ petition before this honorable court.
No, see, now the option is.
No, these documents are already marked because of the order passed by this honorable court.
You have to file an application for reopening under Order 18, Rule 17. If the court dismissed, then you can come here.
No, they have withdrawn the application.
One second.
These two documents were marked.
Without any order, you can see if your law is permitted, you file it. The trial court, after seeing that earlier is dismissed, if it is dismissed, then you can come to that court. There is no order, you have not filed.
Your lordships, one moment. In 2019, court observes the fact that I have to cross-examine PW1. So the matter was posted for.
PW1 is dead. PW1 is dead now.
No, Mr. Counsel. once evidence is closed.
Evidence was not closed. That's what I'm saying. Evidence was not.
Evidence of PW
Close,
is
close,
closed.
close.
ಇಲ್ಲ,
Full
evidence close
cross-examination
ಮಾಡಿಲ್ಲ.
was matter of
I
posted.
pointed out.
But
your
I
lordship,
really do not
at
know
page
why
number
such submissions
227,
are-
at
But
page number
kindly see,
227, I
he was
pointed out.
fully cross-examined. Page number 6 will kindly be seen, page number 6 of my list of dates, with the documents. My list of documents.
Your lordship, that is of the year 2019.
Only
Even
1 second, sir.
2017.
Only 1 second. I beg you. Page number 4, defendant has filed his affidavit, PW1 further examined, O1 and O2 exhibit P17 are marked for cross-examination of PW1. Kindly similar the next page, that is page number 6. PW1 further cross-examined in full.
No.
For-
That is before this court is granting.
Exactly, your lord.
Now, after that, you have marked the document.
No. What the trial court has done is, it has given effect to the order of this court that instead of O1 and O2, it has to be marked as a P38 and 39 because this document
No,
was
court also
elaborately
said-
cross-examined. It was cross-examined. Kindly see the cross-examination on this O1 and O2.
You see that order passed by
No,
this.
50, no, that is if I produce other document, if I produce any other witness. Kindly see page 52, my lord.
No,
If
you
I
see that-
produce any other witness,
Yes.
they can cross-examine. I am not producing any other witness. They are not producing any other witness to lead further evidence. The cross-examination arises if I produce any other witness. So far as
mention that
PW1 is
after the
concerned, is
subject
completely
document has been
cross-examined.
Held admissible in this evidence. See, this is only related to these documents.
Yes,
It
yes.
is needless to mention that now that the subject documents have been held admissible in this evidence, it is open for the respondent to lead further evidence either by examination or further examination or that further cross-examination of any witnesses or by producing any document as he may. He can examine any witness.
From my side, I have no further evidence. I have no further
For him,
It is
he-
for-
No. Let him lead evidence. Let him lead evidence for any.
also given cross-examination.
No, cross-examination of the witness if I produce any witness. Now the PW1 is dead now.
See,
PW1 is dead.
now after this marking,
Yes,
what is that order sheet says? Is it evidence is closed? Where is that?
no, after marking this, it was marked as O1 and O2. Then this the trial court said there's not inadmissible in evidence. We came with this
No,
on court.
after this court has directed, then document has been marked.
As PW, instead of O1 and O2, it is marked as P38 and 39. That's all. I have not produced any other witness for leading evidence. He has not produced anything. Now he filed application for permission to cross-examine. He withdraw.
No,
And that is
see,
suppressed
only
now.
thing is that you have to file an application
Your
to
lordship.
permission to cross-examine. If court pass any order, then you have to come before this.
No,
court.
your
There is
lordship-
No order has
No,
been passed.
what I'm saying is that the stage was still open. The stage has not been closed. The issue of filing an application would arise if had the stage been closed. Stage had not been closed at all.
So what is this application you have filed?
I have filed an application, I
Reopen.
filed a memo, your lordships.
To
Appli-
reopen and
I had filed the application for reopen of, to cross-examine only PW2, not PW1, because PW1 was not alive at that point of time. And I withdrew it because the documents in essence were not marked at all. And besides, your lordship, they take the benefit of the order passed by coordinate bench of this honorable court. While one portion is respected, I don't know how they can blow both hot and cold at the same time.
Now you are showing that, where is that any order of refusal?
No, I'm saying that the opportunity has not been, your lordship.
Where is that
Yes,
order
yes, I'll
says that
show,
you have
I'll show.
been
I'll
refused
show
to
your
do it?
lordships.
Where is that?
no, what he has challenged is entirely different. He has not challenged the refusal.
One moment.
That order,
But impugned order is
honorable court-
marking these two documents as exhibit P38 and
21st.
39 as per.
that he
Can I-
is challenging.
Kindly similar page number 19. Page number 19 may kindly be similar. Page number-
Wait. Now you are seeking quashing of annexure A.
Yes, my lord.
This has been done pursuant to
Yes.
the directions of
Page,
this.
page
Yes,
number,
that is
page number
exactly what I-
315, your lordships. Page number 315 of the order sheet.
No, what is that prior you are sought, mister? See that.
Marking of this document, page 25.
You are-
Page
I've
25.
sought for review of the order concerning marking of the documents itself. Now that the documents have been marked, automatically the stage should have been for evidence of cross-examination of PW1 is what I'm saying. Instead, at page number 315, your lordships, 315 of the order sheet.
No, mister, you are filing a writ petition challenging that annexure A.
Yes, your lordship.
What is that annexure A?
Annexure
A-
with respect to marking of the documents. Now that your lordships, subsequent, in the same order, what has happened is, court goes on to direct to mark the documents as P38 and 39. And after that, the next stage should have been for cross-examination of PW1. Instead, it says for arguments. I'm challenging for that part of the
So they
order.
filed the application of the withdraw.
See, that deems to show that his evidence has been closed. You file an application for reopening.
But they filed the application that they withdrawn.
No, there is no bar for him to file a second application.
Operates as a-
If they file, let them pass an order, then.
No,
we
no,
go
no,
to-
now he cannot file because after withdrawing the memo, my lord,
No,
any
that
the
we
reason
can
is this.
argue that.
Lord,
As
kindly-
on today,
kindly see,
there is
my
no
lord.
order before me to quash.
This writ petition is not maintainable for the simple reason that P38
Here,
and 39.
Sought quashing that order dated 13/8/2021. This is marking in terms of the directions of
Yes,
this
yes,
court.
Yes, but I
Therefore,
am
this
only
court-
concerned, your lordship, if I may bring your lordship's attention to page number 351. One moment, your
No,
351.
that is
Sorry,
not the
315.
primary or shortest, mister.
Your
I
lordship,
can't
all that
find-
I'm saying is,
Tomorrow you can say that degree suit here itself without seeking that.
I have to cross-examine, the stage is still open, that's what I'm
23
saying. The
years
stage has not been
that
closed.
On the
closed,
last
your lordship.
occasion, 5 lakh rupees cost was imposed. They
No,
paid
you see
23
your
years.
prayer. You see that your prayer, you want, I will give you a finding and reject it. You see that prayer, what you sought. Now that your case is that court has not permitted, you have to file an application after that court finding and given a finding that you are not entitled, then I can examine.
Your lordship, the issue is, no, the issue is that document market, no, the primary issue is that the marking of the documents itself is wrong because
Why you are all arguing, you are challenging that. You don't know how that writ petition has to be filed, what is has to be.
no, all
challenged.
that I'm saying, the marking of the document itself is wrong, your lordship. That's why I'm before.
That is the.
That if there is any order, you challenge it, I will examine that. What is not there, you have to be asked. to
Or your
examine.
lordship permit me to file an application.
That is, if
with-
law permits, you do it, mister. Is this writ petition, you have sought the directions, that is the
But
direction.
your, my right to cross-examine should not be taken away, your lordship. That's
I
the-
have not closed it all. You have to work out how you have to be get it, mister. For that only they are engaging the council. You are asking me that.
No, I understand, I understand.
It whatever.
Or let there be an observation, your
No,
lordship,
my lord.
because there's a possibility of misconstruing the order entirely by the trial court.
Come me and argue there also. You have to be argued and what that, mister? Nowadays, all advocates are, see, you have to work out, you have to convince the court, not that you have to be asked here. You go and convince, if the court is passed an order against you, if you find that you have a merit, come before that, convince us, then we'll see that. See, I have not seen that you are seeking that order which is as per the
No,
direction.
I'm only challenging the part where it says for arguments, your lordship.
Yes. In this writ petition, defendant called in question, order dated 21/11/2024, passed by 31 additional city civil and session judge in OS number 1963 of 2002, whereby, as per the directions of this court, the permitted the plaintiff to mark that document as exhibit 01 and 02.
No. O1, O2.
Yes, one other.
O-
Yes, O1
Now
and O2.
P38, 39.
Since the permission has been granted to mark the documents pursuant to that order passed by this court in WP number 35358 of 2017. That order is attained finality. Therefore,
But they are marked as P38 and 39. They are now marked as 38 and 39 pursuant to the order of this. court.
well, yes, it has been marked as exhibit P38 and 39. Therefore, there is no error or illegalities in the impugn order annexure A. Hence, writ petition is devoid of merit accordingly. Dismissed. If file necessary application, then take an order, then we'll, yes.
Serial number 43, here for the petitioner's counsel.
Serial number? Which one?
43. Tomorrow I have a matter at the Apex Court, so I'm not available. in there.
43, yes. When do you want?
Anytime in the
Yes,
2
who is
weeks.
other side? Second or third? Second week of April.
second week of April,
Second, huh?
8th or 9th.
Eighth.
I'm leaving to.
Yes, you have any objection for adjournment? Let us see.
The Apex Court to go back. I have to leave today, that's why.
Today.
Tomorrow is the
No,
matter.
but
is fixed.
your
Matter is listed tomorrow.
She is objecting for that.
Allah, from 2 years we have an interim order.
Yes.
Today there is the urgency.
No, passed over when it will reach. Now he is asking for adjournment. You have any adjournment? Let us see when the matter is called. He has an objection.
Allah, I will not be there. That is why I'm saying.
Let us see, your colleague will be there. Yes. Now there are an objection.
Allah, for 2 years there is the matters. There has been an interim order.
I can adjourn the matter if both the parties agreed. When there is a vacation, then one of your colleague has been objected. I can't refuse that. We'll see when the matter is called. When the matter is called, it is my discretion. Yes.
31, my lord.
Yes.
Taken up on Monday or Tuesday, my lord.
30?
38, no.
38.
Yeah.
You are appearing for
Petition, my lord.
petitioner.
It's up to them.
Yes, at the request of petitioner, use this matter next week.
31, my lord. Other side is also.
105. 105, my lord.
Date will be from there. 3rd or 4th. my lord.
Yes, now what is that, this thing not pressing IA to dispense with production of certificate copy 3 for production
38, my lord.
38. What are the IA, Mr.?
35, my lord. 35, my lord.
Then which matter, Mr.? You are taking?
35, my lord.
Yeah, you have to furnish that process, Mr.
I'll bring you that produce in the office, my lord. Taken up on Tuesday.
No, notice has to be served other respondents.
Served, my lord.
Where?
To the respondent.
No, by what?
And the direction was given, my lordship. It is
And
the
delivery or service to that council?
council, my lord.
Council is not in a service, Mr.
31,
Third.
31, my lord. Others.
One
My lord,
submission.
31, my lord.
Time is granted to do the needful 35.
105, my lord.
31, my lord. Other side is also there. My lord, it up to first, my lord.
30?
31, my lord.
31.
Other side is there.
Date will be fixed on 35.
My lord. Third of
31.
31.
Yes. Yeah, ಇದ್ರಲ್ಲಿ ಏನೋ process ಎಲ್ಲ ಇದೆಯಾ?
ಅದೆಲ್ಲ ಏನಿಲ್ಲ ಸರ್ 24ನೇ ತಾರೀಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೇಟ್ ಇದೆ ಅಂತ ಇವತ್ತು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಆಕ್ಚುಲಿ 1ನೇ ತಾರೀಕು ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಫ್ಟರ್ ಫಸ್ಟ್ ಮೇಲೆ ಥರ್ಡ್ ಮೇಲೆ ಅಷ್ಟೇ ಮೇಲೆ
Yes. Please this matter on 3rd.
ಮಚ್ಚ
105, my lord. One short date, my lord.
105.
Yes, my lord. One short date, my lord. It is a,
Yes, at the request 105. leave-
I am for the petitioner, my lord.
Yes, petitioner.
Interim order, my kind.
28
35, there is a stay, my lordship. Interim stay. 35, there is a stay, my lordship.
35 ಅಲ್ಲಿ?
Stay days only.
35 ಅಲ್ಲಿ interim order granted earlier is extended till next date of hearing. 105
Also interim order is there, my lord.
at the request of
Yes.
petitioner. All this matter of 2 weeks. Interim order granted earlier, if any, is extended. till-
My lord, 28.1, 28.1. My lord, tracking of the notice, it has been served, but office have not put up that acknowledgement. I will say that it will be put up, it may be called on 2nd, my lord.
Yes, 28 await service of notice. Yes.
On 2nd, my lord.
Oh,
Because
that sorry, notice has to be served.
now tracking, track rate, it has been served. Now only thing is
28. Is this matter?
2nd,
Third.
3rd. my lord.
90? 99 ಏನಾಯ್ತು? $99. Yes, interim order is there. 99, leave this matter at the request. You are appearing for? Petitioner, leave this matter next week. Interim order granted.
Serial number
42.
Date of hearing.
89, I appear for petitioner.
89.
99. I'm sorry.
ಏನಲ್ಲ?
Milord,
Sorry.
42 ನಲ್ಲಿ
99.
I have filed the wakalat, milord, recently.
40?
42.
Hmm.
I am for the petitioner. I recently filed the wakalat.
Hmm.
Previous council has filed the memo for retirement.
Hmm.
May be accepted and may kindly be urgent for 2 weeks, milord.
No, I have informed that other side. There is an IA for vacating. You inform and come
Please,
back.
I will inform.
Kindly, serial number 66, I am appearing for the petitioner. Kindly be taken up next week, my lord.
60?
66.
Yes. You are appearing for?
Petitioner, my lord.
Yes, at the request of petitioner, leave this matter next week.
Interim order may kindly be extended.
Yes. Have you informed other side?
Yes, my lord.
Interim order granted earlier is extended till next date of hearing.
Much obliged.
My lord, serial number 60, I have received the IA copy now.
60?
60.
60. Yes. No, you are appearing for,
I am for petitioner.
you are the petitioner. Then he has filed an IA for vacating.
That yes, served the copy today. I would like to file an objection.
No, you have any objection? Then wait. Then wait, yes.
Two weeks. 2 weeks. ಇಲ್ಲ ಅವ್ರು ಹೇಳಿರೋದಕ್ಕೆ ನಾನ್ ಚೇಂಜ್ ಮಾಡೋದು ಇಲ್ಲ sir. ಅವ್ರು ಹೇಳಿಲ್ದೇ ಇರೋದಕ್ಕೆ ನಾವು ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಷ್ಟೇ. ನೀವು ಅವೆಲ್ಲ ಕೇಳ್ಕೋಬೇಕು. ಅವ್ರು ನೀವು ಕೇಳಿದ್ರು ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಬೇಡ ಅಂತ ಅಂತದ್ರಲ್ಲಿ ನಾನು ಡೇಟ್ ಹಾಕಿದ್ರೆ ಬಿಡ್ತಾರ. ಫಿಫ್ಟಿ 55 ಇಲ್ಲ ಇದೆ. Yeah. No. Again, you should move the memo. Okay, madam, you should move the memo. After service of notice. ಇಷ್ಟು ಜನಕ್ಕೆ ನಾನು ಹೇಳಷ್ಟಲ್ಲಿ ನಂಗೆ ಊಟದ ಟೈಮ್ ಮುಗ್ದೋಗುತ್ತೆ. ಇದ್ಯಾವ್ದು ಪ್ರೊಸೀಜರ್ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲ ನಿಮ್ದೊಂದೇ, ಬಟ್ ಹಿಂದೆ ನೋಡಿ ಜನ ಈಗ ನಿಮ್ದೊಂದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಅವ್ರದೆಲ್ಲ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ದೆ. ನಾವು ಊಟ ಮಾಡೋದ್ ಬೇಡವಮ್ಮ. 28 ಆಯ್ತು. ಅರ್ಜನ್ ಹೇಳಿ ಫೈಲ್ ಆಮೇಲೆ ಬನ್ನಿ. ಹೇಳಿ ರಾಜಣ್ಣ. ಹೋಗೋಣ. Madam, notice has been ordered through RPID. You should supply copies, process fees, etc. Office will send the notice. ಏನು ಇಲ್ಲ ಇದೆ. ಇದೆ ಸರ್, ಆ ಕಡೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿರೋದು ಅದೇ ಉದ್ದೇಶಕ್ಕೆ, ಯಾರು ಬರ್ತಾರೆ. 60. ಹಾ. ಏನ್ ನೋಡಿ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಏನು ಬಂದಿಲ್ಲ ಇದು. ಹಾಕಿದ್ದೀರಾ ಏನು ಅಪ್ಲಿಕೇಶನ್? ಇಲ್ಲ ಸರ್ವಿಸ್ ಇಲ್ಲ ಅಂತಾನೆ, ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತಾನೆ ಅರ್ಥ. ಆಗಿದೆ CM ಇದೆ. ಆಗಿದೆ. ಹೇಳ್ತಾರೆ ಸರ್, ಅವರೇ ಬಂದು ಅವರೇ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಯಾವ ಚೇಂಬರ್? ಹಾ, ಅದೆಲ್ಲ ಹೋಯ್ತಾ 22 ಎಲ್ಲ ಅವ್ರಿಗೆ ಹೋಯ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ ಬಂತ? 22 ಇನ್ಚಾರ್ಜ್. ಸರಿ, ಬಂದೇ ಇಲ್ವ? ತೊಳಿ ಗಿರೀಶ್ ಅಷ್ಟೇ. ಹೇಳ್ತಾರೆ ಇನ್ಚಾರ್ಜ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಯಾವ್ದು ಹಾ ಅದು ಇನ್ಚಾರ್ಜ್ ಹೇಳ್ತಾರೆ ಸರ್ ಹೇಳೋಣ 25 ಏನಾಯ್ತು ಲಾಸ್ಟ್ ಸರ್ ಹಾ 22 ಅದೆಲ್ಲ ಬೆಳಗ್ಗೆ 10:32ಗೆ ಮುಗ್ದೋಯ್ತು ಏನ ಟೆನ್ಷನ್ ಅಲ್ಲಿ ಈ ಕಡೆ ಅದು ಇದು ಹಾ ಅಷ್ಟೇ ಡಿಸ್ಮಿಸ್ ಬರ್ಕೊಂಡು ಬರ್ಕೊಂಡಿಲ್ವಲ್ಲ ಡಿಸ್ಮಿಸ್ ನಾವೇನು ಬರ್ಬೇಕು ನೀನು ತಪ್ಪು ಮಾಡೋದು ಆರ್ಪಿಗಳಿಗೆ ಆನ್ ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಹೆಸರು ನೋಡ್ಕೊಂಡು ಹಾಕ್ತಾರೆ. ಏನೋ ಅದು ಆಕರ್ಷ್ ಕುಮಾರ್ ಗೌಡ ಏನೇ.
Yes.
42. I informed the other side.
42. Yes. The request of counsel for the petitioner.
That memo for retirement may kindly be.
Who has filed memo?
Earlier council has filed.
Yes. Sri Siddharth Suman Leonard Council has filed a memo for retirement. Memo is taken on, memo is taken on record. Counsel for the petitioner is permitted to retire from the case at the request of counsel for the petitioner H.N. Basuraj. Please this matter next week.
Lord, I have complied with the office objection.
Copy of the amendment, PDP to be filed, verifying cost title. Parties and the other than that parties are FDP has made a.
My Lord, most of the office objections were cleared. Only 2 objections were left. One is filing of a written statement. I made a submission that written statement I am not relying upon. Second one is respondent 2A is not made as a party. Respondent
They are
2A
not asked to filing of a written statement. Nature of the relief to be stated is specifically. Then annexes to be stated at a prior. Certified copies checked later. Copy of the amendment PDP to be filed to verify LR's cost title.
My
Parties and other than that parties to the FDP made parties to the writ petition to be clarified. These are all that we have to be clarified. What you have said is not the top subjection, it is different. Yes, you Lord.
only 2 days time, my Lord, because there is an urgency, property surplus.
Yes. At the request, 2 days time is granted to complain of subjection.
Date.
Is this matter on 3rd?
Please.
For orders, serial number 27, Srinivas SV for petitioner, SV but
Taken steps.
Yes,
Have taken steps.
awaiting service of notice to respondent. What is that interim order?
The interim order is to stay further proceedings. The application is for appointment of commissioner. Your lordship heard the matter on that, on the previous occasion, and was pleased to grant the interim order. My app,
That you want to do that? There are other petitions are there.
my lord,
Yes. Yes.
I will make my submission. The application is moved on behalf of all the,
Wait. Yeah, wait.
kindly see my application, my lord. My application is at page 105.
Yes.
My lord, this application is moved on behalf of, there are different objectors. Objectors in IAS 25, 30, 34, 35, 42, 48, 49, and 62. All of these objectors filed this application.
Now, all of these objectors were not available at the time of filing this writ petition, which is why I was constrained to make them as respondents because they were not available for signatures.
Now that,
Notice is ordered against them.
no, now that agreed is only one person.
All of them are agreed, but they were not available.
Aggrieved person means
Well,
these
the
are
difficulty
all
was, the difficulty,
arguments. What
Well,
is this?
no, one
happening
submission.
in this bar? I don't know that.
No, my lord.
How
Kindly
can
see
you
my
understand that? Without filing in a wakalat, they have been made as a respondent. You said that aggrieved party.
No, my lord.
You-
Which is why notice has been ordered against them. In fact, on the last occasion when your
Notice
lordship
has
had.
been ordered, let it be go.
My lord, in
Stay
fact, I sought dispensation to save time for the petition. I am ready on the merits of the matter.
Saying that this interim order can be restricted only to that party who has appeared before this court. He said that.
My lord, the interim order is to stay further proceedings. It will,
Further proceedings in respect of that property which is belongs to you. That's what he's saying.
The-
Because there are so many others are there.
all of the objectors are related to the suit schedule property. There's only one suit schedule property.
There is an order against all objector.
Please.
Who has coming before the court? For them, I have.
It was a common application, my lord. I have,
Application may be common. He is not interested to challenge.
no, my lord. One submission, my lord.
Yes.
Let the matter be taken up today on merits. I am ready on merits, my lord.
Yes, yes,
Okay.
argue. Yes. Even if you succeed also, it will only the one petitioner, Mr. You can't say that it can be given to that all.
My lord, I will convince why it cannot be that way because as a matter of fact, all earlier applications in this, my lord, I will tell the facts of the case, then it will be clear, my lord.
No, it is not clear, Mr. I know that. See, person who is don't want to challenge that, you want to get is it a public interest litigation?
No, it is not a public, it is a common trial which is going on, my lord.
Yeah.
May I only make this if, once,
Yes, yes, you argue, I will consider.
Please.
Yes. Yes,
my lord, the petitioner is an objector in an execution petition.
yes.
The execution petition, your lordship gets it at page 33. The order impugned is one seeking rejection of my application for appointment of a commissioner.
Yes.
The execution petition at page 33 may kindly be seen.
Yes.
The schedule to the execution petition is at
What
page
is that
30.
degree they want to execute?
The decree that they want to execute is one for partition and separate possession, and certain sale deeds and conveyance deeds are not binding on them. That suit came to be decreed. Under a final decree, a specific portion was allotted in favor of these decree holders who are represented by the KV at now. And then when the decree was sought to be executed, at that point of time, when the bailiff wanted to execute the decree, he found that there were obstructors. In fact, the spot measure also have produced at page 40.
No, you are not a party in that.
I am not a party either in the original suit or in the FDP,
Yes,
nor in the execution. I am a judgment debtor. I am an obstructor independent third party.
yes.
Kindly see the spot measure which I have produced at page 40. Type portion is at page 40.
Yes.
Then the relevant portion I will commence at page 41, my lord, to save time.
Yes.
At page 41, Kacheri in the, so I will read from the third line. The second line. ಈ ದಿನ ಸುಮಾರು ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆಗೆ ಸಮಯದಲ್ಲಿ ಡಿಕ್ರಿದಾರರು ಪಂಚಾಯತ್ದಾರರು ಹಾಗೂ ಮತ್ತು ನ್ಯಾಯಾಲಯದ ಬೇಲಿಫ್ ಸಮೇತ ಹಾಜರಾಗಿ ಡಿಕ್ರಿದಾರರು ಇದೇ ನಮಗೆ ಸ್ವಾಧೀನವಾಗಬೇಕಾಗಿರುವ ಪ್ರತಿವಾದಿಯ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಶೆಡ್ಯೂಲ್ ಸ್ಥಿರ ಸ್ವತ್ತು ಎಂದು ಡಿಕ್ರಿದಾರರು ತೋರಿಸಿದ ಸ್ವತ್ತು ಅಜಮಾಯಿಸಿ ನೋಡಲು ಸದರಿ ಸ್ವತ್ತು ಮೋದಿ ಆಸ್ಪತ್ರೆ ರಸ್ತೆಯಿಂದ ಬಂದರೆ ಶಂಕರಮಠ ಸರ್ಕಲ್ನಿಂದ ಬಲಕ್ಕೆ ತಿರುಗಿದರೆ ಶಂಕರಮಠ ಮತ್ತು ಖಾಸಗಿ ಶಾಲೆ ಅನುಪಮ ಎಂದು ನಮೂದಿಸಿದ್ದು. Then I will not read the entire thing, my lord. He lists out a number of properties, whatever is there in identification.
Yes.
He says there are so many houses, etc. And then kindly come to the last 4 lines in the very same page.
Yes.
ಅದೆಲ್ಲ ಹೇಳಿ ಆದ್ಮೇಲೆ ದೇವಸ್ಥಾನ ಸೇರಿ ಸುಮಾರು 130 ಮನೆಗಳು, ಚಿಕ್ಕದಾದ ಮನೆಗಳು ಇದ್ದು ಡಿಕ್ರಿದಾರರು ತೋರಿಸಿರುವ ಶೆಡ್ಯೂಲ್ ಖಾಲಿ ಮಾಡಿಸಲು ಹಾಗೂ ಅಲ್ಲಿ ಸುಮಾರು 400ರಿಂದ 500 ಜನ ವಾಸವಾಗಿರುವ ಮೇಲ್ಕಂಡ ಅಂಗಡಿಗಳು, ಹೋಟೆಲ್ಗಳು, ದೇವಸ್ಥಾನ, ಶುದ್ಧ ನೀರಿನ ಘಟಕ, ಬಿಬಿಎಂಪಿ ಅಂಗನವಾಡಿ ಖಾಲಿ ಮಾಡಿಸಲು ಹೆಚ್ಚಿನ ಪೊಲೀಸ್ ಸಹಾಯ ಮತ್ತು ಗಲಾಟೆಗಳಾಗಿ ಬೀಗಗಳನ್ನು ಹಾಕುವುದರಿಂದ ಗಲಾಟೆಗಳು ಆಗದಂತೆ ಅತಿ ಹೆಚ್ಚಿನ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿ ಹಾಗೂ ಬೀಗಗಳನ್ನು ಒಡೆಯಲು ಆದೇಶವಾಗಲು ಡಿಕ್ರಿದಾರರು ಕೇಳಿಕೊಂಡಿದ್ದರಿಂದ ಹಾಗೂ ಸ್ಥಳದಲ್ಲಿ ಗಲಾಟೆಗಳು ಆಗುವ ಸಂಭವವಿರುವುದರಿಂದ ಇಲ್ಲಿ ಖಾಸಗಿ ಅಂಗಡಿಗಳು, ಹೋಟೆಲ್ಗಳು, ಸರ್ಕಾರಿ ಶಾಲೆಗಳು ಇರುವುದರಿಂದ ದೇವಸ್ಥಾನ ತೆರವುಗೊಳಿಸಲು ಅನುಮತಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಡಿಕ್ರಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಖಾಲಿ ಮಾಡಿಸಲು ಸಾಧ್ಯವಾಗಲಿಲ್ಲವಾದ ಕಾರಣದಿಂದ ಸದರಿ ಸ್ವತ್ತನ್ನು ಡಿಕ್ರಿದಾರರಿಗೆ ಸ್ವಾಧೀನಪಡಿಸಲು ವಾಗಲಿಲ್ಲವಾದ್ದರಿಂದ ಡಿಕ್ರಿದಾರರು ಹೆಚ್ಚಿನ ಪೊಲೀಸ್ ಸಹಾಯ ಮತ್ತು ಬಿಗಳನ್ನು ಒಡೆಯಲು ಆದೇಶವಾಗಬೇಕಾಗಿ ಡಿಕ್ರಿದಾರರು ನ್ಯಾಯಾಲಯದ ಆದೇಶವಾಗಬೇಕೆಂದು ಕೇಳಿಕೊಂಡಿದ್ದರಿಂದ ಸ್ಥಳದಲ್ಲಿ ಹೇಳಿ ಬರೆಸಿದ ಸ್ಥಳ ಮಹಜರ್. ಈ ಸಮಯದಲ್ಲಿ ಹಾಜರಿದ್ದು ಪಂಚಾಯತ್ದಾರರಾದ ನಾವು ಸ್ಥಳ ಮಹಜರನ್ನು ಓದಿಸಿ ಹೇಳಿ ಕೇಳಿ ತಿಳಿದುಕೊಂಡು ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇವೆ. ಸೊ ಈ ಜಾಗದಲ್ಲಿ there are about 600 people residing. Among these 600 people who are residing, I represent about 60 of them. About 60 of them filed applications in the executing
You
court.
say that for 600 also.
My lord,
You can do it.
no, my lord,
Why
I have filed wakalat for about 60.
No,
Then,
here you are challenging one person. You can argue for 600 also. You can do it.
no, my
That's
lord,
what you said. Why can't tell me that when you are saying that
No,
person who has not filed writ petition,
Please.
he can represent. Why can't you 600?
my lord, I filed wakalat for about 60 of them. Then what happened is about 52 of them did not turn up for evidence. Their applications were dismissed for non-prosecution.
If they are not come forward to give an
No, I am not prosecuting on their behalf. I will complete.
Yes, yes.
And on behalf of whom the application was made are 8 objectors who have let in evidence who have been cross-examined. Prior to trial, an application was moved on behalf of the objectors for appointment of commissioner. That application, your lordship gets it at page 57.
Yes.
Earlier, this application was moved prior to trial.
Yes.
At that point of time, when
Now,
the
what is that order you are challenging?
order is to appoint commissioner for local investigation to find out whether, because there is the decree holders have raised 2 objections to my objector application. One, they say I have no title, and second, they say my identity of my properties are.
Now, where is that now order which is you are challenging?
The order which is under challenge, your lordship, the order commences at page 19. Reasoning commences at page 26.
Yes. No, application for appointment of the commissioner is rejected.
Rejected. Earlier, prior to that, may I bring to your lordship one more fact. When I had filed an application for appointment of commissioner prior to trial, the trial court had dismissed it, saying that trial is yet to commence. I had approached this honorable court on a writ petition.
Mr. We have to hear that, man. If it is
Please.
granted,
In fact, it was heard by your lordships at length and then granted.
If it is appointment of the commissioner is quashed or application is allowed, it will benefit for even one person. But even if it is restricted, proceedings cannot be gone. But that main relief is that not.
In fact, the caveator was also heard by your lordship on the last date.
He cannot file the petition or he cannot file the application. What we are saying is the application has been rejected on the ground that ultimately your lordship, it is his application, not 2609. 2609 application can be filed only when if the court is.
No,
not
that's
in a
no
position-
whether.
He is in a position to take a decision as to whether we got the.
No,
identity of
that-
the property. Then if it requires more evidence.
No,
then
that will dealt later on that merit. Whether property can be identified, when commissioner himself said it cannot be, then whether it is necessary or not. Now, if it is relief to that one person, if it is relief to the 600 also, even they are not.
This person, the reason why you see the application what they have filed.
Hmm.
In the application.
No, not that. The execution that bailiff has given a report saying that it cannot be executed. To identify your property, commissioner appointment is necessary. If you want, I will.
Bailiff does not say that property cannot be identified. What he says is, there are so many people. Without the.
No, you see
police
that-
help, it cannot be.
You see that finding.
40.
Page
40 it commences.
40.
Please,
Yes.
I read out at 41.
ಚಿಕ್ಕ ಚಿಕ್ಕ ಮನೆಗಳು ಇದ್ದು ಡಿಗ್ರಿ ತೋರಿಸಿರುವ ಶೆಡ್ಯೂಲ್ ಖಾಲಿ ಮಾಡಿಸಲು ಹಾಗೂ ಅಲ್ಲಿ ಸುಮಾರು 400ರಿಂದ 500 ಜನ ವಾಸವಿರ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಅಂಗಡಿ, ಹೋಟೆಲ್, ದೇವಸ್ಥಾನ
ಹೆಚ್ಚಿನ ಪೊಲೀಸ್ ಸಹಾಯ
ಮತ್ತು ಗಲಾಟೆ, ಬೀಗ ಹಾಕುವುದು ಗಲಾಟೆ ಆಗುತ್ತದೆ. ಅತಿ ಹೆಚ್ಚಿನ ಸಿಬ್ಬಂದಿ ಹಾಗೂ ಬೀಗ ನಡೆಯುತ್ತದೆ.
ಅತಿ ಹೆಚ್ಚಿನ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿ ಮತ್ತು
ಇದರಲ್ಲಿ ಹೇಳಿಕೊಂಡಿದ್ದಾಗ ಸ್ಥಳದಲ್ಲಿ ಗಲಾಟೆ ಆಗುವ ಸಂಭವವಿರುವ ಖಾಲಿ ಅಂಗಡಿಗಳು, ಹೋಟೆಲ್ ಹಾಗೂ ಸರ್ಕಾರಿ ಅನುಮತಿ ಬೇಕಾದ್ರಿಂದ
ಪೊಲೀಸ್ ಹೆಲ್ಪ್ ಸ್ವಾಧೀನ
ಖಾಲಿ ಮಾಡಿಸಲು ಸಾಧ್ಯವಾಗಿಲ್ಲ.
ಖಂಡಿತ.
Yes.
Property is identified. They also does not dispute that they are in occupation of a property which has fallen to my share, that is
survey number 176/1B.
Hmm.
ಅದನ್ನು
Yes, mister, where is that identification is difficult?
My lord, no. So pursuant to this, I filed objector applications. My objector application is at page 43. I will point out their objections to my objector application. Where they have disputed identity, kindly come to page 52, my lord. Page 52,
Hmm.
paragraph 5, I am reading out from their objections to my objector application.
Yes.
Para 5, without considering what is stated in paragraph 3 supra, it is submitted that the present application is considered as an application under 21 Rule 99 CPC also. Since the objector claiming to be an unauthorized occupant of a small portion, identity of which is disputed, cannot maintain the application. The decree holders dispute the identity of the property as described in the schedule to the application.
No, your application for impleading objector is allowed.
I was permitted. It was held, inquiry is all.
Inquiry. Let that application decided, till then not to evict them. If it is evict them after conducting inquiry, what is there is?
No, that is.
They will not be evicted.
Not good.
It is only final hearing has to take place and order is passed, then only court will take a decision.
That's
That is correct. That is correct.
that will clarify that.
In that inquiry, in the process of that inquiry, before the inquiry commenced, I made a commissioner application. That was rejected. This honorable court said, I can revive my application after trial. Now the trial is completed. At that stage, I filed this present. May I point out the earlier order, page 73. Commences at page 73.
Yes, why let the commissioner go and give a report? Why do you worry that? If there is no difficulties for identification.
Commissioner is not required to be appointed for the purpose of collection of evidence.
No, it is not collection of evidence. See, now the latest judgment says that
I have relied on
collection
it.
of evidence and at any stage you can appoint. Here it is assisting the court to identify that property unless it is prejudice to you. Why do you worry if it is commissioner is appointed?
The reason is this. It is not in this.
No, Mr. But one thing, if they are in the possession of that your property, they have to evict. If other than that suit schedule
No, ma'am,
property,
it is the,
that cannot be.
it is the other way around, my lord.
44, their schedule.
Yes.
On the piece and parcel of the residential house property bearing number so.
Yes.
Farming part of survey number 176/1A, 176/1B, aggregate, issue prohibited. So there insert but be 176/1B ಅವ್ರು admit ಮಾಡ್ಕೊತಾರೆ. ಅದಕ್ಕೆ schedule, schedule, executive schedule 176/1B only. It is not dispute ಮಾಡ್ತೀನಿ ಅಂತ.
ನಿಮ್ದು ಯಾವುದು? ನಿಮ್ದು ಯಾವುದು?
176/1B.
176 for? They are also saying that 176 for 1 page.
Yes. That is why it is required.
Because I am disputing. When they are admitting 176/1B, where is the question of appointment?
When it is 176/1B, then if I am in possession of 176/1B, which according to me I am, which they have disputed, if they now consider that I am in 176/1B, then the only question which will remain is whether I have independent title. In a 21 Rule 97, I am required to show before the executing court that I do not claim title either under the decree holder nor under the judgment debtor. That is a question of title.
See, now by that report submitted by the bailiff,
Please.
it shows that you are in the possession of the property.
No, it does not, because he says 130 ಮನೆಗಳಿದೆ. ಆ 130ರಲ್ಲಿ ನಾನು ಬರ್ತೀನಾ ಇಲ್ವಾ is one of the questions.
No, even if it is that your case is also that you are in that 160/1B.
1B, please.
Their case is also 160/1B. Suppose if you are in the possession of that suit schedule property,
Please.
what is your remedy?
My remedy is then I must show to the executing court on the basis of the evidence that I have led and also on the basis of the evidence which they have already led, that I have an independent right, title and interest that is independent of either the decree holder or the judgment debtor. I claim a title which flows neither from the decree holder nor from the judgment debtor. My case is that it flows neither from the decree holder nor from the judgment debtor. That title aspect I have to independently show. Why this commissioner application was required is because they also disputed that I am in 176/1B. They are not conceding, if they are now conceding that I am also in 176 bar 1B, that could be recorded and it could be
The two
closed
thing-
here.
Now, two things. See, report says they are all in that 160 per 1B because therefore they cannot be evicted without the police force and all.
Yes.
If you says that, yes, if they are, then court has to decide what is their right
Title.
and all.
Title.
Suppose if you say they are not in that, then commissioner is
Please.
necessary.
Absolutely.
Of the bailey, insofar as when delivery warrant was issued, he has given the report saying that there are so many people, 130 people are there, 130 houses are there. In that, according to them, they are also one of them. When that be the case, their possession of a portion of the property is an admitted possession. Otherwise, there is
No, the question is, if
They-
that,
they will have to
no,
see
if that,
the title.
no, if the degree holder is in the possession, then they can be evicted. If the person who is not in the party to the suit, if they are in the possession, then right has to be determined by the.
Determined.
That is not- Finally, the.
No, see, now he is saying that my position is disputed by them. Therefore, I want that. If you are admitting that, commissioner is not necessary
Necessary.
because prima facie, there is a material.
And
Yes, we'll hear that, yes. Yes,
So far as the other petitioners are concerned,
No.
let the interim may not.
no, it's one and the same.
Proceed.
Yes, it's one and the same, yes. Now that service is complete, which is the serial number?
27.
27, my lord, 8 to 30.
8 to 13 avoid.
I've taken steps on the very next day, my lord.
Yes, week's time is granted to avoid service.
Wait,
of
I have
notice
taken
to
steps already.
R8 or 13. Yes.
Interim order,
Interim order granted earlier is extended till next date of hearing.
public.
Cell number 28 adjourned, cell number 29, Arun BK for petitioner.
Yes, Mr.
Will take steps, my lords. I may also be permitted to serve, sir's notice upon the advocate appearing for the
Yes.
respondent number 1 before the trial court, my lord. In addition, my
There
lord,
is, in addition to the petitioner permitted to take out hand summons to that respondent. Have you taken the hand summons?
he was not available for service, my lord.
Who?
The respondent number 1 was not available. I have filed the summons.
Who
along
is
with
the
the memo.
respondent number 1?
V Venkatesh, my lord.
We have to go to his house and serve that.
ಅಲ್ಲ ಅವ್ರು ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಈಗ ಏನ್ ಮಾಡ್ತೀರಾ ಈಗ?
Counsel appearing for him before the trial court, my lord, through his
But if
counsel.
the counsel is not appeared, then you can't force him to,
I know.
best method is to go and serve them hand summons.
Summons and service upon the council, both, we will take both the steps.
Yes, week's time is granted to pay the process, issue notice to respondent number 1.
Lord,
In addition, petitioner is also permitted to serve a copy on the counsel appearing for the respondent number 1 before the trial.
my lord, one more prayer, my lord. If an interim order of stay of further proceedings could be passed, because the matter, my lord, before the trial court is being posted once in every 2 weeks. The order, my lord, which is under challenge is
Now,
one-
have you filed any affidavit that he can't, he is not available for service?
a memo has been filed, my lord,
You
wherein.
file an affidavit, have you went, as your client went to his, near his house and see that?
Yeah, please, my lord.
What is that he saying?
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. He has-
ಏನ್ರಿ ರೆಸಿಡೆನ್ಸಿಯಲ್ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
please, he has recently vacated that house and he has shifted his residence is what my inputs are, my instructions are.
Anyhow, now that you service
Please,
lawyer, let us see. Yes,
A date may kindly be
yes,
fixed.
we'll fix the date.
Next date before the
Correct.
trial court, my lord, is on 17th of April,
17th of April.
please.
Yes, we'll have it on 17th. In the meantime, you serve it. Yes.
Please, please. Really.
Is this matter on 17th? Permitted to serve? Yes.
Cell number 30, 31 adjourned, cell number 32, Raghunath MD for petitioner.
I appear for the petitioner, my lords.
Yes, Mr.
My lords.
What is this maintainability, Mr.?
Yes, my lords. I'll come to that aspect. If my lords may kindly permit me to point out 2 points, my lords, which
Yes.
is interconnected.
Yes.
My lords may kindly peruse. There is a suit filed by the respondent against the petitioners, my lord. And the
Yes.
relief sought for is at annexure A at ink page number 16, my lords, 16.
16.
Yes, my lords. Please, my lords, it says direct different number 1 to 6, including persons claiming so and so, to deliver, quit and deliver vacant physical possession. 2, direct different number 1 to pay plaintiff a sum of rupees 48,500 as
Yes.
arrears of rent. 3,
Yes.
direct different
For
number.
ejectment and.
Yes, my lords.
and
The
recovery.
petitioners are subtenants, my lord.
Yes.
The third point, my lords, is direct difference number 1 to pay plaintiff a sum of rupees 1,50,154 towards arrears and municipal taxes.
Yes.
If my lords may kindly peruse both prayer number 2 and 3,
Hmm.
upon addition, it comes within 3 lakhs, my lords. Because prayer number 4 talks about future mean profits,
Yes.
which is at 5 lakhs, which is at a future date, my lords, not from the past date or when the petitioners were in possession of the property.
Yes.
If I may bring to my lord's attention to Section 6 of the Commercial Courts Act, my lords.
Yes.
It talks about the jurisdiction of a commercial court, which says, my lord, the commercial court shall have jurisdiction to try all suits and application relating to a commercial dispute of a specified value.
No, you filed an application under Order 7, Rule 10,
Yes, my lords.
return of plaint.
Yes, my lords.
It is rejected.
It has been rejected, my lords.
Now, what is that office objection?
Now, the office objection, my lords, is that in accordance to Section 13(1)(a) of the Commercial Courts Act, I should have filed an appeal before this honorable court. But my humble submission is this, my lords. May I pass on this judgment, my lords?
No, I don't think under 43 there is an appeal.
Yes,
You
my
go
lords.
to the- Because only in rejection.
Yes, my lords. That's precisely my point as well, before my
The-
lords.
Other than that, commercial suits, you can file in a revision, but here you can't file in a.
A revision, I can't do so, my lords.
Yes, then what else for that? Yes. That is that only office objection. What
That is,
this
that's the
judgment?
only one, my lords.
What is this judgment?
This, my lords, is an exceptional case, which is at page number 10.
No, that rejection of the application itself is not that appealable.
Yes, my lords. It could be filed under a writ petition, my lords.
Yes. Yes. Then what is that other? That is the only office.
That is the
objection?
only office objection.
Yes. See, because you see that Order 43,
Yes, my lords.
Rule 1.
1(a)(b), my lords.
See, if the order is Order 7, Rule 10(a),
Correct, my lords.
then it's
Correct, my lords. That is only when it is appealable.
appealable. Yes.
Please, my
Otherwise,
lords.
it's not. Yes. No, even if it is rejected, plaintiff is rejected
Please, my lords.
under Order 7, Rule 10,
Please, my lords.
appealable.
Please, my lords.
If it is 10(a), again it is not appealable.
Yes, my
Even
lords.
though it is rejected.
Even though, yes, my lords. In this case, it's the contrary. my
A,
lords.
on the request of the plaintiff itself, it is returned. Therefore, it is not appealable. That's
True,
what-
my lords.
Yes, now that you argue on that merit.
Please, my lords. My lords may kindly peruse. In page number 16, prayer number 2 and 3, my lords may kindly peruse. Upon calculation of the amounts, it comes within 3 lakhs, my lords.
How you are calculating 48,000,
Yes, ma'am. That is the
Dependent-
total arrears of rent.
pay sum of rupees towards arrears of municipal taxes, other charges.
Yes, my lords. And
Can't you add this
para number 4, my lords.
48 and?
Yes, my lords. Even if 48,500 plus 1,50,000 is added, it comes to 1,98,654.
This is what that 5 lakhs per month. means
5 lakhs per month is future mean profits, my lord, not the past or the present mean profits. They're talking about future mean profits. The reason why they did this, my lord, so that they could bring the suit in the jurisdiction, within the jurisdiction of the Honorable Commercial Court.
That
That's
cannot
why
be-
they got this clause, my lord.
No, that cannot be calculated.
That cannot be, my lords, because what happens is
You
a
have any
future mean
judgment on
profit.
that?
Yes, my lords, that also I had relied on before the Honorable Trial Court.
Yes.
This is a settled position, my lords, before my lords. The same decisions have been given by the Honorable High Court of Karnataka itself.
Is that?
In page number 36, my lords,
36.
36.
Yes.
The
Yes.
third unnumbered paragraph, my lords.
Yes.
During his arguments, he has relied upon decisions reported in AIR 1969 SC 155 and in another decision by the Honorable High Court of Karnataka in Sandeep Chauhan and another versus Sri Krishna Raj Raja Bhatt. Despite doing so, the Honorable Trial Court, my lords, went in contra, wherein the reasoning given is in page number 38, my lords.
Yes.
They have relied on the decision given by the respondent, which goes on to say, my lords, that Order 20, Rule 12, is with respect to past mean profits as well as the present mean profits, my lords. When that is the scenario, the decision relied upon by the respondent is with respect to past mean profits, not the future mean profits, my lord. The jurisdiction of the Honorable Court
No, you
cannot be
see-
based upon
no,
a future mean profits.
Judgment which you have relied on.
Yes, my lord.
It says that only a past mean profit.
Yes,
has
my
been
lords.
considered.
Future mean profits cannot be taken into consideration. Apologies, my lords. I do not have it right now. If my lords may kindly post it tomorrow, I shall produce the same.
Yes, tomorrow.
Please, my lords. Apologies on that aspect, my lords.
Yes, yes. Please let us, yes.
Cell number 33 disposed of. Cell
Macho.
number 34, Nayanatara BG for petitioner, Raj Aditya Sadasivan.
Yes. Yes, we'll dictate.
Lords, I appear for
Only
the
that day.
petitioner on this matter, my lords.
Yes.
I'm sorry, my lords, I'm on VC. I have some difficulty today.
No, only I have to dictate that date I don't have any time, therefore, yes, tell. This petition is filed by defendant challenging order dated 5/11/2024 passed by 41st Additional City Civil and Session Judge, Bangalore, in YS number 6660 of 2024, whereby
2014.
Whereby IA number 3 to 5 of 2024 filed by the plaintiff has been rejected. Plaintiff has filed a suit for
Lords, I'm sorry, the IAs are allowed.
IS. No, that your application or your challenge, defendant has
Yes.
filed an application has been allowed. Plaintiff has filed a suit for recovery of money sum of rupees 18,89,723 with 18% interest. After service of summons, defendant has appeared through counsel, filed a written statement. On the basis of the pleadings of the parties, trial court has framed the issue ಮಾಡಿದ್ರು first. Where is that issue you have produced, Mr.?
Page number 23.
Yes. Framed 6 issues. Thereafter, the parties has adduced their evidence. Both the parties has adduced their evidence.
I completed my evidence in 2017. This additional issue came to be framed
No.
in 2019
Before defendant evidence.
for defendant.
Yes, after completion of plaintiff evidence, defendant has seek for an framing of additional issue. On the request of the defendant, the trial court has framed additional issue. On after framing of-
4/11/2019.
Yes, on framing of additional issue, the defendant has adduced their evidence. At that time, plaintiff has filed a memo. Where is your memo, Mr.?
Page number 24, my lord, next page, 4/12/2019.
Yes,
I filed a memo before the defendant commenced the evidence.
yes. In that same document. 24. Yes, filed a memo before the defendant start their evidence on 4/12/2019. Reserve the right to lead rebuttable evidence on additional issue after the evidence of the defendant is complete. After that evidence of defendant was completed, the plaintiff has filed this application. IA number. What are that application? IA number 3 for?
IA 3 is for under order 18 rule 17 to reopen the plaintiff side evidence and recall PW1.
Reopening the plaintiff evidence. IA number 4,
IA4 is under section 151 to recall the order dated
no,
13/6.
IA4 of 2024 is filed under 18 Rule 17, Mr.
IA3 is under 18 Rule 17.
But you see that impugn order, page 62. IA3 is filed under 151 of CPC to recall that order. IA4 is for order.
My apologies, I stand
Yes,
corrected.
yes, here is there, yes. Filed an IA number 3. Filed IA 3 to 5. The same has been allowed, being agreed by the same. The defendant is before this court. Learned counsel appearing for defendant has contended that the right of the plaintiff to lead rebuttable evidence does not extend it to overcome the omission in his additional evidence or other material admissions in the cross examination. In the guise of rebuttable evidence, plaintiff cannot be permitted to lead additional evidence. Since the additional issue has been framed, shifting the burden on the defendant, the plaintiff cannot be permitted to lead rebuttable evidence in respect of the issues where onus is on the defendant. He further contended that in application for additional evidence for production of additional documents, no reason is forthcoming. Even though the additional issue has been framed on
4/11/2019.
2019.
There is no explanation for delay in producing that application. The trial court, without giving any reason, has allowed that application. Hence, he sought for allowing that petition. For contra, so and so learned counsel appearing for the plaintiff respondent. On the basis of the pleadings of the parties, trial court has framed the issues on plaintiff completing his evidence. On request of defendant, additional issue has been framed. Immediately thereafter, on 4/12/2019, defendant has filed a memo reserving right to lead rebuttable evidence on additional issue after that evidence of the defendant is completed. Therefore, he has all rights to recall the witness of PW1, the witness of the plaintiff, and to examine his witnesses on additional issue. He is also contended that he has all rights to adducing rebuttable evidence in respect of additional issue. If also relied on. And lastly, he has contended that since he has reserved his right for adducing that evidence, he need not give any explanation for production of documents. It is a right available for the parties. In support of his contention, he's relied on judgment of this court in WP number 30338 of 2023 at 2003, disposed of on 15/7/2003. And also judgment of this court in writ petition number miscellaneous civil number 3231 of 2021, disposed of on 10/2/2011. Hence sought for dismissal of the writ petition. Heard the learned counsel for the parties. Peruse writ papers. The plaintiff has filed a suit for recovery of sum of rupees 18,89,723 with future interest at 18% from the date of suit till the date of realization of the same. Defendant, after appearing through their counsel, has filed a written statement. On the basis of the pleadings of the parties, trial court has framed 6 issues. Accordingly, plaintiff has adduced their evidence. When the matter is posted for evidence of defendant, defendant has filed an application for framing of additional issue. Considering the same, the trial court has framed an additional issue on 4/11/2019. Additional issue framed by the trial court is whether defendant bank proves that the fixed deposit account held in the name of the plaintiff was an Hindu undivided family account. Immediately thereafter, on 14/4/12/2019, the plaintiff has filed a memo after serving in a copy to the plaintiff, serving copies to the defendant. Reserve his right to lead that rebuttable evidence on additional issues after the evidence of the defendant is completed. So far, his request for adducing that his request for reserving the right to lead rebuttable evidence on additional issue after the evidence of the defendant is completed is not rejected by the trial court. Therefore, application filed by the plaintiff IA number 3 of 2024 for recalling that order dated 13/6/2023 to reopen the case of the plaintiff for evidence, and IA number 5, IA number 2 for what?
A3 is to recall order dated 13. 4 is 18 Rule 17 to recall the PW1.
Yes, IA number 4 of 24 filed under order 18 Rule 17 for recalling that PW evidence is just and reasonable. The trial court has rightly allowed that application. In respect of IA number 5 of 2024 filed under order 7 Rule 14(3) read with section 151 of CPCs for production of 15 documents is concerned. No doubt that plaintiff has claiming that all these documents are related to that additional issues framed by the trial court. The additional issue has been framed on 4th November 2019. Immediately thereafter, on 4/12/2019, that plaintiff has filed a memo reserving right to lead that rebuttable evidence on additional issues after the evidence of the defendant is completed. Thereafter, he has not filed any application for production of documents in respect of that additional issues. Application has been filed after that evidence of the defendant. After the evidence of the defendant on additional issues. Additional issues.
On all issues.
All issues. The specific contention of the defendants that now by filing the application for additional document has been filed to overcome that omission in that additional evidence or other materials admission in the class examination. Even though additional issue has been framed on 4/11/2019, the application for production of the document has been filed 2024. There is no reason forthcoming in that application for non-production of the documents immediately after framing of the traditional issue. Trial court has not answered this averment allegations made by the defendant in that objection. There is no reason forthcoming to allow that application IA number 5 filed under Order 7 Rule 14 subclass 3. Therefore, the order in respect of IA number 5 is required to be set aside. Accordingly, the writ petition is allowed. Order passed by the trial court dated so and so in respect of IA number 3 of 2024 on IA number 4 of 2024 is confirmed. In respect of IA number 5 of 2024, it is set aside, remitted back to the trial court to reconsider the same afresh in accordance with law after giving an opportunity to both the parties.
I may be permitted to file additional affidavit explaining the relevance
That's you.
and also why I could not produce. I may be
Yes,
permitted.
that's you do it.
I mean,
even-
liberty may be granted.
No, I have not given any finding that delay and all.
My lords,
Now
I
it
don't
is-
think my learned friend should improve his case now. I oppose any
It is not a
liberty.
criminal case where I start improving the case.
You file, if the permitted, you file it. I have not restricted it. If I permitted, then even
He'll
though this
compel
law
the
is not
trial court to
permitted,
take it.
trial court, nobody, even a defendant cannot object. because
Yes,
High Court
yes,
has
please,
permitted.
your lordships are right, your lordships are right. I'm deeply grateful, my lords.
Yes,
Your lordships have given us a very patient hearing in this matter.
yes, yes.
I'm grateful.
Yes. All pending applications are disposed.
Cell number 35 adjourned, cell number 36, Kishan GS for petitioner, Manjunatha SC.
Yes,
Petition, my lordship, kindly, next week, my lord.
yes.
Senior is out of station.
Monday or Thursday,
ಆಗ್ಬೋದು.
3 or 4.
Fourth.
Please.
Yes, at the request, ಏನಕ್ಕೆ ಬಂದಿದೆ ಇದು?
Interim order extend.
Rectification of the office objection
Yes.
raised on IA. You have filed an IA for vacating.
Vacating, please.
What is that rectification, mister?
ಒಂದು acknowledgement ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕಾಪೀಸ್ has been served.
Yes, now that, who is that respondent number 1? Is necessary?
Already sell this property.
ಅಲ್ಲ, whether
Not
R1 is
required.
necessary or you are that enough for?
Enough.
Yeah, yes,
My lordship, interim order can be
yes,
extended.
leave this matter on 4th. Interim order granted earlier is extended till next date.
Fourth. Please.
Cell number 37 adjourned, cell number 38, Prashant Yuti for petitioner, Vishnu Yegde.
Yes.
Lordship were pleased to hear the matter at
Yes,
length
but
the
two
previous occasion.
Hmm.
My lords, this is a matter wherein, my lords, the property belonging to this petitioner
Yes.
has been sold without even fixing the base price as per.
Yes, now we will hear that, yes.
Not only that,
You give that.
please,
brief
please.
facts.
May I just draw attention of your lordship straight away to page number 75, please. This is the sale proclamation model which has been issued by the trial court.
Give that brief facts, I forgot.
Please,
everything.
Please. My lords, the property, no, my lords, petitioner is a judgment debtor before the trial court.
No, but suit for,
Suit for specific performance was filed.
Hmm.
Wherein, my lords, it ended in compromise. At annexure B, your lordship may find.
Annexure.
Compromise petition, please.
Page.
Page. Lords of. Annexure B page. Forty-seven. Compromise petition. Kindly turn to para 4, please.
47.
Yes, please.
What is that settlement?
Suit for specific performance was decreed in terms of compromise.
Yes.
My lords, under the sale agreement, my lords, rupees 60 lakhs was received by this judgment debtor. That is petitioner. Para 4, please.
Yes.
My lords, the defendant has undertaken to agree to pay entire amount of rupees 60 lakhs to the plaintiff through DD or RTGS into the bank
You
account
are
of
the plaintiff.
My lords, I am the defendant in that matter, please.
You are the defendant.
I am the landlord.
You have executed,
I had executed, my lords, agreement of sale. I had
you have undertaken to agree to that entire amount. Now that
60 lakhs. My
yes.
lords, kindly peruse the time limit, please. Plaintiff, the defendant has undertaken to agree to pay entire amount of rupees 60 lakhs to the plaintiff through DD or RTGS into the bank account of the plaintiff within 4 months from this day. My lords, kindly peruse when this compromise was entered, please. 22/11/2019
to the plaintiff within 4 months from this date.
plus
However,
30 days grace period.
Are extended for clearance of rupees 60 lakhs to the plaintiff.
4 months plus grace period of 30 days.
Yes.
My lords, this agreement was executed in the month of November 2019.
November.
2019.
Yes.
4 months means, my lords, March 2020. Unprecedented pandemic.
March 2020.
I could not, my lords, sell the property, my lords. Therefore, my lords, in view of unprecedented pandemic, I could not.
Yes.
No, my lords, in the month of June 2020, my lords, they filed execution.
Yes.
Annexure D. Property belonging to this petitioner, my lords, was attached.
Yes.
No, my lords, I am not questioning the attachment at all. The day or other, my lords, I need to pay the amount.
Yes.
I need
yes.
to pay,
Now
please.
property is
That's
attached.
why, my lords, I'm not questioning the attachment.
Yes.
Pursuant to attachment, whatever that is done is absolute illegality, please.
Yes.
Kindly turn to, my lords, page 75, please. This is the sale proclamation warrant, my lords, which has been issued by trial court without even fixing base price. Kindly peruse page 75, please. My lords, the amount mentioned herein is amount which I am due to judgment debtor. This is not the value of the property.
Yes.
Now kindly peruse what order 21 rule 66 clause 2 subclause E says, please.
66,
21 rule 66 clause 2.
Yes.
I may be permitted to read, my lord, please.
21/6.
21 rule 66 subclause 2
Yes.
subclause E. May I read, my lords, please?
There is no estimation.
No estimation. Absolutely right. May I, my lord, straight away read clause E, please? Every other thing which the court, I'll read
66.
Subclause 2. My lord, such proclamation shall be drawn
Yes.
up after notice to the decree holder and the judgment debtor and shall state the time, place of sale and specify as fairly and accurately as possible. Now kindly peruse what E says, please. Every other thing which the court considers material for the purchaser to know in order to judge the nature and value of the property.
No, that after 2, you are reading which E?
Clause E.
E, yes.
Every other thing which the court considers material for a purchaser to know in order to judge the of the nature and value of the property. Now, my lords, kindly peruse second proviso to Clause E, please.
Yes.
Provided further that nothing in this rule, may I read, my lord, please?
Yes, yes.
Provided further that nothing in this rule shall be construed as requiring the court to enter in the proclamation of sale its own estimate of the value of the property, but the proclamation shall include the estimate, if any, given by either or both of the parties, please. Court need not estimate on its own,
Yes.
but it has to quote the estimation given by either of the parties, please.
Yes.
If not judgment debtor, my lords, either decree holder. Now, kindly peruse, my lords, page 75, please. Admittedly, my lords, no estimation.
Yes.
Now, kindly peruse, my lords, the proclamation which was held on 5/10/2023, please. Page 79.
Yes.
My lords, your lordship may find scheduled property, please.
79. Yes.
Page 70, in page 79, please.
Yes.
Your lordship may find east by, west by, north by, south by in
Yes.
scheduled property.
Hmm.
Just opposite to that, my lords, VST DHR submits the market value of scheduled property site rupees 4 crore 87 lakhs. Now, in the sale proclamation, there is no estimation. Here, court bailiff notes that this is the value of the property. Sarkari saval 90 laksha. My lords, the purpose behind estimation of the property value is to see that the court bailiff is going to start the bid from the estimated value. Here, since there is no estimation, court bailiff, my lords, records that the value of the property is 4 crore 80 lakh and odd, and thereafter, my lords, start the bid at 90 lakhs. My lords, kindly peruse, turn to next page, please. Page 81, my lords, please. Second respondent, my lords, is declared as highest bidder.
Yes.
1 crore 8 lakh, Amrit Kumar. He is second respondent before this court.
1 crore.
8 lakhs.
ಯಾವ್ದು serial number?
5. My lords, 7.
Yes, yes.
1 crore 8 lakhs. My lords, now kindly turn to what is the valuation of the property for a moment, please. Government guideline value, please.
Yes.
Annexary, page 73. In page 73, my lords, please.
Yes.
My lords, 813, a serial number 813.
73 na?
In page 73, there, my lords, serial number 813.
813.
Nagashettihalli, Yella Mukhya Rastegalu. 97,980 rupees. It will come to around, my lords, 2 crore 99 lakhs as per government guideline value, please. Let us leave, my lords, private value, please. Government guideline value itself will come to around 3 crores.
Yes.
Now, admittedly, my lords, no sale price is mentioned. Now, kindly let us see, my lords, whether trial court has taken any effort to give wide publicity or not. Now, kindly turn to, my lords, page 88 for a moment, please. Where and all, my lords, sale proclamation has to be affixed.
Yes.
Kindly peruse, my lords, order 21, rule 54 for a moment, please.
80.
88. I may be permitted to read, my lords, please.
Yes.
This is the typed copy of, my lords, page 78.
Yes.
ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಡಂಗೂರ ಹೊಡೆಸಿ ನಕಲನ್ನು ಸ್ವತ್ತಿನ ಬಳಿ ಅಂಟಿಸಿರುತ್ತೇವೆ. ಮತ್ತೊಂದು ನಕಲನ್ನು ಸಿಪಿಎನ್ ಮೀನ್ಸ್ ಕೋರ್ಟ್ ಪ್ರೊಸೆಸ್ ನಜಾರ್ ಬ್ರಾಂಚ್ ನಾಮಫಲಕಕ್ಕೆ ಅಂಟಿಸಿರುತ್ತೇವೆ. ಡಂಗೂರ ಹೊಡೆದವರಿಗೆ ಬತ್ತೆ ನೀಡುತ್ತೇವೆ ಸ್ವಾಮಿ. My lords, sale proclamation warrant has been affixed in court process nazar branch and near the property.
ಆದೇಶದಂತೆ ಡೊಂಗುರ ಹೊಡೆಸಿ ನಕಲನ್ನು ಸ್ವತ್ತಿನ ಬಳಿ ಅಂಟಿಸಿರುತ್ತೇವೆ. ಮತ್ತೊಂದು ನಕಲನ್ನು ಸಿಪಿಎನ್.
That is court process nazar branch.
Court process
nazar branch. CPN. ಕೋರ್ಟ್ ಪ್ರೊಸೆಸ್ ನಜರ್ ಬ್ರಾಂಚ್ ಅಂತ ಒಂದಿರುತ್ತೆ, ಅದು ಸಮನ್ಸ್ ನ ಸರ್ವ್ ಮಾಡ್ತಾರೆ.
ಪ್ರೋಸೆಸ್ ಎಲ್ಲ ಜನರೇಟ್ ಮಾಡುವಂತ ಬ್ರಾಂಚ್ ನಜರ್
ಬ್ರಾಂಚ್.
ನಾಮಫಲಕಕ್ಕೆ ಅಂಟಿಸಿರುತ್ತೇವೆ.
In 2 places, my lord, sale proclamation warrant has been affixed. Now, kindly peruse what order 21 rule 54(2) says, please. Even wide publicity is not given. This is my second ground. I may be permitted to read, my lords, order 21 rule 54 subclause 2.
Yes.
The order shall be proclaimed at some place. My lords, why I am reading order 21 rule 54(2) is order 21 rule 67 says sale proclamation shall be widely published as required under order 21 rule 54.
Yes.
That's why I'm reading my lords order 21 rule 54 2, please.
Yes.
The order shall be proclaimed at some place on or adjacent to such property by beat of drum or other customary mode, and a copy of order shall be affixed on a conspicuous part of the property.
Yes.
This is complied. And then upon a conspicuous part of the courthouse, this is also complied. No, next is not complied, please. And also where the property is land paying revenue to the government, in the office of collector of the district in which the land is situated, and where the property is land situated in the village, also in the office of Gram Panchayat, if any, having jurisdiction over that village. My lords, here is the case. Property falls within the ambit of, my lords, BBMP limits, please.
Yes. Yes.
In the office of BBMP, my lords, proclamation warrant is not affixed.
Yes.
Order 21, Rule 54, Clause 2 is also not complied.
Yes.
No, my lords, kindly peruse Order 21, Rule 84, please.
Yes.
Now, court has conducted auction. Court bailiff has conducted auction,
Yes.
and second respondent is declared as my lord's highest bidder. Kindly peruse, my lords, what he has done, please. Kindly peruse Order 21, Rule 84 for a moment, please. This is also not complied. My lords, as per your lordship, peruse the court bailiff's, my lords, minutes, wherein, my lords, it says, my lords, that second respondent is declared as highest bidder. I'll come to that point, my lord, please. Deposit by purchaser and resale on default.
Yes.
Clause 1, I am going to read, my lords, please. On every sale of immovable property, the person declared to be the purchaser shall pay immediately after such declaration a deposit of 25% on the amount of his purchase money to the officer. My lords, kindly note.
Yes.
To the officer, not to the court, or other person conducting the sale. And in default of such deposit, the property shall forthwith be resold. My lords, on 5/10/2023, auction was conducted by court bailiff. Second respondent is declared as, my lords, highest bidder. He did not deposit on the day. Order 21, Rule 84, Clause 1 says, whoever is a highest bidder, my lords,
Yes. Yes.
then and there he has to deposit 25% to the court bailiff.
Yes.
He did not do so. Please kindly turn to, my lords, page Annexure M for a moment, please.
Annexure.
Annexure M, page 167, my lords, please.
172.
167, my lords.
Yes.
27/10/2023, my lords, that is, sorry, 25/10/2023, 165, please. Sorry, please. My humble apologies.
Yes.
My lords, the typed copy of page 165, your lordship may find at page 188.
Yes.
DHR present
188.
188, please. This is the typed copy of, my lords, page 165. Order sheet. DHR present, my lords, this is court sale, 25/10.
Yes.
2023. 5/10, my lords, is the spot sale.
Yes.
25/10, my lords, is court sale. So,
Yes.
DHR present.
Yes.
Counsel for DHR, Shri so and so present. Highest bidder by name Amrit Kumar S. present. Amin of this court, so and so also present. As per
The highest bidder, same is confirmed through the court.
same is confirmed through the court.
Yes.
Your lordship may kindly appreciate confirmation can be done only pursuant to second respondent depositing entire amount.
Yes.
Till 25/10/2023, he did not pay even single pay.
Yes.
Court has confirmed the sale. Kindly appreciate, my lords. Now, the book doesn't stop here, please. Kindly peruse when he has paid the deposited 25% of the amount, please. 27/10.
Yes.
He was declared as highest bidder on 5/10.
Yes.
Deposited, my lords, on 27/10. That is exactly after 25 days.
Yes. No, it declared on 25/10.
5/10, my lords. Please.
25/10/23.
My lords, that is court sale. My lords, suppose today I am going to conduct auction. My lords, suppose 10 bidders are going to participate. Among them, one will be emerged as, my lords, highest bidder. Then it is court bailiff who will declare, my lords, that In the spot, he has to declare so and so person, my lords, is
No, that has been done when?
on 510.
510. No,
Court-
this is confirmation by. the court.
Confirmation by the court. He is declared as highest bidder on so and so date.
Yes.
My lords, 21 rule 84 says, my lords, on the
Yes.
spot, he has to pay 25%. Admittedly, that is also not done.
No, that on 2510 it is confirmed.
Confirmed.
25% of the total bid amount has to be deposited within 30 days. Again, time has been.
Again, time has been granted, my lords, please.
Remaining 75 has to be deposited.
My lords, kindly turn to next page, please.
Yes.
There, my lords, 189, typed copy, my lords. Shri Amrut Kumar bidder filed memo along with my lords DD on 2710. That is, my lords, 510 is the spot sale. 2710, my lords, he deposits 25% of the amount. No, 21 rule 84 is also not complied. Kindly peruse, my lords, order 21 rule 85 for a minute. At least let us analyze whether this has been complied by second respondent or not, please. Time for payment in full of purchase money.
Yes.
The full amount of purchase money payable shall be paid by the purchaser into court before the court closes on the 15th day
Yes.
from the sale of property.
Hmm.
My lords, there is a difference between order 21 rule 84 and 85, please. Suppose, my lords, on the day under 84, my lords, if my lords, he doesn't deposit 25% to the court bailiff then and there, then property has to be resold forthwith.
Yes.
No,
Yes.
here is a case, he did not deposit 25%. On top of it, my lords, he did not even deposit on the 15th day
Yes.
as required under order 21 rule 85. May I just pass on
Yes.
this judgment of Honorable Apex Court, please?
Yes.
My lords, may I just draw attention of your lordship for a moment on para 7.3 for a moment, please.
Yes.
Last but one page.
Yes.
My lords, Honorable Apex Court has cited my lords order 21 rule 84,
Yes. Yes.
64, 85, 86, and my lords kindly peruse what 7.4 says.
Yes.
As per order 21 rule 84, on every sale of immovable property, the person declared to be purchaser shall pay immediately after such declaration deposit of 25% on amount of his purchase money, and in default of such deposit, the property shall forthwith be resold.
Yes. That is what that provision says.
Please.
Yes.
Now, my lord, 7.5 I will not read.
Yes.
7.6 my lords, 7.5 my lords I will read. As per order 21 rule 85, the full amount of purchase money payable shall be my lords
But within 15 days.
within 15 days.
Plumber.
7.6 says, my lords, in the present case, admittedly, the purchaser, respondent number 1, deposited amount of rupee 25% of the amount on 3/11/21 and 2011 and did not deposit 25% of the amount as required under order 21 rule 84 immediately.
Yes.
The auction purchaser was required to deposit 25% of the amount the day on which he was declared purchaser, that is so and so date. Even the balance 75% of the amount has not been deposited as required under order 21 rule 85. The full amount of purchase money in the present case has been deposited on 4/11/2011 after the period prescribed provided under order 21 rule 85. Therefore, there is non-compliance of order 21 rule 84/85. Now, kindly peruse, my lords, para 88.3, please.
ಆಯ್ತು ಅದನ್ನ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ದುಡ್ಡು ವಾಪಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Absolutely, my lords, please. Now, kindly, my lords, peruse the list of citation which I have passed on before this honorable court on 23/8/2024, please.
On what point?
My lords, 21 rule 66. Our own High Court judgment, my lord, please.
Same, it is not complied, it has to be set aside and.
If property value is not estimated by the court, wide publicity is not given, then that is one of the ground for, my lord, setting aside the sale.
Yes.
Now, here is a case, my lords, on the initial, on the institution of this writ petition. On the first day of hearing, my lords, it was said that subject to outcome of writ petition, my lords, the sale certificate shall be issued in favor of second respondent. Therefore, my lords, my humble submission is, since there is non-compliance of 21 rule 66 and 54,
Yes.
let the sale be set aside.
Yes.
Please.
Yes, Mr. Please.
Lord, before getting into all these provisions read by my learned friend, Lord, let us read this judgment
in what perception a sale through the court in the execution proceedings has to be pursued. Lord, page number 219, paragraph number 9, last paragraph 9. Be it by receiver, last paragraph. From there it starts. May I read, Lord?
Yes, yes.
Be it by a receiver, commissioner, liquidator, or court, his principle must govern. This principle must govern. This proposition has been propounded in many rulings cited before us and summed up by the high courts. The expression material irregularity in the conduct of the sale must be benignantly construed to cover the climax act of the court accepting the highest bid. Indeed, under the civil procedure code, it is the court which conducts the sale and its duty to apply its mind to the material factors bearing on the reasonableness of the price offered is part of the process of obtaining a proper price in course of the sale. Therefore, failure to apply its mind to its aspect of the conduct of the sale may amount to material irregularity. Here, substantial injury without material irregularity is not enough, even as a material irregularity not linked directly to the inadequacy of the price is insufficient, and where the court mechanically conducts the sale or routinely signs assents to the sale papers, not bothering to see if the offer is too low and better price could have been obtained, and in fact the price is substantially inadequate. There is a presence of both the elements of irregularity and injury, but it is not as if the court should go on adjourning the sale till the good price is got, it being a notorious fact that the court sale and the market price are distant neighbors. Otherwise, decree holders can never get the property of the debtor sold, nor is it the right to judge the unfairness of the price by the hindsight wisdom, maybe subsequently events not within the ken of the executing court. When holding the sale may prove that had the sale been adjourned, a better price could have been had. What is expected of the judge is not to be a prophet, but the pragmatist and merely a make of realistic appraisal of the factors and satisfied that in the given circumstances, the bid is acceptable, conclude the sale. The court may consider the fair value of the property, the general economic trends, the large sum required to be produced by the bidder, the formation of a syndicate and the futility of postponement of the possibility of litigation, and several other factors depend on the facts of each case. Once that is done, the matter ends there. No speaking order is called for and no meticulous postmortem is proper if the court has fairly, even if silently, applied its mind to the relevant considerations before it while accepting the final bid. No probe in retrospect is permissible. Otherwise, a new threat to certainty of the court sales will be introduced. This is in this perception, my lord. Before getting into other citations, my lord, let me take your lordship through the order sheet. How fairly the court has conducted the proceedings of selling the property. It is for the mind of the executing court. If the court finds that, yes, this is fair, whatever the property price it has fetched, there are n number of bidders were there, wide publicity through the paper publication has been given, in the conspicuous part of the property has been affixed, the notification, the date has been fixed, time has been fixed, and in all throughout the proceedings, the judgment was present. And all the time, throughout the proceedings, the judgment letter has the very good opportunity to object for quoting of the sale price or the market price or anything as such. It is enunciated in Order 21 Rule 66 itself.
My lords, one humble submission, please. Paper publication is not given, please. Let my learned friend not to say that, please. No paper publication has been given. Let them not mislead, my lords, please. There's an order sheet before this court.
Yes. Yes, Mr. Continue.
Please. This is the way of misguiding the courts. Paper publication is there. And no, subsequently, that has been proclaimed in the, by publishing, by beating the drum of Tom Tom and etc. My lord, page number 171 may kindly come to, my lord.
Yes.
Last but one paragraph, my lord, page number 171.
Yes.
Last but one paragraph. As per the compromise, JDR agreed and promised to repay total amount of rupees 60 lakhs to the decree holder, but fails to repay the decretal amount after lapse of 4 months. Thereafter, they obtained 30 days grace period from remitting the said amount, but fails to pay the decretal amount. DHR took further steps for attachment of the suit property for recovery of the decretal amount. Accordingly, the court attached the suit property through the order dated so-and-so completed the attachment proceedings. Next paragraph, the court officials has visited the spot and Tom also done in the suit property. At that point of time, the JDR was present near the suit property and the JDR also present before the court on all the hearing dates. Though the order of the attachment, JDR fails to pay the decretal amount. As per the order dated order of the court, suit property has been attached and the sale warrant and sale proclamation issued on 13/4/2023. And the date fixed for spot sale on 5/6/2023 and the court sale on 20th June 2023. But due to some technical problem, court officials have not completed the process. Again, 20th of June 2023, this court has reissued the sale proclamation and sale warrant in respect of the suit property and fixed the date for spot sale on 19/8/2023 and the court sale on 30th August 2023. But the JDR intentionally avoided to appear before the spot. Whenever he has avoided to appear before the court, next, accordingly, in the presence of DHR and the presence of JDR, the staff of the court have completed the spot sale on the highest bidder by name Amrut Kumar as the highest bidder for an amount of rupees 1 crore 8 lakhs. Thereafter, on 25th of October 2023, case called out in the open court, DHR and his counsel, JDR and his counsel were present, and the highest bidder by name Amrut Kumar also present before the court. In the open court insisted to call the bidder, if any, but except Mr. Amrut Kumar, the other persons are not ready to bid the property. Accordingly, the presence in presence of the JDR and DHR, also highest bidder, Mr. Amrut Kumar, the court sale proceedings confirmed and completed for rupees 1 crore 8 lakhs.
Yes.
Till here, my lord, there is no objection raised, not even a whisper insofar as conducting the proceeding, the following up of the proceedings, etc., etc., etc. Order 21 Rule 66 may kindly be taken up, my lord, now.
Yes.
Order 66, Rule 1, my lord.
Yes.
Where any property is ordered to be sold by public auction in execution of the decree, the court shall cause a proclamation of the intended sale to be made in the language of such court. Such proclamation shall be drawn up after notice to the decree holder and the judgment debtor and shall state the time, place, and sale and specify fairly and accurately as possible. As much as possible, the court shall ensure that all these parameters are met.
Yes.
Time has been specified, paper publication has been given, proclamation has been given, tom-tom has been done.
Yes.
As far as possible,
Yes.
for the satisfaction of the court, there has been a role of discretion comes because the executing court running the litigation for the past 15 years.
Yes.
And what is the penury undergone by the decree holder has been seen by this court, the executing court.
Yes.
Therefore, for the satisfaction of the executing court, whatever is possible, as far as possible, all these things has to be met and published and in presence of the judgment debtor, everything has to be followed with.
Yes.
within 3 weeks, within 30 days.
Yes, that's all.
Please. And my lord, as far as publishing in the in front of the revenue office and all, my lord, what is the purpose for which publication of the proclamation in front of the revenue office is meant?
Yes. What is the purpose? 54.
21 rule 54 may kindly come to me.
Yes.
To avoid the sales when the attachment of the court is there, this purpose is, this provision is enunciated, my lord. Attachment of immovable property, 54(1), my lord, where the property is immovable, the attachment shall be made by the order prohibiting the judgment debtor from transferring or charging the property in any way and all persons from taking any benefit from such transfer or charge. It is for which purpose in front of the revenue office the affixing of the proclamation is expected. Here, order 21 rule 54 subclause 4, lord, as if it is a mandatory procedure. What is the purpose of this provision? According to the insight opinion of the court,
Yes.
For purposes of avoiding further sales, though there is an attachment, there should not be further sales. That is the purpose for which this provision is. This cannot be taken benefit, saying that it is a irregularity or material irregularity or kind of a thing.
Yes. Yes. 15.
Please. And the application on the grounds my friend is urging now under order 21 rule 90, when it can be urged? In the light of the judgment, what I have read to your lordship, my lord, in the light of that judgment, this provision has to be looked into, my lord. Order 21 rule 90, sub rule 3, my lord.
Yes.
No application to set aside a sale under this rule shall be entertained upon any ground which the applicant could have taken on or before the date of which the proclamation of the sale was drawn up.
Yes.
As far as the market value of the property,
Yes.
my friend has ample opportunity to bring it to the notice of the court before publishing the proclamation or before drawing up the publication. The judgment debtor could have taken an objection without quoting the market value of the property.
Yes. Yes.
Yes. Lord, as far as the irregularities insofar as the proclamation is concerned, till then, beating of drums, drawing up of the proclamation, issuance of the notification, fixing of the date, postponement of the date, or anything as such. Till then, whatever could have been taken by the judgment debtor could have taken by then.
Yes.
If he has not exhausted that opportunity,
Yes.
he cannot come roundabout and say that after lapse of 6 months, the decree holder is suffering for the past many years in the court to take back his money, though the judgment debtor has agreed before the court to pay the said amount within such and such a period.
Yes.
Even and irrespective of this, my lord, to urge the application under Order 21 Rule 90,
Yes.
under Section 127 of the Limitation Act, my lord, the time prescription is 30 days. Limitation Act 127 may kindly be seen, my lord. Limitation Act, my lord. Article 127, I'm sorry, my lord.
Yes.
To set aside the sale in execution of a decree, including any such application by a judgment debtor, earlier it was 60 days from the date of sale. And due to the amendment of the year 1977, my lord, it has become 30 days from the date of sale. What is the date of sale?
Yes. What is the date of sale?
25/10/2023.
23.
Please, ma'am. The application came to be filed on 30th of March 2024.
Yes.
It is of lapse of 6 months almost.
Yes.
There is no limitation at all, my lord. On that point, my lord, there are rulings. When there is no limitation for filing the said application, the other aspects need not be considered and need not be get into, is the ruling. My lord, may kindly be considered this ruling.
Yes.
Paragraph number 6, my lord.
Yes.
Yet another aspect to be considered in this regard, this point of limitation under Article 127 of the Limitation Act. Time is prescribed for filing an application seeking to set aside the sale. Obviously, that time has to be elapsed by now. What is now available, having been barred by limitation, cannot be permitted to be achieved indirectly, as it could be tantamount to circumvent the specific provisions incorporated in the statute in regard to thereto. Therefore, it is clear case where the judgment debtor, having not availed the remedies available either under Rule 89, 90 or 21 of the Civil Procedure Code, cannot now be permitted to achieve the same by maintaining this revision petition indirectly to set aside the sale. In my considered view, therefore, the present revision petition is misconceived and is not maintainable. And one more ruling, Lord.
Yes.
Relevant paragraph, my lord, in the page number, second page, paragraph number 5. The first submission raised by the counsel for the petitioner is that application filed by the judgment debtor under 21 Rule 90 of the Code of Civil Procedure was barred by time. There is no dispute that limitation for filing an application under Order 21 Rule 90 is 30 days. The trial court has recorded a finding that the sale was conducted on 20th August 1982 after following the procedure prescribed. The appellate court has observed that there was collusion between the decree holder, his relation to, the appellate court held that Article 127 of the Limitation Act 1963 would not apply. Hence, the application cannot be held to be barred by time. In the present case, the objection filed by the judgment debtor purporting to be under Order 21 Rule 90 Code of Civil Procedure praying for setting aside the sale. The sale was also confirmed on 1st December 1982. Before the trial court, both and auction purchaser appeared were cross-examined. Finding was recorded by the trial court that proclamation was duly issued. The trial court further held that under Order 21 Rule 66 of the valuation of the property was kept as rupees 50,000 and no objection was raised by the judgment debtor. Here also in the instant case also the same thing. As on the date of proclamation, the judgment debtor has ample opportunity to prescribe the price. Maybe as per the guideline value or market value, fancy value or fair value, whatever he feels good. Before that date, he could have, the same scenario has happened in this ruling also. The action, it is clear that 7 persons have participated in the bid and also, and last bid was of Chandrapal. The trial court further held that there was no violation of Order 21 Rule 72 since prohibition was only against the decree holder. The sale having been placed and the objection having been filed by the judgment debtor, the sale at the best could have been said to be viable, capable of best being set aside on the grounds as mentioned under Order 21 Rule 90, the Code of Civil Procedure. The sale which requires to be set aside under Order 21 Rule 90 of the Code of Civil Procedure cannot be said to be void, nor there are any facts in the present case on the basis of which it can be contended that the sale was void. The sale being voidable, Article 127 of the Limitation Act shall be fully applicable and application having not been filed within 60 days was rightly held to be observed that if the sale is one which has under the law to be set aside under Order 21 Rule 99, Article 166 of the shall apply. Old Act 166 shall apply. New Act that is Article 127. It was held by Article 166 of the old act shall be applicable only when the sale is imperative and void. Apex Court observes in the paragraph number so and so. Coming to next Article 166, application by the judgment debtor to set aside the sale, execution of the decree has under the article to be filed within 30 days of the sale. If the present proceedings are governing by the article, when there is an authority, Article 166, only when the sale is on which one which has under the law to be set aside, as for example under Order 21 Rule 89, 90 and 91, but that it has no application when the sale is inoperative and void. The application of the judgment debtor having been found barred by time, it is not necessary to consider other submissions raised by the counsel for the petitioner.
Yes.
And for making payment, my lord, Order 21 Rule 84, there is a relaxation depending on the procedure followed in a particular region.
Yes.
In paragraph number 28, my lord.
Yes.
The findings, page number.
Regarding what point?
My friend was canvassing on Order 21 Rule 84. Within 24 hours of the finalization of the bid, one should have deposited the amount. When the finalization of the bid occurs is, before that, my lord, Rule 138 of Karnataka Civil Rules may kindly be seen.
Yes.
Rule 138, sale of immobile property shall ordinarily take place at the spot, subject to the condition that the final bid shall be offered before the presiding officer at the courthouse. This rule is prevailing in the state of Karnataka. Subject to, here, this component of this rule is very important.
Yes.
Sale of immobile property shall ordinarily take place at the spot, subject to the condition that the final bid shall be offered before the presiding officer of the court.
Yes.
Only in the presence of the court, in presence of the presiding officer, the sale will be confirmed.
Yes.
Final bid will be offered. This is what the procedure. This is what the rule to conduct the sale. And the 24 hours of time limitation as per Order 21 Rule 84 runs from that time.
Yes.
When the sale confirmation in front of the presiding officer happens, from then within 24 hours, Order 21 Rule 84 plays a role. For a moment, my lord,
Yes.
sale confirmation, my friend has already read the provision, the order sheet, my lord, page number 188.
Yes.
Page number 187, the date finds in the last left-hand side, my lord, 25th of October 2023. In presence of the next page, my lord.
25th, 10/2023.
Please, my lord. The order sheet runs in the next page.
Yes.
DHR present, counsel for the DHR Sri VHA present, highest bidder by name Amrut Kumar S present. Amin of this court, Vasant Kumar also present. As per action papers, one Amrut Kumar is the highest bidder for rupees 1 crore 8 lakhs.
Yes.
Of SSP. The same is confirmed through court sale. Accordingly, Amrut Kumar has to deposit 27 lakhs. That is 25% of the total bid amount has to deposit within 30th of October 23 and remaining 75% of the balance has to deposit within 30 days from this day.
Yes.
This is the order of the court, my lord. As per this order, my lord may kindly come to the handwritten order sheet when the deposit has been done to the court. Page number 167 may kindly come to me.
Yes. Yes.
Page number 167 may kindly come to me. On the left-hand side, office note, my lord, 27th October.
67.
167. Office note, Sri Amrut Kumar, the bidder filed a memo along with DD bearing number so-and-so dated 26/10/2023. October was the date when the sale was confirmed. DD bearing number so-and-so dated 26/10/2023
Yes.
for an amount of rupees 27 lakhs of HDFC Bank along with the copy of the Aadhaar card.
Yes.
Please, my lord. The next day it has been deposited.
Yes.
And the remaining amount, lord, Order 21 Rule 84 is complied with. Next, my lord, the page number 188, fixing the date for payment of 75% of the balance bid amount was before 30th of October.
Yes.
Before 30th of October. The amount, the remaining amount of 81 lakhs, my lord, page number 168.
Yes.
Page number 168, my lord.
Within 30 days, you have done it.
Yes, my lord.
Yes.
168, bottom on the left-hand side, office note, my lord. 23rd of November.
Yes. Yes,
Within 30 days, my lord, it has been deposited.
yes.
Received DDA from HDFC Bank bearing number so and so dated 21/11/2003 for an amount of rupees 81 lakhs.
Yes.
Wide RR number, RO number, receipt order number dated so and so sent to SBI for clearance.
Yes.
Or 21 Rule 85 also has been complied with. Or 21 Rule 85 specifies 15 days from the date of confirmation of the sale. For which, my lord, ruling? For which, my lord, the prevailing procedure as per the court orders, when the challan is issued, from then, once the court challan issues, within that date and from the date of court challan, within 30 days is the procedure prevailed in the region.
Yes.
Please, ma'am. In this ruling, Lord, the third page, paragraph number 6, the relevant portion starts, my lord.
Yes.
It is clear that these rules insist on a challan being obtained before a payment could be made into court. Without a challan, a deposit could not be made. Even the sale is confirmed, the court, if does not permit the bidder to make the payment, the bidder cannot make payment. Thus, this is the first step in the process of making the deposit. If the court does not issue the challan in spite of the application for it by the party before the expiry of the prescribed period, he is not in opposition to fulfill the obligation cast by Rule 85. So, non-observance of the terms of Rule 85 is not due to any default or negligence on his part, but due to causes beyond his control. It is the inaction on the erroneous act of the court that is responsible for the inability.
That is in spite of your application.
In spite of my application.
If you are made any effort, then it's.
No. Once the confirmation of bid is done, as on the spot, my lord, the court has confirmed and given the challan, means issued the dates, prescription for scheduling the dates for payment of 25% and 75%.
Yes.
Further, my lord, the last conclusion paragraph number 20, my lord. We are not inclined to agree with the contention of the learned counsel for the appellant that the default should be attributable to the negligence of the party and was not occasioned by the inaction of the court, since it was open so party to have applied much earlier for challan and could not insist on its being given to him by as enable him to make the payment in time. In so, it is no argument to say that had been diligent in applying for the challan long before, he could have obtained one and would have been in a position to comply with the requirements of the rule. A party expects a court to be diligent in the dispatch of its business and not to be inactive. If really a party is disabled to perform the obligations owing to an act of the court, he should not be made to suffer the penal consequences following from the non-performance thereof. ಇಲ್ಲಿ ಕೋರ್ಟು 25% ಡೆಪಾಸಿಟ್ ಮಾಡೋದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಶೆಡ್ಯೂಲ್ ಮಾಡುತ್ತೆ ಅಂಡ್ 75% ಮಾಡೋದಕ್ಕೂ ಕೂಡ ಶೆಡ್ಯೂಲ್ ಮಾಡುತ್ತೆ. ಇನ್ ದಟ್ ಕೇಸ್, ಮೈ ಲಾರ್ಡ್, it is absolute compliance of Order 21 Rule 84 and 85.
Yes.
And before proclamation, whatever could have been taken, the contentions, the objections by the judgment debtor, it could not have been raised at the later point of time. As far as the quoting of the guideline value or market value or fancy price or fair price or anything as such, the judgment debtor could have been supplied to the court or the court officer within time. Those objections, my lord, cannot be urged at the later point of time. And the Order 21 Rule 90 application is hopelessly time barred. Under those circumstances, my lord, when the application could not have filed at the later point of time, since it has been time barred, and other contentions cannot be considered. Even in case of getting into consideration of all these factors, all these prescribed rulings has to be taken into account. And in the light of the first judgment, my lord, I have read it to your lordship. The judgment, the decree holder cannot see the light of the result of the litigation. If this kind of attitude is allowed to be continued for years together, the judgment and the compromise decree, my lord, is of the year 2019. From then, the judgment, the decree holder is suffering to get back his money. In that count of the my lord, it is a total misguiding before your lordship. I have produced the paper publication as well as this thing proclamation has been done in the spot, as well as tom-tom has been done, and I have produced all those papers are before your lordship. Yes, please, madam. Along with the statement of objections, we have produced, madam.
Yes.
ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಿ ತಗೊಳ್ಳಿ ಇನ್ನೊಂದು ಕಾಪಿ ತಗೊಳ್ಳಿ ಒಂದು ಕಾಪಿ
Yes. What do you want to show?
But the copies of the paper publication and proclamation has been affixed in the conspicuous part of the property, the photographs and the paper publication cuttings.
Yes.
Paper publication is an option.
Yes.
Please.
Mandatory.
Yes. And also tom-tom, such a big publication, my lord, page number 5.
Yes.
Last but one photograph, my lord.
Yes.
Tom-tom having been done.
Yes, yes.
Please.
Yes.
No irregularity at any stage of the proceedings, my lord, and the very ruling relied upon by my learned friend, my lord, paragraph number 15. Highlights. Deshbandhu Gupta, my lord. May I be permitted to produce one more copy of it?
He has relied on only that 2023 recent judgment.
Not only that, my lords, on 23/8/24, I have filed list of citation, please.
One more copy I may be permitted to supply, my lord. Instead of searching in the bundle.
Limitation ಬಗ್ಗೆ.
Paragraph number 15, my lord, page number 148, internal page. 10th line.
Yes.
At the same time, the court should not go on adjourning the sale.
Para 15.
Para 15, my lord. Para 15, page number 148, my lord. Page number 148.
47 ಇದೆಯಲ್ಲ 15.
147 ಅಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ, 148 ಅಲ್ಲಿ ರಿಲೆವೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. 148 ಅಲ್ಲಿ 9th line ಕೋರ್ಟ್ ಅಂತ ಇಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ ಸ್ವಾಮಿ. At the outside. At the same time, the court should not go on adjourning the same till the good price is got. Or otherwise, the decree holder would never get the property of the judgment debtor sold. This court further held that there is always considerable difference between the court sale price and the market price. The court sale is a forced sale, and notwithstanding the competitive element of the public auction, the best
I
price.
think same judgment which you have relied on.
Please, my lord.
is extracted.
Yes, please, my lord. In this, a step further, my lord, other findings, my lord, from bottom 5th line, my lord. The court may consider the fair value of the property, the general economic trend, the large sum required to be produced by the court bidder, the formation of a syndicate and the futility of the postponement of the possibility of the litigation and several other factors depending on the facts of each case. If the court has fairly applied its mind upon going through all these things, my lord, whether the court has cherished this fairness or what, is reflecting fairly applied its mind to the relevant considerations while accepting the final bid. It is not necessary to give a speaking order, nor can its order be examined meticulously.
Yes. Yes.
Therefore, my lord, there is no irregularity, considerable irregularity appears
Yes.
on the record. Under these circumstances, my lord, whatever the sale has held, it is in accordance with the law. And more importantly, the application is barred by law of limitation.
Yes, Mr.
Therefore, my lord,
My lords, with humble submission, kindly peruse when I have filed application, please. 31/3/2024.
Okay.
I'm speaking on limitation, please.
No,
I'll-
I will give the time because I have not touched that other matter also.
Please, sorry. my-
See limitation,
Please.
then other point, when you are present, we have any option to raise that objection at any time.
Please, my lord.
And that civil rules of practice, this all you have to be replied.
I'll read order 21, rule 89, rule 90, when sale will become absolute as per order 21, rule 92.
Yes.
Whether my application is barred by limitation or not, I'll meet all those points, please.
We'll have it on second. Second.
Please, my lords.
Yes, second.
second, fourth, or fifth, my kindly.
Yes, fourth, fifth Rajala, fourth.
Fourth.
Yes, fourth.
Please, my lords.
Public.
Yes.
Interim order may be extended, please.
Yes, interim order granted, this court will extend till next date of hearing.
Great.
First order, yeah. Correct.
First or matter. Serial number 1, Balraj AC. First or matter, serial number 1, Balraj AC.
Comply ಮಾಡಿದ್ದಾರೆ. Comply ಆಗಿದೆ. Yes, sir.
Senior Counsel DR Ravi Shankar.
Yes,
On his
next,
legs.
day after tomorrow.
Plus nominal. It's urgency, my lord.
Yes, next. Tomorrow ಇಲ್ಲ, Monday,
Sir.
Tuesday.
Plus, tomorrow, ma'am, because,
Tomorrow list is out, yes.
no, sir, because on the second is this thing, my lord. Tomorrow, my lord, please.
Tomorrow
Please.
ಇಲ್ಲ, Monday, yes, Tuesday.
My lord, please, my lord.
20,
My lord, the matter is on Tuesday itself there, before that.
What to do, mister? You want that I have to come there and argue?
No, no.
What is this? Yes,
Serial number 20, Pawan Shamje.
yes. Yes, mister.
Case wherein, my lords, I'm a petitioner, I'm a delinquent trustee, my lords.
Yes,
I was subject to internal inquiry, my lords, by the committee of the trustees.
yes.
Now, my lords, I had filed an application, a suit in OS, my lords, alleging bias and prejudice by the inquiry officer, my lords. I had made out a certain case in the plaint, my lords. However, the impugned order at Annexure K came to be passed, wherein the learned trial court did not give any finding, but just boldly said that
You are a plaintiff,
plaintiff, my lords.
suit for,
My lords, my lords.
Lords, as a suit for injunction.
yes.
Lords, plaintiff, my lords, is a trustee. If my lords may kindly see the cost title for a moment, my lords. Respondent number 1, my lords, is a trust.
Yes.
Runs several educational institutions, including Ambedkar Institute of Technology.
No,
which
this,
has-
where is that plaint?
Lords,
plaint-
plaint is at,
No, that plaintiff is a trustee.
Lords, plaintiff is a trustee of the respondent number 1 trust.
No, plaintiff is not trustee. Plaintiff is B.N. Umesh.
Please, my lords, he is one of the trustees. The other trustees are respondent number 2 to respondent number 5.
Yes,
Lords, they have instituted under the trustee, for the removal of the trustee, there is a provision, my lords, where you can hold an inquiry
yes.
against the trustee. Initially, my lords, the suspension order was passed illegally. As against that, my lords, we approached the civil court. Civil court, my lords, passed an interim order of injunction. I continued. Thereafter, my lords, they have appointed an inquiry officer who is respondent number 6 to inquire, my lords, into certain charges against me.
Yes.
Now, my lords, respondent number 6, my lords, is a retired district judge.
Hmm.
He is also an inquiry officer who has been appointed.
Hmm.
Now, my lords, he is actively involved, my lords, in the affairs of the society, because I am also, my lords, part of the managing committee. So therefore, my lords, we filed an application seeking for his recusal.
Yes.
he has recused from the matter. Page number 34 is his order of recusal, and my lords 36 is the typed copy.
Yes.
He recuses.
Hmm.
And my lords, afterwards, my lords, the trust again appoints him as inquiry officer. They have to appoint a substitute inquiry officer. So therefore, my lords, I have approached the civil court seeking for an injunction notice not to continue the inquiry proceedings with the same inquiry officer, but my lords to appoint a substitute inquiry officer.
Hmm.
So now, my lords, we had filed an injunction application, my lords, because the inquiry was being proceeded against.
Now, where is the plaint?
My lords, plaint is at page 49, my lords.
Yes.
My lords, the prayer, it starts at page 49. I'm sorry, my lords, at page 50. Prayer is at page 60, my lords.
Yes.
May I read the prayer, my lords?
Yes.
Pass an order of permanent injunction restraining the defendants or any other person acting through the defendants, restraining further conduct of inquiry proceedings by Mr. So-and-so, inquiry officer appointed through letter dated so-and-so, vide document number 5. Pass an order for directing respondents 1 to 5, kindly note this, my lords, to appoint an independent and impartial inquiry officer for conducting inquiry proceedings.
Yes. Now that, what is that order you are challenging here?
No, my lords, ex parte interim order was sought. My lords, the court heard the matter, and my lords, that is order is at page number 78. And my lords, after ex parte interim injunction has been rejected,
Where is that?
page 78, my lords, bottom of the page.
Yes.
This suit is filed by the plaintiffs for permanent injunction, restraining the defendants from further conduct of inquiry proceedings by Mr. M. Ramchandra, inquiry officer, appointed through the letter dated so-and-so. The plaintiff has filed application under order 39 rule 1 and 2, read with seeking ad interim order of temporary injunction restraining the defendants from proceeding with the inquiry scheduled on 1/3/2025 by current inquiry officer, whose defendant number 6 pending disposal of suit. Heard learned counsel for the plaintiff and peruse the plaintiff government's own statement and also documents. Counsel for the plaintiff also filed short notes dated so-and-so, which does not bear a signature. After considering the facts and circumstances, I am of the view at this stage, there is no prima facie case made out by the plaintiff to grant order of ex parte temporary injunction, hence issue suit summons. Now, my lords, my case is this.
If inquiry is completed, then suit is becoming.
Not only that, I have filed an application to recuse. He recuses. You cannot appoint an officer who has recused himself. The recusal, my lords, order, kindly see, my lords, is at page 34.
Yes.
At 36.
Heard. Issue notice. What is the say you have sought?
My lords, suit is there tomorrow, my lords.
Let them inquire. If they want to substitute that other inquiry officer, let them go. That is what your prayer.
No, my lords, I want it substituted, but same inquiry officer is continuing now.
No, now we will clarify that.
Please, my lords.
Further proceedings by inquiry by that so-and-so. If that defendant wants, they can appoint another inquiry
Please,
officer.
my lords,
The
may make
suit
that
itself
up.
be also be-
Please, my lords, suit itself is
Or stay of the further inquiry conducted by inquiry, further inquiry
by the
proceedings by, he has been made as a party,
Please, my lords, respond number 6.
respondent number 6. He state, this order will not come in the way of that. Who is that disciplinary authority? Who is?
My lords, defendant number, respond number 1.
Respondent number 1 will not come in the way of the respondent number 1 to appoint any other inquiry officer and to proceed inquiry
Yes, grateful.
in accordance with. Yes.
Office objection complaint.
Yes, submission is accepted. Office objection is complete.
Appeal number 1 pass, sorry.
Yes, wait, Mr.
Please,
Yes.
I'll-
Sure, Madam. First one, yes.
Serial number 39, Manmohan PN. Saramaya.
In this matter. Its third respondent is minutes as zonal officer of the Mysore City Corporation. It's Gaurav, Mr. Gaurav APS for the second respondent. There is a city
Sure,
corporation.
appears to the
I may be
respondent number 2.
permitted to serve a copy on him itself. In
Yes.
respect of third respondent,
Third respondent, yaar
zonal officer minutes of the Mysore City Corporation.
who is there?
It's an official of the
Minutes, it's
respondent number
not
2.
served.
corporation,
I may
my lord.
permit to serve on him.
I will take notice, my lord.
We will take notice, Mr. Two
Please.
Two, he has already entered appearance minutes, only in respect of third respondent.
So and so is undertake to appear for respondent number 3. Yes, 21.
Minutes, can it be on second, third, there is a matter minutes. Second minutes, there's some urgency in the matter.
Second,
Please,
yes.
minutes may make one request minutes. Can it be on my lords for orders regarding consideration of my interim prayer?
No,
my
it
lords?
will be there in all stage, mister. I can't alter the stage and all. Otherwise,
please.
in all matters, everybody started telling that it should be in preliminary hearing orders and all.
My request, my lords, that's all.
No, wherever there, I will
Please.
try to reach. If it is
Please.
reached, you argue, I will pass an order. That's all.
Public.
Yes.
For 40 KK Vasan for petitioner MS
But in
Narasimha.
this case,
Yes.
the application may be
Hmm.
not pressed, dismissed and not pressed. But only direction to the respondent to cross-examine PW1.
Rectification of the office objection.
ಅದು ಇದಾಕಿದ್ದಾರೆ application, that application not maintained because the matter is not, rule is not issued. The only prayer in this, my lord, the application filed by the defendant
Hmm.
to recall PW1 was came to be allowed.
Hmm.
And that has been questioned in this petition. The lordship may direct the respondent to cross-examine PW1 on next date of hearing, my lord.
No, what is that order you are challenging?
That is order is at page 15, my lord,
Page,
15.
what is the suit for?
Suit for injunction,
Hmm.
the plaintiff was examined, examining chief in the year 2022. They have taken 5 adjournment, they did not
The
cross-examine.
hearing for other side.
The other side is, my lord, is not represented.
MS Narasimha serial number
Narasimha
40.
ಅಂತ ಇದಾರಲ್ಲ ಯಾರು?
Narasimha, ನಾನು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
Hmm.
Only just direction to the trial courts saying that the respondent to cross-examine PW1.
The suit for,
Suit for permanent injunction.
you are the plaintiff or a
I am
defendant?
the plaintiff.
You are the plaintiff.
Yes, my lord.
Hmm.
The PW1 was examined on 1/4/2022.
Hmm.
Thereafter, they cross-examined on 3/6/2022.
Hmm.
Again, 14/10/2022. Thereafter, they went on filing 3 or 4 applications to recall the PW1 and they did not actually proceed with the further cross-examination. Now the case is posted to 4/4. The
Hmm.
lordship may direct the respondent to cross-examine PW1 on 4/4.
No, now that ಪ್ರತಿವಾದಿ ವಕೀಲ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ 13
ಮಾಡಿದ್ದಾರೆ, ಅಲೋ ಮಾಡಿದ್ದಾರಾ?
ಅವ್ರದ್ದು ಪರ್ಮಿಷನ್ ಅನ್ನ ಅಲೋ ಮಾಡಿರೋದು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಚಾಲನೆ ಮಾಡಿದ್ವಿ. I don't stand on the formality, only direction.
Yes. When next date is fixed?
4/4.
4/4. 4/4, you have to be present before that
Yes,
PW1
yes,
case.
yes.
In this writ petition, petitioner plaintiff has called in question order dated 6/3/2024 passed by 17th Additional City Civil and Session Judge Bangalore in OS number 4789 of 2020, whereby IA number 13 and 14 filed by the defendant for recalling. What are that application, mister?
Third application.
ಎರಡು application ಏನು?
Recall, reopening and recalling.
Reopening and recalling that evidence of PW1. Learned counsel appearing for the petitioner plaintiff outside submits that he will not press the writ petition and he sought only direction to that defendant to cross-examine that
PW1
in next date of hearing, that is on
4/4/2025.
on 4/4.
2025.
2025, on that day, PW1 will present before the court. In view of the above writ petition is disposed of. The respondent defendant is directed to cross-examine that PW1, further examine as PW1 on 4/4.
2025 or complete the cross-examination within certain period. That may be also.
2025, the directed to, now complete ಅಂತಂದ್ರೆ ನೀವು present ಆಗ್ಬೇಕಲ್ಲ.
Present is 3.
On 4th,
4/4.
4/4 or further date, next date, or further date fixed by that trial court without taking any further adjournment. Yes. With that observation, writ petition disposed of.
Pending application.
All pending applications are disposed.
Serial number 41, Shankar Narayana Bhatt fee for petitioner. We have
This matter I pay for petitioner, my lords.
Hmm.
The petition itself is infructuous, my lords.
Yes,
Kindly
Learned-
please come to the annexure A, my lords.
ಆಯ್ತು, ನೀವು infractions ಅಂದ್ಮೇಲೆ ಆಯ್ತು ಮುಗಿತು.
Please, my lords.
Learned counsel for the petitioner ತಾನೆ?
My lords, kindly direct to the trial court, my lords, to dispose this matter, my lords.
Learned
The lease
counsel for
period
the
is
petitioner
completed,
submits
my
that.
lords.
In view of subsequent event, the writ petition become infructuous. Accordingly, the writ petition dismissed as infructuous. The trial court is directed to dispose of the suit as expeditiously as possible.
Please, my lords.
Seal number 42 adjourned, seal number 43 Suraj Sampath for petitioner, Kiran Viran.
This is the matter senior
Respondents-
mentioned at 1:30, my lord.
My lord, there is an
A-
interim order operating against me, my lord. I
That's
filed
there
an
for
IF for
two
vacating the
years,
stay.
my lord.
My
2
lord,
ವರ್ಷದಿಂದ ಇದೆ.
ಇಲ್ಲ, ಇವಾಗೆ.
July
My-
23
my
ಇಂದ
lord,
there is an
this-
interim order.
No, that you are appearing for whom? Define-
I'm for the petitioners, for the petition, plaintiff.
You are the petitioner.
I'm the plaintiff.
Yes, now you have filed an application for vacating.
Please, my lord.
Because
My
they
lord, just
filed
two-
some application also, they have not served me. IA 1 of 25.
That is for early hearing. We will serve a copy of them. My lord. It's only for early hearing.
No, there is no question of early hearing. It is not yet admitted. Only for application for vacating. You are
Please, my
ready?
lord. Please, my lord.
You are ready?
Yes, my lord.
Yes.
Any
My
date
lord,
may be
this
fixed.
is for injunction, my lord.
Hmm.
It's only a bare injunction. They don't even seek a specific
I've sought for
performance.
mandatory injunction also.
Now, which is that next date you want? Now that
Uh,
time is over.
It can be had anytime next week, my lord, third or fourth.
April
whatever
9th,
convenient.
senior had requested, my lord.
Third or fourth?
Third or
Alla,
fourth. my
9th ಗೆ senior had requested. 9th of April.
What will be that fourth? Ninth, why ninth?
Alla, because the,
That, mister, you are enjoying that interim prayer there.
alla, there is two aspects. One, I have an interim order here for 2 years. ಇವಾಗೇನು urgency
lord. Lord,
ಅಂತ.
first for 3 years, they didn't have an interim order.
ಅಲ್ಲ, second aspect is ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ they have an interim order against them for the same property for 3 years. They filed an MFA before my lords.
Concerned with, now there is a stay, there is a vacating.
I understand.
Say that
Allah, there is another interim order in another matter operating against them for the same property.
Request of petitioner. Is this matter on ninth
Interim order may kindly be extended.
petition that he should not seek any further.
Please.
Please, my lord, because both the courts below two concurrent
Interim order
findings.
Interim order kindly extended.
Till next date.
Please.
Seal number 44 PP Raju.
Compliance affidavit ಹಾಕ್ತಾ ಇದೀನಿ.
Yes.
ನೋಟಿಸ್ ಸರ್ವ್ ಆನ್ ದ ಆಪೋಸಿಟ್ ಸೈಡ್ ಅಂತಿತ್ತು.
ಹ್ಮ್.
ಸರ್ವ್ ಮಾಡಿದ್ದೆ. ಮುಂಚೆ ಇದ್ದ ಪ್ರಭಾಕರ್ ಶಾಸ್ತ್ರಿ ಸಾಹೇಬರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಫಿಡವಿಟ್ ಹಾಕು ಅಂತ ಹೇಳಿದ್ರು.
ಹ್ಮ್.
ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾ
No,
ಇದ್ದೀನಿ.
you have served to that party or council.
ಕೌನ್ಸಿಲ್
Council service ಹೆಂಗ್ ತಗೊಳೋದು? Which
ಇಲ್ಲ, ಅದು,
only hand summons ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ಆನ್ ದಿ ಅಡ್ವೊಕೇಟ್
Service to that advocate is not a service. ಎಲ್ಲಿದೆ? ನಾವೇನು ಇನ್ನೂ ರೂಲ್ ಆತರ ಮಾಡಿಲ್ಲ like ಸದ್ಯ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್
Pending matter ಕೂಡ so far there is no rule that if it can be served to
My
the
lord, I will take it out, my lord. I'll take it out.
hand summons ತಗೊಳ್ಳಿ.
ತಗೊಂತೀನಿ ಸುಮ್ನೆ.
Yes.
My lord, in the meantime, first petitioner is demised. Application ಒಂದು ಹಾಕಿದ್ದೀನಿ, that may be allowed.
Petitioner is demised.
First petitioner.
ಒಬ್ಬರೇ ಇರೋದು. First time.
ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ ಒಬ್ಬರೇ petitioner ಇರೋದು.
ಹೌದು,
ಈ petitioner is dead.
ಹೌದು.
Yes.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ, that may be allowed. I'll carry out the amendment.
Where is that IA?
IA 1.
IA is filed on 20.
IA 1 of 2024 is filed for condonation of delay of filing an LR application to bring LR of petitioner. Deceased petitioner one ಒಬ್ಬರೇ ಇದ್ದಾರೆ. For the reason stated in that accompanying affidavit. LRC ವಕಾಲತಿ ಹಾಕಿಲ್ಲಲ್ಲ ನೀವು?
Along with the amended petition, ಒಟ್ಟಿಗೆ ಹಾಕ್ತೀನಿ.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇದೆ.
Yes. PB Raju undertakes to appear for LRs of petitioner for the reason stated in that accompanying affidavit. Delay in filing LR application is condoned. IA 1 of 2024 is allowed. Consequently, 2 of 2024 is allowed. IA 3 of 2024 is allowed. LRs of petitioners are permitted to come on record. Counsel for the petitioner is permitted to amend the custody. Petitioner is permitted to take out hand summons to the respondent.
Kindly call it, cases on 5th. Kindly call it on 3rd, my lord. ಅಷ್ಟೊತ್ತಿಗೆ ಮಾಡ್ಬಿಟ್ಟು.
No, you serve and move that matter. Yes, you amend it first.
ಮಾಡ್ತೀನಿ ಈಗಲೇ.
Yes.
Seal number 45 Jagadish TC for petitioner.
Memo for dismissal.
The parties have settled the dispute between themselves.
Yes,
I have for this memo for it.
dismissed as withdrawn.
File ಮಾಡಿದ್ದಾರೆ.
Yes,
Seal number 46 disposed of.
Appearing,
yes,
no objections.
yes. 46 dispose ಆಗಿದೆಯಲ್ಲ, memo of withdrawn ಆಗಿದೆ. Fast work ಮಾಡಿ. ಅದು ಒಂದಿತ್ತಲ್ಲ fast. ಅಲ್ಲ ಹೌದು, first matter.
Serial number 47, my lord.
Hmm.
Direction to the trial court, my lord, to dispose of IA filed under order 12 rule 6.
Only disposal.
Please, madam, for disposal of the IA, my lord.
Last file.
Yes.
IA was
Really?
filed in the year
They filed
2018.
The
response-
the dependent petitioner herein is filed a statement claiming a counterclaim
On the same day, he also filed an application under 12 Rule 6. Now, the pleadings are complete for court below. Your lordship can direct the trial court dispose of the entire suit itself.
No, application,
ಅಲ್ಲ counter claim ಕೇಳ್ತಾರಲ್ಲ, he is claiming a counter claim in
no,
my
what is
suit.
that application he wants to dispose?
Article 6 ಅಲ್ಲಿ partial decree ಮಾಡಿದ್ದು Article Rule 6 ಅಲ್ಲಿ.
Order?
Article Rule 6 filed by the petitioner herein.
Lord, suit is one
That my
for
suit for declaration.
declaration and
ಆಯ್ತು,
permanent
ಯಾರೋ
injunction.
ಒಬ್ರು ಹೇಳಿ.
My lord, suit is for declaration and permanent injunction, my lord, in which, my lord, the defendant appears and files a counterclaim and also files an application under 12 Rule 6 for judgment on admission. There is a clear unequivocal admission on the part of the plaintiff, my lord, and for that counterclaim also.
No, you are the defendant or
Defendant, and I have filed a counterclaim also. My lord, therefore, I have filed an application under 12 Rule 6. That application was filed in the year 2018, my lord. Till now, my lord, till today, the application is not decided. Therefore, I have sought for a direction to the trial court to decide that application on merits. Other than that, my lord, I have not sought for any prayer in this writ petition, my lord.
It's my suit for declaration, declaring that I am absolute owner and restrain the petitioner therein, the dependent therein, not to intervene in possession of the property. He appeared before the court below, my lord, he filed a statement claiming a counterclaim. On the same day, he filed application under 12 Rule 6. There is no admission in so far as plaintiff is concerned.
ಅದನ್ನ
ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನಾನು ಹೇಳೋದು 12 Rule 6 ಆಗ್ತಿದ್ದ ಸೇಮ್ ಡೇನೆ ಈ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಕೌಂಟರ್ ಕ್ಲೈಮ್ claiming counter claim in respect of my property is concerned. Now the court has to decide the issue regarding counter claim as well as my declaratory. Instead of Article Rule 6, merits ಮೇಲೆ pleadings complete ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಅದಕ್ಕೆ Article Rule 6 ಮತ್ತೆ ಏನಕ್ಕೆ ಮತ್ತೆ?
ಅದನ್ನ ಬೇಕಾಗಿಲ್ಲ, ಅದನ್ನ that's what
Order 12 Rule 6 ಯಾಕೆ legislators has put it before going to the trial.
The same day,
there is an admission.
kindly appreciate the same day when the statement is filed a counter claim, he filed also application under 12 Rule 6.
ಏನಾರ ಫೈಲ್ ಮಾಡಿ.
ನಾನು ಹೇಳೋದು instead of considering the application, enter suit may be disposed upon merits. I will cooperate the day by day proceedings.
That Order 12 Rule 6 provision has been made to avoid the trial. If it is admission, it has to be closed. It.
I do agree. There is no dispute about it. Here, he claims a counter claim the same day.
ಏನಕ್ಕಾರ ಆಗ್ಲಿ, ಅದನ್ನ ಬರೋದಿಲ್ಲ ಅಂತಂದ್ರೆ ವಜಾ ಮಾಡ್ಲಿ ಅವ್ರು.
ನಾನು ಹೇಳೋದು IML ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿ ಅದಕ್ಕೆ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಆರ್ಡರ್ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಕ್ಚುಲಿ ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ರಿಸರ್ವ್ ಆಯ್ತು ಆರ್ಡರ್ಸ್ಗೆ ಇವ್ ಲಾರ್ಡ್ಶಿಪ್
IML ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಡಿಲೇ ಆಗುತ್ತೆ, ಕಾನೂನಲ್ಲಿ ಫೈನಲೇ ಮಾಡ್ಬೇಕಂತ ಏನಾರು ಇದ್ರೆ
ಅಲ್ಲ ಅವ್ರು ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಲಾರ್ಡ್ಶಿಪ್ ಮಕ್ಕಳು ಟರ್ನ್ ಪೇಜ್ 64
ಅಪ್ಲಿಕೇಶನ್ ವಿಲ್ ಬಿ ವಾಟರ್ ಡೌನ್ ಮಿಸ್ಟರ್.
ಅಲ್ಲ ಪೇಜ್ 64 ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ ಆಮೇಲೆ ಈ ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ 6 Rule 17 ಇಟ್ಸ್ ನಾಟ್ the defect on the part of the trial court to dispose the application as such. Instead of arguing the matter is filed an application under 6 Rule 17. You lordship kindly turn on to the application. Court trial court ದಲ್ಲಿ ಏನು ತಪ್ಪೇನಿಲ್ಲ.
Is there any bar for filing an application under?
ಅಲ್ಲ ಬಾರ್ ಅಂತ ಹೇಳಿಲ್ಲ. I am making submission, my lords, instead of considering the application. Pleadings complete ಆಗ್ಬಿಟ್ಟು issues frame ಆಗಿ ಎವಿಡೆನ್ಸ್ ಹಾಕೊಂಡ್ರೆ within span of
ಹೇಳ್ತೀರಾ ಅವ್ರು ಇಲ್ಲ ನಂದು ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಕಾನೂನು ಪ್ರಕಾರ ಮಾಡಬಹುದು ಅಂತ ನಮಗೆ ಅನಿಸ್ತಾ ಇದೆ. ಡೈರೆಕ್ಟ್
ಅಲ್ಲ ನಾನು ಹೇಳುದು instead of arguing the case and reserving the matter for address and ಎಲ್ಲ
that shows that there is an admission on your side. Then why
no way
leave it.
ಅಲ್ಲ ನಾನು ಹೇಳುದು
let them do it.
ಎಲ್ಲೂ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಅಡ್ಮಿಷನ್ ಇಲ್ಲ,
dismiss
ಆಯ್ತು ಆಯ್ತು ಆಗ್ಬೋದು.
In this writ petition, petitioner sought direction to the trial court to dispose of IA. What is that IA number?
My lord, there is no number is assigned by
6 of CPC in OS number 1403 of 2017. The plaintiff has filed a suit for
declaration and consecutive injunction.
Declaration and injunction. On service of summons, defendant has filed a written statement and also counterclaim. Thereafter, he has also filed an application under Order 12 Rule 6 on 29/10/2018. So far, as on today, that application has not been disposed of. Hence, counsel for the petitioner seek for early disposal of the application. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that application filed by that petitioner defendant under Order 12 Rule 6 of CPC as expeditiously as possible, not later than 6 months from date of receipt of copy. Yes.
Pending application.
All pending application.
Serial number 1, Balraj AC.
Yes, what
My
is
lord,
this?
the order of attachment of movables, my lord, is called in question.
Hmm.
My lord, in execution proceedings, this order has been passed.
Yes.
My lord, the respondent, my lord, he claiming, my lord, he has filed a suit, my lord, in, before the additional district judge, Rajampet, Andhra Pradesh, my lord, asserting that, my lord, he has lent a sum of rupees 20 lakhs to me in the way back in the year 2012, my lord. Suit document is only a hand receipt, my lord.
No, that suit is decreed.
Suit is decreed, my lord,
Where
ex
is that
parte,
decree?
ex parte, my lord.
Where is the degree?
My lord, decree I have not produced, my lord. I have produced, my lord, I filed an appeal before the Andhra Pradesh High Court and in RFA, that is pending, my lord. Now, in the meantime, my lord, he files an execution petition, my lord, before the Andhra Pradesh District Judge Court, and he obtains transfer of that execution proceedings to the, before the City Civil Court, Bangalore, my lord. And my lord, I file an objections to that execution petition, and the court below, my lord, now passes an order, my lord, passes an order of attachment of movables, my lord, by order dated 11/3/2025, my lord. That order has been challenged, my lord, before
No,
this honorable court.
what has happened to your appeal?
Appeal is still pending, my lord. It's still pending before the court.
You can file an application before the
My
executive
lord,
court
what
for
has
stay
happened,
of
my
that.
lord? Illa, I'll stay ಕೊಟ್ಟಿದ್ರು 50% amount ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ರು. We have committed a default, my lord.
Then
Now, my lord, excuse.
then
my lord,
you can't, mister.
My lord, I will deposit some
Directed to
my lord, because my lord suit.
comply with the directions of the High Court to deposit 50%. Now that you can't take another order
lord,
from me, mister.
My lord, I'll deposit some amount before this honorable
No,
court.
you take, you
My
go
lord.
to that other court hall and says that
Lord.
my order to be violated and I will pay. This is not. This
No,
will
my
not-
lord, illa. What has happened, my lord? My lord, no attachment of movables has been ordered, my lord.
No,
I'll
see,
deposit.
now what is that meaning of the High Court order which is directed
Lord.
there? I can.
My lord, I'll because of my lord, COVID-19, my lord, we suffered
No,
very
you
huge
go
losses,
before
my
the
lord.
same court and seek for modification.
My
You
lord,
can't
there-
seek here, mister.
illa,
There is no sanctity.
My lord, now
What is
this
that?
court, my lord, City Civil Court has passed an order, my
Thankful
lord.
you have brought to my notice.
My lord, I don't
Otherwise, I
want to-
would have granted this.
No, I don't want to take any order by
Yes,
surprise, my
that's
lord.
what I said.
My lord, I'll
Otherwise,
deposit, my lord,
there
I'll
is no-
deposit some amount, my lord, before this
No,
honorable
I will
court.
say 25%.
Yes, my lord.
You go to that other court, I will say that 10%. Then what is the sanctity of? You go and seek for a modification, mister.
My lord, the IA is rejected there, my lord. They have rejected the IA.
Cancel that IA if law provided.
I have to go to Supreme Court.
For that, yes.
My lord, only
That is
one
not that-
submission.
no,
I'll
yes.
deposit 50% of the some amount before this honorable court.
No,
my
you
lord.
comply. What is that High Court directed?
50%, my lord. What has happened, my lord? Only 20 lakhs was the loan amount, alleged loan amount, because only suit and the ex parte judgment has been obtained, my lord, there.
No, that is not the issue.
My lord.
There is already in a directions of the High Court.
My lord, 24%.
Executing court say that as per that you have to deposit,
20
otherwise
24% has been, interest has been levied, my lord. My lord, some,
we can't, yes.
at
Yes.
least, my lord, at least,
Yes,
my lord,
leave
come
it
on.
matter of 2 weeks.
My lord,
We
some-
can't, there is a court order.
My lord,
ಈ
before-
ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗೋದನ್ನ ಇಲ್ಲೇ ಮಾಡಿ ಅಂತಂದ್ರೆ ನನ್ನ
ಇಲ್ಲ, my
ಸುಪ್ರೀಂ
lord,
ಕೋರ್ಟಿಗೆ ಕಳಿಸಿದ್ರ
ಇಲ್ಲ, my lord, ಅದು ಆತರ ಇಲ್ಲ. My lord, kindly see,
ಫಾಲೋ ದಟ್ ಜುಡಿಷಿಯಲ್
my lord, kindly see, my lord, some, because my lord, I have challenged them.
I can't, if there is not an high court order, I could have granted
My lord,
even
High
if
Court,
it is
I am not
20%.
questioning the High Court order, my lord. The order passed by the trial court of this, trial court Bangalore, my lord.
No, High Court has said 50%, therefore you pay it ಅಂತ ಅವ್ರು ಹೇಳಿರೋದು. Andhra Pradesh High Court ಅಲ್ಲಿ there is a direction to you, pay that 50%.
Well, that IA was rejected, my lord. Now, thereafter they have filed an execution petition, my
No,
lord.
that, what is that order, this
Please, my lord, what they say, my lord, we have committed a default, therefore,
additionally failure to JDR to comply with the directions of the High Court to
Yes, ma'am.
deposit 50% of the digrital amount.
ಹೌದು.
Then ಮತ್ತೆ
Then,
High
my
Court
lord,
directions
thereafter,
ಕೊಟ್ಟಿದಾರಲ್ರಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ವಜಾ ಆಗೋಯ್ತು ಅದು IA ವಜಾ ಆಗೋಯ್ತು. ಆಮೇಲೆ they file execution petition, my lord, before the district court in Andhra Pradesh.
High
On
Court has
transfer it has-
directed to pay 50%.
On
If you have not paid, therefore rejected.
There, ಅಲ್ಲಿ IA reject ಆಯ್ತು. Thereafter they filed an execution petition, my lord, before the district court. That was transferred to this honorable, before the district court of Bangalore. Now this court has, trial court has passed an order, my lord.
Yes, no mistake. Yes.
My lord,
If you want deposit 50%, I may grant more time. Not that this thing.
50% ಬೇಡ.
No, 50%, there is already an order.
ಇಲ್ಲ, 50%.
I can grant by installment. I can't alter that. If you want that, I can grant that. Yes.
Yes, my lord.
Yes. What is that 50% amount?
50% amount, my lord, 34 lakhs, my lord, is the decretal amount.
Yes. Heard, issue notice. Stay of further proceedings in execution number 389 of 2024 passed by 28th Additional City Civil and Session Judge, Bangalore.
27th, my lord.
27th. till the next date of hearing, subject to condition. Petitioner has to deposit 25% of the degree return amount on or before, when will you deposit?
8 weeks.
On or before end of April. Another directed to deposit 50% by installment. Out of that, 25% has to be deposited end of April. Another 25% by end of May. Yes,
August month.
subject to that stay. Yes.
End of August month, second installment.
August ಗೆ ಅಲ್ಲಿ execution ಮುಗಿಸ್ಬಿಡುವುದು.
Yes. ತೊಂದ್ರೆ.
Yes. Yes.
June.
Yes, June 15th, second install.
Much.
Yes.
My lords, next matter number,
Serial
number
number
48.
Yes.
My lords have heard in part, it is that issue that concerns the Sauharda Act and the KPID Act.
Day after tomorrow.
Serial number 8.
My lords have it on
My lord,
the
my
third.
lord, serial
Serial
number
number
84.
89, my lords.
My lord, serial number
94.
One minute.
Date, all matters will give the date.
Will my
My
lords have it
one
on the
submission,
third,
my
my lord?
lord.
I will file a written submissions on the third.
Serial number 89. my
Yes,
lord.
I think.
My lord,
one
serial
matter
number
I have struck in the
94.
morning, otherwise I would have reached that.
No problem.
Of hours.
My lord,
Either,
serial number
either tomorrow or the third.
Tomorrow you cannot be, except tomorrow, you take any date.
Third, my lord, third.
Serial number 8.
My lord,
Serial number 89, my lord. Serial number 18. Serial number.
Tuesday, yes.
Serial number 8. Serial number 89. My lord. Tuesday, my lord.
Tomorrow may not be possible.
Serial number 89, Tuesday, my lord.
Tomorrow you
my
take
lord,
it,
your honor.
grant.
Serial
My lord,
94.
ಒಂದ್ ನಿಮಿಷ. ಯಾವ್ದಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ, ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಬಿಟ್ಟು ಬೇರೆ ಡೇಟ್ ಏನಾದ್ರು ಬೇಕು ಅಂದ್ರೆ ಇಬ್ರು ಕನ್ಸೆಂಟ್ ಇದ್ರೆ ಮಾತ್ರ. ಸರ್ ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ.
Serial number 73.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗತ್ತಾ?
ಆಗತ್ತೆ. ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಗತ್ತೆ.
ಸರ್, serial number 84, 2 weeks.
ಎಲ್ಲದಕ್ಕೂ
Third, 48.
ಎಲ್ಲದಕ್ಕೂ ಏನು
Sir, serial number 73.
ಡೇಟ್ ಏನಾದ್ರು ಬೇಡ ಅಂದ್ರೆ
ಇಲ್ಲ ಬೇಕು.
ಬೇಕು ಅಂದ್ರೆ ಬಿಟ್ಟುಬಿಡಿ. ಎಲ್ಲಾರ್ದು ಮಂಗಳವಾರ. ಮಂಗಳವಾರನೂ ರೀಚ್ ಆಗಲ್ಲ ಅದು.
ಆಗ್ಲಿ. ಮಂಗಳವಾರನ ಸರ್, ಮಂಗಳವಾರ.
ಗೊತ್ತಿರೋದಲ್ಲ, ಎಲ್ಲ ಮಂಗಳವಾರ. ಯಾವ್ದಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ, ಎಲ್ಲ ಮಂಗಳವಾರ.
Sir, serial number 73.
ಎಲ್ಲ ಮಂಗಳವಾರ.
ಸರ್ ನಾಳೆಗಾಗಲ್ಲ.
ನಾಳೆ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿ 1 hour ಆಗಿದೆ.
Serial number 73 ಅಲ್ಲಿ.
Sir, serial number 73 after 12th kindly.
ಅದು ಬೋರ್ಡ್ ಬಂದ್
ಸರ್, serial number 61. ಸರ್
ಥರ್ಡ್ ಹೇಳಿದ್ರು ಸಾಹೇಬ್. 48.
Serial number 73.
ಥರ್ಡ್ ಬೇಕಾ ನಿಮ್ ಸೆಕೆಂಡ್ ಬೇಡ? ಥರ್ಡ್ ನಮ್ಮ ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ತಾ ಇದ್ದಾರೆ, ನಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್. ಥರ್ಡ್ ಸಾಹೇಬ್ರಿಗೆ. ಥರ್ಡ್.
ಸರ್, serial number 84. ಸರ್,
Sir, serial number 73.
ಒಬ್ರಿದ್ರೆ ಆಗಲ್ಲ, ಒಬ್ರಿದ್ರೆ ಮಾತ್ರ.
Sir, serial number 73.
Serial number 73 ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಪ್ರೂಫ್ ಇದ್ದೀವಿ.
12ನೇ ತಾರೀಕು ಆದ್ಮೇಲೆ ಹಾಕಿ. After 12th.
ನಾನು ಇದ್ದೀನಿ.
ಅಷ್ಟು ಕಾಣ್ತದೆ.
ಸರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ.
After 12th.
73
After 12th.
ಯಾರಾದ್ರೂ ಒಬ್ರು ಮಾತಾಡಿ, ಈ ಕಡೆನೂ ಮಾತಾಡ್ತೀರಿ, ಈ ಕಡೆನೂ ಮಾತಾಡ್ತೀರಿ.
ಅಲ್ಲ 12ನೇ ತಾರೀಕು ನಂತರ
ಬಿಸಿಯಲ್ಲಿ ಯಾರು ಇರೋದು? 73ಗೆ.
73 ಅಲ್ಲಿ ಇದ್ದಾರೆ ಸರ್.
ನಾವಿದೀವಿ ರೆಸ್ಪಾಂಡೆಂಟ್. After 12th.
ಒಂದ್ ನಿಮಿಷ. 73.
Yes sir, for respondent.
ನಾನು ಪೆಟಿಷನರ್. ಇಲ್ಲಿ ಸ್ಪೆಟ್ಸ್
ರೆಸ್ಪಾಂಡೆಂಟ್ 73 ಯಾರು?
ಸ್ಪೆಟ್ಸ್
For
ಹಾಕೊಂಡಿದ್ದಾರೆ.
the respondent sir. ಇಲ್ಲಿ
ಹೆಸರು
ಸುಹಾಸ್.
ಮತ್ತೆ
ನಿಮ್ಮ ಸೀನಿಯರ್ ಹೆಸರು ಹೇಳಿ.
ಮಾನಸ ಅಂತ
For
ಹೇಳಿ.
PhD. For MBR Manasa B Rao.
ಆಯ್ತು. ಸಾಯಿ ಕಿರಣ್
ನಾನು.
ನೀವಾ?
ಹೌದು ಸರ್.
ಯಾವತ್ ಬೇಕು?
After 12th.
16th ಸರ್.
ಇಬ್ರು ಒಂದ್ ಡೇಟ್ ಹೇಳಿ ಸರ್.
16th ಹಾಕೊಂಡು.
ಇರ್ಲಿ ಸ್ವಾಮಿ.
16th.
ಇರ್ಲಿ.
ಓಕೆ ಅನ್ನಿ.
Okay.
16th ಸರ್. ಓಕೆ ಅಂದ್ರೆ 16.
ಆಯ್ತು.
ಸರ್, serial number 84.
ಓಕೆ 16th.
ದಿನಾಂಕ ಯಾಕೆ ಅಂತ.
Officer sir, serial number 71.
ಇಬ್ರಿದ್ದೀರಾ?
ಸರ್ 73 ಅಲ್ಲಿ ಐಒ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸರ್.
ಅದ್ರ ಬಗ್ಗೆ ತಲೆ ಕೆಡ್ಸಿ.
ಆಯ್ತು.
ಆಗತ್ತೆ ಸರ್.
50. ಶಶಿಧರ
ಸ್ವಾಮಿ 53.
ಸಿದ್ದಪ್ಪ ನೀವಿಬ್ರು ನೋಡಿಲ್ಲ, ಅವ್ರಿಬ್ರು ನಂಗೆ ಗೊತ್ತು, ಆದ್ರೆ ನೀವಿಬ್ರು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಇವಾಗ ಏನ್ ಮಾಡೋದು? ಇಬ್ರು ಇದ್ದೀರಾ? ಹೇಳಿ. ಟಾಪ್ ನಾನ್ ಮೇಲೆ ಹೋಗ್ತೀನಮ್ಮ, ನಿಮ್ ಟಾಪ್ ಹಾಕದ್ ನಾನ್ ಮೇಲೆ ಕಳಿಸ್ತೀನಿ.
Third is okay.
ಆಯ್ತು.
Third.
ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ, ಇಲ್ದಾದ್ರೆಲ್ಲ
ಸ್ವಾಮಿ 53 ಇಬ್ರು ಇದೀವಿ.
53. ವಿವೇಕ್ ಒಳ್ಳೆ ಪಿವಿ ಅಪ್ಪಯ್ಯ.
ಹೌದು. ಥರ್ಡ್ ಆಗ್ಬಿಡಿ.
Sir, serial number 86, sir.
ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ. ಗೊತ್ತಿಲ್ಲ ಸಾರಿ, ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ.
Sir, serial number 86.
ಅವ್ರಿಗೆ ಹೇಳಿ
ಸರ್ 86.
ಅವ್ರಿಗೆ.
ಸರ್ 86 ಇಬ್ರು
86 ಇಬ್ರು ಇದ್ದೀರಾ?
ಹಾ ಸರ್. ಸರ್ ಡೇಟ್ 2ನೇ ತಾರೀಕಿಗೆ ಕೊಡಿ ಸರ್.
ದೀಪಕ್ ಭಾಸ್ಕರ್ ಯಾರು?
ನಾವು ಸರ್ ವಿಸಿ ಅಲ್ಲಿ ಇದೀವಿ.
ಆಯ್ತು.
ನಾವು ದಿಲೀಪ್ ಸಿಜಿ.
ಇಬ್ರು ಹೇಳಿ.
ನಿಮ್ಗೆ ಯಾವ್ದು?
ಸರ್ 2nd April ಸರ್.
2nd April ಅಂತ ಅವ್ರು
ಕೊಡ್ತಾ ಇದ್ದಿದ್ದು ನಾವು.
ಸರ್ ನಮ್ದೊಂದು
ಸರ್ 86.
ಇಬ್ರು ಇದೀವಿ.
ಸರ್ 86 ಯಾವ ಡೇಟ್ ಸರ್?
104 104. ಹಾ ಹೌದು, ಇವರು ಜಯರಾಜು ನಾವೇ. 17th ಕೊಡಿ. 17/4 ಏಪ್ರಿಲ್ 17th 4.
ಏಪ್ರಿಲ್ 17th.
ಟು ಮೇ 2nd April.
ರೀಚ್ ಆಗಲ್ಲ ಸುಮ್ಮನೆ.
ಸರ್ 72
ಐವೋ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು.
ಮಂಗಳವಾರ.
ಸುಮ್ಮನೆ ಕಾಯೋದು ಯಾಕೆ?
ಇಬ್ರು ಇದ್ದವ್ರು ಮಾತ್ರ ಅಷ್ಟೇ. ಎಲ್ಲ ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ. ಒಬ್ಬೊಬ್ರು ಹೇಳಕ್
93.
ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ.
ಇಲ್ಲಾಂದ್ರೆ ಡೇಟ್ ಕೊಡಲ್ವಾ?
ಬಿಟ್ಬಿಡಿ. ಮಂಗಳವಾರ 1ನೇ ತಾರೀಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. 71